We can
But
see
I
it,
think
Racketeers.
Oh, Vern, come on now, Mike, show
It
him.
also says
Mike, show him
delicious.
your glass.
Take a while.
His cup
And
says
then
maggoteers.
it'll kick over to
It says delicious on the bottom.
it's connected. So
All right, we're live.
live. It's live.
Okay. Good afternoon. It is the 21st of January, 2021. Welcome to the House Judiciary Committee. We have several bills, right? 6 bills today. Members, remember to mute and unmute when I recognize you to ask a question. Witnesses, you'll unmute yourselves when I recognize you to present your testimony. We have several bills with a few people set to testify on each one. I'm going to alert people that 2 of the bills from Delegate Wilson, House Bill 149 and 382, we're going to do those 2 together. And we're going to do 3 minutes for the sponsor to talk about both bills and 2 minutes for witnesses. Going to be a little forgiving because I'm going to put those 2 bills together, but because they're similar in focus, I don't think that should be that big a deal. Let's see, the other bills, House Bill 180, which is my bill, will be 2 minutes, 1 minute. The other bills today are all 3 minutes for the sponsor and 2 minutes for the witnesses. For each bill after sponsor, I'll ask, I'm going to try and keep the panels to about 5 people on each panel. There are bills later today where we're going to be bringing in 5 people, and then asking them to move out, and then bringing in the next 5 people, just so that we can keep things moving along. And with that, we're going to start with House Bill 180, and that is my bill. And I will keep this relatively brief because I think we're going to end up having a larger conversation about this bill again in the context of Delegate Wilson's bills and the context generally about kids who participate in sexting. What House Bill 180 does, it is the bill that we passed out of committee and that passed the House of Delegates last year. And the goal of the bill is to avoid situations where kids, mainly on the first time that it is discovered that they have participated in sexting, that they should not receive detention for that they should get some kind of education about the dangers related to sharing pictures, explicit pictures online. And it provided an affirmative defense. The bill provided an affirmative defense if a child was coerced, threatened, or intimidated into sending those explicit pictures. House Bill 180 also ensures that if they are found to be delinquent for possession of child pornography, and that's kind of the underlying issue here, they're being found guilty of possession of child pornography, that they are not included on the sex offender registry. The goal here, and we just did have another case in Dorchester County where a child was charged with possession of child pornography, and that puts those children in a position where they could potentially be on the sex offender registry. They could be seeing detention, and I think what this committee felt and felt pretty strongly about was we're not necessarily looking for people to go to jail for this unless they come back a second time. So House Bill 180 left open the possibility that if there was a second second case where they were charged with being in possession of child pornography, that the judge would have an alternative there in that case. So with that, I'm going to stop. There are witnesses on both. Well, there are people who are favorable with amendments, and unfavorable. We'll start with just the people who are favorable, and that's Melissa Hopmeyer, who I
am here.
You are there. There you are, and Gavin Potashnik. So we'll start with the 2 of you, and we'll ask you to stay within a minute. Then we'll take questions for the 2 of you. Then we'll go to Lisa Jordan and Melanie Shapiro. And then we'll go to Vince McAvoy and Michael Gross. And I mispronounced your first name. I'm certain of it, but that's, you'll correct me here in a minute. So let's start with Melissa Hotmeyer, please.
Thank you. Good afternoon, Mr. Chair, Madam Vice Chair, members of the committee. My name is Melissa Hotmeyer, and I am the Chief of the Special Victims and Family Violence Unit for Prince George's County. I'm asking that this committee issue a favorable report for House Bill 180. As a prosecutor who prosecutes child pornography, I know that the production and distribution of child pornography is a growing issue, even more so with this pandemic. And we need criminal sanctions for individuals who exploit children. But I also recognize that we should not criminalize consensual behavior between similarly aged juveniles who are engaging in what we know as sexting. However, the prosecutors need to be allowed to prosecute malicious and harmful distribution of production of child pornography. And I do have two examples that are from Prince George's County. In the last year, we have had a teen who was buying and selling images of young girls at high schools and distributing them and selling them for profit. He was under the age of 18. And then more recently, we had a teen who had made some sexting videos with a girlfriend. And after they broke up, he began uploading them to Pornhub and sending individuals to our victim's house on multiple occasions, saying that she wanted to engage in rape fantasies. And she was also a juvenile. He was a juvenile. We believe that House Bill 180 protects both juveniles engaging in consensual behavior and allows victims to receive justice from the criminal justice system from malicious and harmful production, manufacturing, and distribution of child pornography.
Right.
I would urge a favorable report on House Bill 180.
Thank you very much. Mr. Potashnik.
Thank you, Mr. Chairman. Good afternoon, Mr. Chairman and Vice Mayor, members of the committee. Gavin Potashnik, Deputy State's Attorney for Hartford County, also representative of the MSAA. We would ask you issue a favorable report with respect to House Bill 180. I think I'm going to start echoing what Melissa was talking about, in that sexting and that type of behavior really at times encourages power and control, even amongst consenting juveniles. There are a number of cases that I could cite where even if the person who was filmed says it was a consenting behavior, it actually wasn't, and there was some sort of proactive force used by the person taking that particular video. We also recognize that we want to make sure we promote education for these types of behaviors, especially first-time ones, that we want to encourage rehabilitation efforts. And I think that House Bill 180 really does a good job of trying to encourage that, and at the same time providing kind of guardrails for this type of behavior. So with that, I will cease comment, and I ask for a favorable report. Thank you so much.
Thank you. Are there questions? I need my other screen. Are there questions for this first panel? These are the people who are just straight favorable. Okay, Delegate McComas.
Thank you, Mr. Chair. I will be brief. I saw where you want them to have education if it's the first offense. My concern is that there may be more behind it than just, hey, this is really dumb for you to do. This could follow you around in your 80s, hurt you for getting a job. I'm wondering if there should be possibly in the opportunity that if the juvenile master or the judge says, I think that this, there needs to be some psychological evaluation and maybe treatment or counseling in addition to the educational might be considered friendly by just a thought.
The magistrate could issue that now. The magistrate could issue could put in a request for mental health treatment, evaluation and treatment. So I don't know that we need to include that explicitly. We included the language about education to sort of underline, two parts. One, we really don't want them to go into detention unless it is a significant case. And furthermore, not only do we not want them to go into detention, but we say that the child should go to an age-appropriate educational program to talk about the risks and consequences of possessing those sexually explicit videos. So I don't know that we need to explicitly say that. Yeah, okay, I guess explicitly say that, but I take your broader point. I think that that magistrates would be doing that anyway, but that's what I think. Are there further questions Seeing none for the first two, we'll go on to favorable with amendments. And those two are Lisa Jordan and Melanie Shapiro. So let's go to Lisa Jordan first. And these will be for 1 minute, please.
Thank you, Mr. Chairman, Madam Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. As the chairman said, we support House Bill 180 with amendments. For all of these bills, we strongly believe that teenagers who engage in consensual sexting should not be criminally prosecuted. But we also are equally devoted to the fact that minors should be protected from non-consensual creation or distribution of nude images of themselves. House Bill 180 is a much more straightforward alternative. It certainly has that in its favor. However, it does not really prevent prosecutors from charging teens, which is kind of on the downside. The other issue of concern we have is that it applies only to images of oneself. In the SK case that we discussed at length last year, the image was of the young woman involved and also a body part of another. So it's unclear if that would apply there. So we do have some concern there. My remaining seconds, let me just emphasize the importance of education. Education has been proven to deter sexting. So we would strongly encourage all of you, whatever you decide to enact in response to the sexting issue, that education be a part of that. And with that, I know that we have two other sexting bills to discuss, so I'll leave my further comments to them, and we urge a favorable report with amendments.
All right, Melanie Shapiro, please.
Thank you. Good afternoon, Mr. Chairman, Madam Vice Chair, members of the committee. Melanie Shapiro, Public Policy Director with the Maryland Network Against Domestic Violence. And we urge a favorable report on House Bill 180. We thank you, Mr. Chairman, for bringing this important issue again this year. Sexting is something that clearly needs to be addressed. I echo a lot of what Ms. Jordan has already stated, notably that we do not believe that children who are engaging in consensual sexting should be subject to the delinquency system. However, the education component in your bill is very much appreciated. Further, one of the concerns that we have is the affirmative defense. And so if there's somebody who has been coerced into sexting, they must then prove their victimhood. They will be subject to a possible arrest and prosecution to prove their victimhood. And I put some data in my written testimony, but what I want to just make sure that all of you are aware of is the connection between sexting and teen dating violence. One study said that nearly 75% of participants said they experienced sexting coercion, also experienced some type of sexual, physical, or psychological abuse from their perpetrator before, during, or after sexting coercion. And so we would like to work with you to come up with something in those situations as opposed to the affirmative defense. So that's why we are favorable with amendments on House Bill 180.
All right, thank you very much. I'll ask committee if they have questions first, then I have a couple. I don't see anyone raising a question, so let me go ahead and ask mine. So let's talk about the affirmative defense for a second. I mean, what would your alternative be to an affirmative defense? I mean, I think we went around and around on this last year a little bit, and I'm happy to hear an alternative. I just need to know either from Ms. Jordan or Ms. Shapiro.
So there have been a few different options that I've sort of contemplated. I know we have another bill that sort of takes a different approach. We have concerns with those systems as well because they could be potential net wideners. I believe the 8-hour education component could be a very easy first-time sexting that appears to be consensual. You have to do 8 hours. And it could be administered. There's a variety of different options available that could be the touch point for that education about healthy relationships, sexting, social media, all of those kinds of things. I think that there are other areas. I would reference citations because they don't come with the same weight of an arrest. I can't remember which section of 388 it is in, but that would be for something down the road, I would think. I think that to get to prosecution, it would need to be a republication situation or coercive sexting. And quite frankly, it wouldn't be the person who sent the sext. It would be the person the issue would be with the coercive nature. And a better way to even handle that would also be in treatment and education versus actual prosecution.
All right, Ms. Jordan was waving her hand. You got to get off mute though. Lisa Jordan. There you
My
go.
apologies. I still haven't gotten the hang of who unmutes
I haven't
who.
either. It's fine. Just, we roll with it.
Thank you indeed. I would suggest that the difficulty with the affirmative defense is that it does place that burden on the responding child. And perhaps the way to address that would be to add some element of voluntariness or something that places the burden on the prosecution in the definition of sexting. I think I would need to think about it a bit more to give you specific language, but that's really the heart of that concern, is that we not say, here's a sexting juvenile prosecution, you tell us that you were coerced, but instead we'd like to have the state say, let's make sure that this was not coerced. The state has that burden of investigating that.
Okay. Okay. Are there, Delegate McComas now has a question. Delegate McComas?
Just briefly, would it be possible that we could, that if it's the first sexting offense, and could they agree to kind of do a deferral of prosecution and then get the child into the education? And then if there's a second one, then maybe allow the affirmative defense. But in other words, kind of do like what they do for theft. They get people into a deferral program and then it disappears, but not get into the juvenile system per se, like the sins or just your thoughts on that.
Either Ms. Jordan or Ms. Shapiro?
So procedurally, I think there are mechanisms to make that happen. And I think that that's something, what all the studies show is that any contact with the delinquency system does not produce positive outcomes. And so to any extent that we can, if it's brought to, it's something that has to ultimately get to the police's attention to even get there. But I think that there is an opportunity to develop an education program that kids can simply be referred to. And that is what happens the first time that there's a sexting. And then if there are subsequent instances, now that also hopefully includes when it's done voluntarily, because there's other issues if it is involving coercion. So I think that there's an ability. I think we just need to potentially sit down and discuss, the various options of what that would actually look like and where it would be housed. But I think if we can separate it from the court system and the delinquency system, that would be the best outcome for young people.
Well, and I'll add that the General Assembly has done some work in this area over the past several years. There's mandatory consent education. There is education about sexual abuse that's happening in the schools now. Sexting is already a part of that. So there is kind of a baseline of education, and it may be that the educational system needs to look at that. I sincerely doubt that that the first time someone is sexting, that they are then automatically going into the juvenile system. This is something that's happening quite a bit. 27% of teens admitted to receiving a text, and those were just the ones who admitted that. So I think it's naive to think that the first time someone sexts is the time that they're going to get caught up into the juvenile justice system. So we do need to look at prevention more than punishment.
And from my recollection, and now I'm jumping in with a question, I guess, and I'll probably end it, isn't that so? But the reason in the bill in 38A 35C2, where we talk about detention, I think there was general support across the committee, again, that the first option should not be considering detention of the child. The first option, and detention should only really be used if there were really extraordinary circumstances that the magistrate was able to put in writing and say, I really think this rises to this level where some level of detention is appropriate. So So with that, that kind of goes to part of it. So again, on the affirmative defense, I'm happy, and I'm sure the committee will be happy to talk a little more about that and figure out if there's a way that we can adjust that. Are there further questions for this panel? I will just say very quickly before the opponents come on, I will just underline, I do hope that we can do, that we can move forward on this issue this year. And I'm certainly hopeful that we can do that. We've had this issue kind of lingering for quite a while, and it's resulting in unintended consequences, I think. So we'll go now to the opponents. That's, please pronounce your first name. From the Office of the Public Defender. Is it Mike?
Michal.
Michal. Okay, I apologize.
Michal. That's okay.
All right. We'll start with you, and then we'll go to Vince McAvoy.
Thank you, Mr. Chairman and Madam Vice Chair and members of the committee. My name is Michal Gross, and I'm an assistant public defender in Charles County. While we appreciate the efforts by this committee to fix the problems highlighted by the Court of Appeals in the 2019 opinion on a case that came out of Charles County, where a teenager was charged with child pornography for sending around a video of herself, we are concerned that this bill won't fix the problems that case highlighted. First, this bill leaves too much to discretion. By making sexting a mitigating factor and coercion an affirmative defense, this bill leaves too much to the discretion of police, prosecutors, and judges. This is a problem because in that case, in Ray SK, the charges were the result of the abuse of discretion. The charges were the result of a police officer at school abusing the trust and discretion to charge a teenager with distribution of child pornography for sending a video of herself engaged in consensual sexual behavior. That case was also the result of a prosecutor abusing discretion in prosecuting that teenager. And that case was also the result of the court abusing their discretion by convicting her. Second, we're concerned that this bill codifies the harms that it's meant to prevent. The concern is that a teenager whose private photo is posted publicly might be scared to approach a trusted adult because they could be prosecuted for taking that photo in the first place. There's concern because the bill allows punitive measures like home detention and out-of-home placements, which can lead and exacerbate exploitation and blackmail and increase the potential for self-harm.
All right, Ms. Gross, if you would wrap up, please, and I'm sure
Yes.
there will be questions.
Yes, I am nearly finished. We urge the committee to promote legislation that instead protects instead of punishes teenagers. We're not condoning sexting, instead understanding that as many as 27% of teens have sent or received texts. We want to make sure that they're aware of potential harms, know there are resources available, and that they can trust adults. We want to avoid the public shaming and potential further trauma of prosecution in juvenile court. I will say I'm available for questions on this bill and HB 382. I'm not signed up for testimony due to a technical problem on 382, so any questions for me would have to be directed, I think, on this panel.
No, we are going to, because I've merged the two bills from Delegate Wilson, you're going to be available for both of those bills as well. So
Okay, thank you.
Okay, we'll go now to Mr. McAvoy.
Hello, can you hear me?
Yes.
Great, thank you. Appreciate you all, Chair and committee. Thank you so much for hearing me. One of the things that we are looking at, as we were the other year, is essentially culture. And that this culture is making it de facto that this is going to be everything that parents are going to be looking at on their children's phones. I don't think that we should subjugate ourselves to this, that the state has a minimum standard of conduct of law with respect to the horrific consequences for children just of the act. And that this bill can allow shuttling of adult infractions onto the children. We talked about the coercion earlier, an atmosphere of sharing these pictures and proliferation of explicit material. This is not good for the culture. And so there should be these existing penalties. These penalties are derived from federal law. And then through mitigation, with them being presented with these charges, a judge, maybe in a SEMA situation, maybe not, can go ahead and determine all the specific details, the who's, the what's, the examination of the actual digital material. And I know that I'm running out of time, but I just want to say We don't use memos of understanding. Chair, you made it. I've rarely seen you push a bill like this. And I would just say that it's very clear that you would have enough gumption to present this to the judiciary and say, we as the legislative branch really don't want children in jail. We don't want children in jail, but we cannot escape from the fact that child trafficking and pornography is prolific, and it's the #2 crime being committed by gangs in our country. Thank you for your time.
All right, thank you very much. All right, questions for the opponents? I see Delegate Cardin for the beginning. Delegate Cardin?
Thank you, Mr. Chairman, and thank you guys for testifying. So this is to Ms. Gross. Thank you very much for your eloquent testimony. Is this bill better than what is presently happening? Is this, in other words, a movement in the right direction?
Delegate, I would answer your question and say the idea of legislation is definitely a move in the right direction. The problem, though, is that this codifies those harms that exist in the current laws, allowing children to be charged with child pornography charges for images of themselves. So while the idea of legislation is a move in the right direction, the concern is that this here codifies the decision that was made by the Court of Appeals in Re SK.
Okay. Do you have, if you had some suggested ideas, you didn't present anything else. You just said it's a good idea to try and move in the direction that we're moving without codifying. So certainly I'm all ears. I would imagine my committee is as well. Thank you.
Absolutely, and I would be happy to offer some suggestions. I know some of those suggestions are actually contained in Delegate Wilson's bill. That's HB 382, which I know we'll be discussing a little bit. So I don't know if you want me to give those suggestions now or wait until Delegate Wilson's bill is discussed.
We will get there soon enough. We'll let Delegate Wilson talk through his ideas to give him that chance. My question very quickly, and then I think we'll get to the next couple bills unless other people have questions, of course. In the bill, it says that sexting is sending of a sexually explicit photograph, image, or video of oneself to another. I mean, I guess the added concern and what that was expressed by the state's attorneys is when, I mean, I guess it does turn on that issue of another, of potentially adding another person in there. The goal here was to focus specifically on the person sending the picture of themselves, while allowing somebody to be prosecuted for possessing the videos of another. I guess that's what I know we wrestled with last year, and I guess I'm giving you a broad-based question to kind of come back to me with, but I think this is an important part of the discussion on this. I mean, how do you, we are trying to draw the line that says that it's not every piece, it's not every charge of child pornography that should go into the system. It is ones that are very specific and very targeted at the person who was in possession of pictures of themselves. So Ms. Gross, could you respond to that a little bit?
Absolutely. I think there's two separate parts to the response. The first is that another teenager receiving a sexually explicit text message from their significant other, their boyfriend, their girlfriend, their friend, that's not child pornography, that's sexting. And the problem with the language as it currently exists is that those individuals would still be labeled child pornographers. They would still be charged with possession or distribution of child pornography, depending on what it is that they did with it. The second problem is that when we're talking about the individuals who, the definition of sexting and having the definition of sexting include individuals who take images of themselves, in my reading of the bill, that just turns, sexting is just, the fact that the photo was sexting, it was self-produced, just makes that a mitigating circumstance for the judge. That was exactly the situation that we had in play in SK's case. It was a video of herself. She was prosecuted for distribution of child pornography for a video of herself. And all of that discretion existed as it exists within the juvenile court system to this day. The problem is that it wasn't appropriately exercised. And she was charged and she was prosecuted and she was placed on probation. placed on electronic monitoring with the conditions that came with it. Everyone in court saw that video of her. And this was after it had been posted on Snapchat, after she tried to get it removed from Snapchat, hoping that the school police officer would help her with that. So the problem, I think, here is twofold. Is one, that even a teenager who receives a text from their friend is not a child pornographer. And second, there's concern that by just making it a mitigating circumstance, we're leaving too much to the discretion of the parties that brought SK to court.
Okay, thank you very much. I think these are the themes we're going to start to see here for the next couple bills. So I'm going to stop unless somebody else has a question about 180. I don't see any further questions about House Bill 180. All right, so that'll conclude the testimony for House Bill 180. And now, Delegate Wilson, there are two bills, House Bill 149 and 382. Give you a little bit of leeway, but you'll have 3 minutes to talk about the two bills. And I'll use a little bit of discretion here so that you have time to be able to properly describe the differences between the two. After you testify, we'll have the witnesses after, which I think in both cases, 382 is a little different, so we'll work it out. All right, so let's go ahead with House Bills 149 and 382. Delegate.
Thank you, Mr. Chair, colleagues. Present two bills, House Bill 149 and 382, and I'm not gonna beat around the bush a lot with hyperbole today. They're both put in to deal with the same problem that we just heard in House Bill 180, which is how to deal with sexting. And the originator there, you already heard from Ms. Gross how I got to presenting this bill last year. But let me tell you why I'm here this year, because I have 3 teenage daughters, and we brought this up in conversation. And my daughter, who was 15 years old at the time, says, oh yeah, her friends send her naked pictures almost daily to compare their bodies. And then they talked about, because, does this look right or whatever, that it's not even of a sexual nature. That young girls are doing this just because, especially in COVID, because they're not talking to each other, they're not seeing each other. In addition, you have the incidents where a young guy doesn't, I don't know the proper terminology of it, but we'll call it a penis picture for better or worse. And then a girl sends it to another girl going, does this look right? These are legitimate conversations I've had with my children. This happens. I think that we are underselling what's going on in this country right now, and definitely in our community, to say like this is some deviant. No, this is becoming the norm. So the question is, what are we going to do about it? Because unfortunately, I do not believe we're going to let the genie, we're not going to stuff the genie back into this bottle. I would love to say as a parent, hey, I will take your phone away and I'm going to look on your phone every day, but I'd be lying. We all monitor our children's phones when we can. We go in when we can to look at them if we do that. But a vast majority of people don't do that. So where we are today as a state and as legislators, well, just what are we going to do about it? Can we punish this out of them? I would argue we can't. The first bill I put in was House Bill 149, which was basically an economy of words and actions. Basically saying in those situations, no. There is no, if they're an infant under the law, that they cannot be charged with the distribution of child pornography. I know that leaves a lot of openings. I know that that would preclude anything about sexting, but it also, for those individuals who are actually using child and underage pornography for excitement, that would leave that wide open. But also understand the problem with those children. A lot of individuals, especially young kids, their sexuality was interrupted at a point when they were younger. And unfortunately for some of them, that's the point they keep going back to even as they grow older. And again, what are we going to do? So House Bill 149 was basically cutting them out of this whole entire area. House Bill 382 was really pushed by the public defenders, which addressed sexting in greater detail. It defined what sexting is. It was trying to avoid juvenile adjudication as delinquent, no out-of-home placement, and it created a Senate component, which I know is a financial, it's a fiscal issue, and also a judiciary issue, but that really took into more detail. And the reason I'm being kind of light on this is because I know this is a subject matter that you as a committee are going to have to run over. So I'm not stuffing either of these bills down your throat, but I need to understand the idea to be very much understood that discretion isn't always a better part of valor, especially when it comes to judicial, Because what that means is in different jurisdictions, children will be treated differently. I'm very much ashamed that Charles County was a jurisdiction that started this. And I've worked with Ms. Hopmeyer on a multitude of occasions. Amazing. Mr. Clippinger, I've worked with people that I trust, but I've also worked in other counties where I'd be terrified to go. I would be terrified to live, and I would be terrified to have my daughter on the receiving end of quote unquote discretion. Also, make sure we understand that we need to do something to differentiate this consensual, and I mean consensual, either the act or the video, because yes, some kind of kids will record and they will send it out. Revenge porn, which we already have laws for, and that true child pornography, and I hate to use that word, and we'll call it the most impure form, where people in that broken state revert back to that area or that age of life, and that's what they use for stimulation, because they do need help.
All right, Delegate.
Make sure we understand that labels matter. Keep calling a child a delinquent, they're gonna be a delinquent. You label them as a sex offender, they're gonna be a sex offender. You treat them like an animal, sooner or later, they're gonna be an animal. I'm not sure where we're gonna go. I say this again, I think we are underestimating what we're dealing with. Sexting, it's huge for adults. We have some kind of common sense. So what do you think a child's doing right now? And are we going to villainize and victimize these children? And are we going to give them, some of them, you're just going to give them a crutch to be a failure. If we use punishment as the key, if we think we can prosecute this away, we're mistaken. And for those of you guys that know me, I'm big on law and order. However, I don't believe that our children need to be labeled as sexual predators and sexual offenders when there are other things we can do. And one of those main things, shockingly, might be parenting, something that you and I can't legislate.
Delegate.
I hope that we take these two bills into account. Thank you.
Thank you very much. All right, so here's what we're gonna do. Pretty much the same people who wanted to testify in the on 180 also want to testify in different ways on these two bills. So I think what I'm gonna do, let's try and do this in the best way that, or at least in the most efficient way. I'm gonna let Ms. Jordan and Ms. Shapiro talk in a moment. So they're gonna be the first group because I think they're favorable with amendments on one and they're unfavorable on the other. And I think that it's easier to merge those two together, and we'll give them 2 minutes to talk each here in a moment. And then Mr. McAvoy is opposed to both bills. Mr. Potashnik is opposed to both bills. Then we also have the public defender, Ms. Gross, who is going to, who wanted to talk on 382. So what I'm gonna do actually is, I know there are questions for the sponsor. So we're gonna take questions for the sponsor right now. Then I'm gonna go to Ms. Gross for 2 minutes on 382, and then Ms. Jordan, Ms. Shapiro, and then the rest. Thank you for putting up with all of that, and I hope you all are still watching at home. All right, questions to the delegate, Delegate Grammer.
Thank you, Mr. Chair. Can you hear me okay? Delegate Wilson, can you hear me okay?
Yes, sir.
Hey, I appreciate the bill. I agree. My first inclination would be to take this issue and try and differentiate between sexting and child pornography. But I think you're right. I don't think you put this genie back in the bottle, and I'd be very reticent to try and pinpoint legislation to deal with this problem. I think it's important to keep the issue in context. When the case happened where the youth was charged, I saw the opinion and I called around to a lot of prosecutors that I know personally, and I said, what happened there? And they said, you know, I wouldn't have prosecuted that. In fact, every prosecutor I talked to said, I wouldn't have prosecuted that. But what we have here is, frankly, statute that wasn't tight enough, and this case comes to pass. Do you know of any other cases where this has happened? Is this?
No, that was unfortunately a seminal case for me, and I don't believe that the statute that they depended upon just was not drafted when sexting or any of this was of issue. And which,
Right.
unfortunately, even though it's hard to do, you guys have a big job because we can't not do anything because that statute wasn't drafted when we were thinking about or even knew about sexting or texting for that matter.
So the thing to me, the thing to do is to keep this in context. We have this case, which has tested a hole in the law. And rather than trying to pinpoint it statutorily, we have this thing called uncodified language that we now know about. Would it not be more proper to try and work out the details of the legislative intent within uncodified language to give forward guidance to say, look, this piece of statute, with whatever bill we pass to try and fix this issue, we put in uncodified language to really make clear that the purpose of the article is not to prosecute children for sharing naked pictures of themselves, but is to more accurately target the proliferation of child pornography. Would that be an option?
And I believe that's great. That's a great thing about legislative intent. What we're just dealing with right now and what you'll be discussing later will be considered legislative intent. I don't believe we can walk away without putting something in codified language because of the quote unquote discretion people will use. And depending on the attorney you get, they might not even read the uncodified language. So it would be a danger. I think you're leaving too much open. It is a very tough job and you're a very wonderful committee. And I know you're capable. So I'm looking forward to seeing what you guys can create.
I agree with a lot of that. Let me challenge you really briefly on it. We have a very narrow hole that's been poked through. Most people wouldn't prosecute it. If we reinforce that with legislative intent, wouldn't the judge say, Mr. Prosecutor, I see what you're arguing on behalf of the state, but look, we have this uncodified language that makes it very clear that we're not trying to target youths, we're not trying to target sexting. Wouldn't it cover the gap?
Not even close. And I appreciate your good faith, but unfortunately, not everybody moves in good faith. Not every good defense attorney is a good defense attorney. And not every prosecutor is, like you said, not willing to prosecute these cases. That's why we need this actually written down because no, sir, I've been in different jurisdictions and the same laws, they apply much differently depending on where you're litigating. And I believe it's unfair to our citizens to be treated differently depending on the jurisdiction which they live in.
Okay, I appreciate it, and it's good to see you.
Nice seeing you, brother.
Are there further questions for the delegate, who I'm going to ask to hang around anyway as we go forward? But are there further questions for the delegate? All right, I don't see any more for the delegate. Let's go now to the public defender, to Michelle Gross. You can have 2 minutes to talk on both bills.
Thank you. And I will just clarify, we're here in support of HB 382. We have no testimony on the other bill.
Okay, so just you can have your 2 minutes to talk about 382. That's fine.
Thank you. I will clarify, and add on to my testimony from earlier that I am the attorney who actually represented SK in Charles County.
Yeah.
I read the legislative intent behind the child pornography bills. They were discussed in court. The legislative intent was to prevent the exploitation of children by adults. Yet somehow SK was still prosecuted in Charles County. I think we've gone through this before that, I don't think Delegate Wilson or any of the other supporters of this bill or any of the other bills are condoning sexting by teenagers. But instead, what we're asking is that the committee understand how common it really is. We've discussed, the studies that show that as many as 27% of teenagers have sent or received a sext. And the issue is that we shouldn't allow the selective few who are prosecuted to suffer the harms. And what is so important to us is to make sure that when teenagers are sexting, one, they're aware of the potential harms, and two, they know that there are resources available for them, that they can trust adults. We want to make sure that they avoid the public shaming and the potential further trauma of the selective prosecution of common adolescent behavior in juvenile court. We urge the committee to issue a favorable report on this bill. I know there was some discussion a little bit earlier about, what our ideal bill would look like. Ideally, we'd like to provide for proactive education of the potential risks of sexting instead of providing education only as a result of prosecution. We'd like to make sure that there are service-oriented interventions through the SINs or SINA system when needed, and that those models are family-oriented, involving the parents, making sure that this is a discussion. So once again, we can ensure that teenagers have adults that they can turn to, that they can trust to help get them out of a situation. Thank you.
Thank you very much. Let's take questions for the public defender here. And we'll go again to Delegate Cardin. I believe you raised your hand. Okay.
Thank you.
Cardin.
Thank you, Mr. Chairman. Just very briefly, thank you again, Ms. Gross, for your testimony. I am going back to what Delegate Grammer had asked Delegate Wilson. Isn't it true, and maybe as a practitioner you can give perspective, I would think that Ms. Shapiro and Ms. Jordan might be able to give perspective too, that a judge can't tell a prosecutor whether they can prosecute a case or not. A judge can only make basically decisions or dismiss based on a failure to provide the requisite evidence. Isn't that true?
While that is true, within the juvenile court system, there is a level of discretion that the judge has, and that's because there is a separate finding of involvement and then a separate finding of delinquency. And so whether or not, the finding of involvement is like a finding of guilt after a criminal trial. But that second level, that finding of delinquency, that's entirely discretionary. What could have happened in a situation such as SK is the judge could have said, yes, technically this fits within the law. Yes, technically they proved that this is child pornography, but I don't think these cases should be in juvenile court. I don't think individuals such as SK should be prosecuted for sending around a picture, a video of themselves, and therefore I will find her non-delinquent and close the case. That's a level of discretion that can be exercised by the judge, regardless of what the law says. And that's the level of discretion that I was really focusing my attention at when I said prosecutors have discretion, police officers have discretion, and so do judges.
Okay, but and so a judge in one jurisdiction, as Delegate Wilson was saying, a judge in one jurisdiction could make a completely different assessment than a judge in another jurisdiction, and unless there's some sort of overriding policy directive, there can be inconsistencies, and that's the issue I think that Delegate Wilson was talking about. Is that fair to say?
That's absolutely correct, and I think it goes back to the earlier discussion that Delegate Wilson was having with Delegate Grammer, that this may not have been prosecuted in the first place in another jurisdiction. Many prosecutors would say that they would never bring a case like this, and similarly, I'm sure many judges would say that they would never place somebody in detention or at an out-of-home placement for behavior like this. But the reality is that we need to anticipate that situations such as SKs have happened before and can happen again. And I urge the committee to understand that and to close those loopholes so that we don't have children treated differently in one county, because that's the judge, that's the prosecutor, that's the police officer that they had to deal with.
All right, are there further questions for Ms. Gross? Delegate Deborah Davis, I think, and then I think I saw you correct. All right, Delegate Deborah Davis, and then I see Delegate Grammer.
Mihal, thank you so much for being here. I think it's important at this time so that my colleagues understand one other important factor. How was SK's case brought to the attention of law enforcement?
So thank you, Delegate Davis. I appreciate that question. What happened in SK's situation is that she sent a video of herself to two friends. And that video was sent, it was a group of friends who, were trying to one-up each other, outdo each other by sending the most ridiculous thing that they could. She sent this video to them of her engaged in a consensual sexual act. Those two friends fell out of favor with SK. They were no longer friends. And one of those two friends actually posted and bragged about posting this video on Snapchat. When those two individuals were no longer friends with SK, one of them convinced, the one who had posted it on Snapchat, convinced the other one to go to the school resource officer to get SK in trouble. That's how this whole investigation started. So when SK was called into the school resource officer's office, she thought she was there for him to offer assistance to help her get the video off of Snapchat. She was crying, she was agitated, she was upset, and she thought she was there for help. Instead, what he did is he interrogated her and had her write a statement that said that she had sent that video out. That's what started the prosecution in this case. And thank you, Delegate Davis. I appreciate the question, and it's good to see you.
Again, Delegate Grammer, I'll get it right.
Thank you, Mr. Chair, and thanks for coming, Ms. Gross. Can you talk to me a little bit about what happened at the county level when they were talking about intent and looking at the statute, and subsequently, if you could refresh me on the opinion. I believe the opinion at the Court of Appeals was very narrow. If you could just walk me through that, please.
Absolutely. So SK was initially charged with 3 different charges. It was production of child pornography for taking the video. It was distribution of child pornography for that initial text message where she sent it around. And she was also charged with showing an obscene matter to a minor, specifically that she sent that video to the other 2 individuals, those 2 friends who were both minors. At the trial level, the judge found her involved on the juvenile equivalent of a guilty finding of just the distribution of child pornography and showing an obscene matter to a minor. I'm not sure if your question is more about, what the discussion was, with the judge and why he made that decision. My memory of that is that he felt that the law said that this could be considered child pornography and that the state had met its burden.
I'm just trying to see how refresh myself on how narrow this was. If I remember, I mean, it came down to 1 vote, and the opinion basically said, look, we don't even think that this was the intent of the statute,
Right.
but this is what the statute says. It's the legislature's fault, and if we want to fix this issue, the legislature needs to fix it.
Oh, absolutely. Your question was not at the trial level, but instead at the appellate level. Yes.
Both. I'm just
Okay.
trying to get a grasp on what the judge did.
Right. At the appellate level, the majority opinion was that sexting can be considered child pornography. It fits within the definition of the law. And while the Court of Appeals said that they felt that sexting should be treated differently than child pornography, they left it up to the legislature to fix that. They felt that it was a loophole within the laws. There was a little bit of discussion, I know at the trial level about legislative intent, and I think it's clear from the legislative intent that the purpose of these statutes was to protect children from adults, not to criminalize children. And I think, as was discussed earlier by Delegate Wilson, cell phones didn't exist, texting didn't exist at the time that these laws were passed. What the court essentially felt, and the Court of Appeals opinion made clear, was that they had no choice but to find her involved because technically this fit within the definition of the child pornography laws as they exist. They ignored the fact that the child pornography laws discuss a subject. They jumped through hoops to find that a person could both be the subject and the person who is charged. And that's really how they reached the decision that they reached. I wish I could elaborate more. I honestly, I don't agree with that opinion, and I don't quite agree with the way in which the court reached the opinion. I think they very well could have, reached a very different opinion by looking at the structure of the child pornography statutes, which do say that the minor has to be a subject, but they reached that decision and then called to the legislature to fix it instead of fixing it themselves.
Okay, I appreciate it. Thank you.
All right. Are there further questions for Ms. Gross? I see Delegate McComas, and then we're going to go to Ms. Jordan, Ms. Shapiro. Delegate McComas.
Thank you, Mr. Chair. Just briefly for Ms. Gross, was there any negotiation as far as with the prosecutor and your office to kind of make this go away? I mean, it seems like, I mean, if you can disclose that, that might be kind of interesting to know.
I don't recall any specific negotiations. I will say that this case happened about 4 years ago. At this point, I don't recall any specific negotiations, but there also was no offer to dismiss the case.
Okay, I think that's the questions for Ms. Gross. We'll go now to Ms. Jordan, Ms. Shapiro, please. We'll give you each 2 minutes, and Ms. Jordan was the first to unmute herself, so she'll go first.
Thank you, Mr. Chair. For the record, Lisa Jordan with the Maryland Coalition Against Sexual Assault. We strongly oppose House Bill 180. We support House Bill 382 with amendments. I do want to thank and acknowledge Delegate C.T. Wilson for all of his work in this area and his sensitivity to the needs of children who have been sexually abused. House Bill 180, although I appreciate the instinct to try to say, there's a bubble, we're not going to prosecute any of these children. I do think that Ms. Hopmeyer's suggestion and observation about the case she had with an offender who was marketing pictures of children, he was under 18. You know, this is what will happen if this passes, is we will create a whole industry of child pornography that is run by teenagers, perhaps supervised by adults from the outside. But this is a really very dangerous path, even though it is well-meaning. So it has too many unintended consequences. House Bill 382, the strongest part of House Bill 382 is the increased education for all children. So I encourage you, whatever the committee decides to do on this issue, let's make sure that all children are getting more information about sexting. The other observation I'll make after both this year's and last year's discussion is that every instance that I've encountered from prosecutors where they're saying, oh no, we need this tool, one of the things they've said is because this is the only way we can get services for the children. And I think we need to take Ms. Shapiro's point that contact with the juvenile justice system is not a positive thing. But I also appreciate those prosecutors trying to use the tool that they have to get children into services. And so Delegate Wilson's approach of using perhaps the SINS system is something that might be especially appropriate for those first or second few instances of sexting that rise to the level of this child is out of control. The parents aren't controlling the child. The guardian's not controlling the child. We do need to have some sort of state intervention, but this is a state intervention that is more directed to services than the juvenile justice system, still allowing that there may be some extraordinary cases where, if a 17-year-old is selling pictures of a 13-year-old who's naked, I do think we want to have some punitive tools available to us. So it's definitely a balance. There are good things in 382. There are good things in 180, but House Bill 149, and I'm sorry, I think I misspoke earlier, House Bill 149, we would strongly oppose.
Thank you very much. Ms. Shapiro, please.
Thank you, Mr. Chairman, Madam Vice Chair, members of the committee. Melanie Shapiro with the Maryland Network Against Domestic Violence. We too oppose House Bill 149 and are favorable with amendments on House Bill 382. House Bill 149, and thank you, Delegate Wilson. I believe that this was the first bill, it was introduced, I believe the first time in 2019 as the response to the Court of Special Appeals decision in Re SK. So it was an initial attempt at addressing the issue, and it is something that very much needs to be addressed because has been stated time and time again, sexting is happening, and so we need to address it in our law. When I think about sexting, there's a lot of different varieties of sexting that happens. There's the consensual sending of an image from one person to another or group of others. There's coercive sexting, which the studies are showing are part of a larger pattern of teen dating violence. And then there's also the republication of the sexting. So somebody receives a sext that may have been voluntary in nature and then republishes it to other people, whether it be posting it on the internet, sending it to another larger group of friends. And each of those situations, we believe, needs to be addressed within its own statute because they don't fall traditionally within what is defined as child pornography. The behavior is different, as we've discussed already today. House Bill 149 just takes this broad brush approach and doesn't really address any of those issues. There's definitely circumstances, as have already been mentioned, that would not be dealt with, the law would not allow to be dealt with if HB 149 were to become law. And so we are opposing that one. As for House Bill 382, the education component obviously is great. Early education, often education, especially as kids are getting cell phones younger and younger and access to the internet. So the concern is with the SINs and the SINA. One, they could have potential net widening effects. It's bringing in Department of Social Services into a family. It's not necessarily their domain. And it could create other system involvement for families. As for sins, it's not really an often used area in current delinquency law. I looked at the data resource guide, what I think is the most recent one, and it's a very small percentage. I can tell you when I was with the public defender's office, when I was chief in Baltimore City, in 5 years, there was one case that was even brought to my attention and it never actually made it to petition. So to expand that is of concern. I do think that there are areas within the juvenile code that we can place the sexting and place a response that does not involve deep system involvement or even court involvement or even arrest. And so we look forward to having a conversation, and that's why we are unfavorable on the House Bill 149 and favorable with amendments on House Bill 382. Thank you.
All right, questions for Ms. Jordan, Ms. Shapiro, Delegate Conaway.
Thank you, Mr. Chairman. Thank you. This is for Ms. Jordan. I got a lot of papers going on here. I was wondering if the juvenile is selling or sending sexually photos that are sexually explicit of other people other than themselves, are they still sexting?
I think that that's up to you, Delegate. You need to define sexting. Sexting is not currently defined in law. My personal opinion would be that that's not really falling under what we're thinking of as sexting commonly. Sexting is often more in the nature of a romantic or frivolous relationship, not something where you're sending a picture of someone else entirely.
So now we're saying it would be illegal for one person to take a picture of themselves sexually and send it to someone else to say, look at me.
That is the state of the law right now, and that is the issue that you're trying to address, is what are we going to do with teenagers who are doing this as a common part of growing up right now, is how do we treat that sort of behavior as in an appropriate way. They're certainly not sex offenders in the way that we generally treat sex offenders. They may not be doing behavior that we're going to endorse, but as Delegate Wilson said, we're not going to put this genie back in the bottle. The question before the committee now is, how do you not punish those children, don't prosecute those children, but still make sure that we are not encouraging coercion and we're not providing a source of child pornography to adults.
Do you know if this sexting concept is taught in grade school?
Some communities do have something about sexting as part of their curricula, particularly on consent education, but that's developed at the local level. So there's a little bit of variance jurisdiction to jurisdiction, but that really is one of the strongest aspects of House Bill 382, is that it would increase the education for everybody across the state. And so I would encourage you to look carefully at those provisions.
Thank you so very much.
Delegate John Carden. And then I see Delegate Kramer again. Delegate Carden, got to unmute.
Thank you, Mr. Chairman. Sorry about that. Just very quickly to Ms. Shapiro, you brought up the issue of other people republishing something that somebody puts up themselves of themselves. Wouldn't that be covered in our revenge porn statute or in the revenge porn law that we have, or not? I mean, I guess you have to have an intent to harm somebody. So if the person puts it up, like in this situation that Ms. Gross was talking about, somebody put it up, but not with intent to harm, but then after the fact, there was an intent to harm, wouldn't that already be covered there? So
it's possible that it could fall under there. I just think that as we're looking at this issue and we had the Court of Appeals decision, and quite frankly, I believe 25 or 26 states have already addressed sexting, and they have all done it very differently. And I just think if it's going to be looked at, it should be looked at specifically at all the different aspects of it and how you want to handle each one of them. If you want to say that we don't think we need to address it because we think revenge porn covers it, then that's fine. My concern would be that it would fall under, if it's not specifically defined and addressed in statute, it could fall under the child pornography statute, which comes with it all of these other additional collateral consequences. just to understand, I mean, it is a quote unquote sex offense. And that is sort of a huge detriment to any person, especially a child who, quite frankly, was just potentially had no ill intent, made a very, very poor decision. It's going to be harmful to somebody else and should be addressed. And so I think the statute should touch on it as well.
All right, Delegate Grammer.
Thank you, Mr. Chair. Question for Ms. Shapiro. We both serve on the Juvenile Justice Reform Work Group. And you made a couple comments today about, we want to give these kids education. The right thing to do is not to subject them to law enforcement or prosecutors. You also said that exposure to the juvenile system typically provides negative consequences. So if the systems that are supposed to remediate juveniles are not doing that, what do you do here?
So as I think that you need to think creatively, and I wish I'd printed it out because I could tell you which state does it. But the one state, the first thing is just a referral for an 8-hour program. So there's no system involvement, there's no arrest, there's no record, there's nothing. And so I think certainly the schools are supposed to, I believe we've seen some pieces of what they're supposed to be teaching and they're developing it. I don't think it's enough. I don't think people quite understand entirely yet how the breadth of what needs to be taught to young people regarding, electronic devices and sexting. And I think it needs to be taught really young, especially now with COVID. We're asking kids to go, kindergartners to go onto a computer on the internet to learn. And so they have all this access. It's going to be hard to take that back. And so kids are going to have computers and access at a very young age. But I think any way to divert them entirely, I think that JS houses a lot of services, but if we can house services elsewhere that address sexting and those behaviors, that would be even better, because they shouldn't have a touch with the court system unless they absolutely need to be there, because all the studies show that any involvement just increases likelihood of further contacts and deeper into the system and recidivism.
But someone has to make the referral. It's typically law enforcement or prosecutor or a judge or the juvenile system. So it's got to be somebody. And if we make a new group and they suck, then what?
So I think that's where the further conversation is needed to be had to sort of flesh out some of those details. I think, for example, marijuana under 10 grams, it's a citation. And that's in the law, and that applies to some other things as well. I would like to see something even lighter than that initially, but that is something that is out there, I think, as an option that hopefully can be discussed.
Okay, I think if maybe you could send me whatever information and as well as Mrs. Gross and Mrs. Jordan, I'd very like to read up on this, please. And thank you.
All right. I don't believe there are further questions from Ms. Jordan, Ms. Shapiro. So we're going to stop there. We're going to go now to opponents of the bill. Generally, I'm going to start with the two state's attorneys, with Melissa Hopmeyer and Gavin Potashnik. I'm going to give them a couple minutes to talk about these bills, and we'll start with Gavin Potashnik.
Thank you, Mr. Chairman. Good afternoon, everyone. Gavin Potashnik from the Hartford County State's Attorney's Office. I like to start kind of with the scope of the problem. And if you want to look at it kind of like a reverse pyramid, I think it's helpful. And first of all, I do appreciate Delegate Wilson's passion and enthusiasm for this issue, and I think it's shared by all. I agree that there is a larger kind of issue with kids sexting and using phones in cases that I think are inappropriate, and to some, the coercion aspect is really frightening to me as one who also has a daughter. But if you take that pyramid lower, you have to look at the number of cases that actually happen. The number of cases that are reported are less. The number of cases that are referred to the Department of Juvenile Services, prosecuted, and then committed. In Maryland, I will note, I went to the Department of Juvenile Services, got the statistics, 0.3% of all referrals in 2019 had to do with all three statutes dealing with child pornography. In 2020 was 0.4%. I think the increase had to do with the change in the law that had to do with the definition of child pornography. I would note that as I sit at my desk, I get calls a lot from police officers in schools to say, what do? I have this image. A lot of times we would say, just delete it, call the parent and be done with it. because we agree that it isn't really a good system for us to utilize for those types of cases. And actually, parents can deal with it on their own to deal with Delegate Wilson's kind of issue with parenting. The cases that make it to intake and the cases that ultimately are prosecuted generally are those cases where the child themselves presents with some significant issue that needs to be addressed. Remember, the juvenile system itself is a diversion. The juvenile system itself is, provides services and opportunities for kids to receive rehabilitation. The cases that make it to court are kids that fail that process. And then the judge then has to make that determination themselves about what services are appropriate for that youth. We had one commitment, which was the SK case in the past 3 years. One commitment. And it's frustrating because although we hear Ms. Gross's side of the story, the state cannot present their side because we're bound by confidentiality. But I would hazard to guess that there's more to the story about the behavior, psychological, and other issues that individual had experienced. Not to say that it's not a problem, not to say that we need to have a solution, but I think the best answer is House Bill 180. I would also note that I share Ms. Shapiro's sentiment about net widening. If you give law enforcement an out, they'll provide more kids to that out. If you say, hey, great, put all these kids in a SINA situation, they'll do it. In which case, then you'll see an increase in kids being put into a system, which I don't think we've explored enough to see if they have the type of resources to handle it. I do want to say I really do appreciate in House Bill 382, and I would endorse continued education, particularly as long as we can. I know when we try to do education in schools, a lot of times parents want to, yes, sir. Oh, give me 1 second. A lot of times parents want to opt out of education because they're concerned. I think mandating it for the state would be a healthy alternative. With that, we ask for unfavorable.
Thank you. Ms. Hoffmeyer.
Thank you, Mr. Chair. And I'm not going to add much more to the testimony that I gave based on House Bill 180. I will just note the way that we handle it in Prince George's County. We have a standard operating procedure within the office where if there is a sexting situation or we have an issue in Prince George's County specifically with airdrops of child pornography, which is in a large lunchroom in a high school, somebody just airdrops an image or a video, and we do not refer any of those cases on a first-time basis for prosecution. Either the resource officer or the detective who's involved contacts my unit, whoever's on call, just gets the information from it, and they are referred for not services, but they are referred to an 8-hour course or whatever course, I'm not sure how many hours it is now off the top of my head, about sexting. And then ultimately, if they are engaged in that process again, we may then at that time, if we think appropriate, refer them to juvenile services. So we do have an internal standard operating procedure, which we took time, with this, with Ms. Braveboy to come up with, because we do believe that this is a problem. We do not want to prosecute our children and make them sex offenders or make them subject to the system without needing to be. And so there are alternatives. I'm not saying that our program is perfect, but there are alternatives to prosecution. But we do need to be able to prosecute those individuals who are malicious and harmful in nature, as I've indicated in those two examples that we have of juvenile offenders who were purposefully and harmfully engaging in distribution of child pornography.
All right, thank you very much. I think there's another, I'm sorry, there's Mr. McAvoy, but what we'll do is we'll take questions for Mr. Potashnik, Ms. Hoffmeyer first. Are there any questions for the two state's attorneys? Seeing none. Okay, we'll now go to the last person to testify, and that's Mr. McAvoy. Vince McAvoy, please.
Thank you, Chair.
There he is. Go ahead. 2 minutes, please.
Is that for both of them?
Yeah, it's 2 minutes altogether, yes.
Okay, thanks. What we heard is mention of parenting. Apparently, someone hasn't seen the family law bills that we have in Judiciary. There's a lot of parenting bills that go on there. We hear that it's happening, and the answer seems to be throw up your hands. I think this is the wrong approach. Every year we get moral judgments from those speaking to these bills in Judiciary, and for our children it must be no different. They making excuses for lack of parenting. For instance, Melanie brought up kindergartners using laptops. You got to revoke your parent card if you give a computer to a toddler and don't put controls on it to prevent inappropriate access. The software is ubiquitous. Okay, and so we're saying, what I'm hearing is that this must go through. I'm hearing state delegates say this must go through. And the fact is that we just heard that we have a minimal problem. We have one high profile case and that most are not being charged. We must keep the net there so that those 14 and 15 and 16-year-olds entering into industries to make profit will not feel that they're immune from production of this material. This is when you just look at the code. I invite you to look at the code in this and what you're giving a pass on. And I urge you not to do that. You know, for instance, production of obscene matter, visual representation, performance, big to minor, engaged in sadomasochism, etc., etc. This must not be allowed. When we didn't have this technology when this code was written years ago, but we also didn't have the proliferation of teens entering into horrible industries. This will help a couple of children, maybe that might end up in the criminal justice system. It might end up there anyhow, as the person from Hartford said. But the fact is, it will put the bulk of the children in Maryland at higher risk because we're not having controls. Is that my time?
Thank you very much.
Thank you.
Other questions for Mr. McAvoy? Seeing none, that concludes the testimony on those two bills from Delegate Wilson, House Bill 149 and 382. We thank you very much, Delegate Wilson. Obviously, committee, we're going to be talking about this some more. I don't want to minimize it at all, and I do appreciate your attention and
Thank you, Mr. Chair.
on these issues. Thank you again, Delegate Wilson.
Be excused.
Yes. Okay, that's fine. So now we're going to Delegate Guyton. Delegate Guyton, and I think we have some maybe of the same witnesses again, or at least, yeah, we do. A couple of the same witnesses again. Is Delegate Guyton here? There she is.
I am, Mr. Chair.
Thank you very much. Here's what we're going to do. 3 minutes for the sponsor. I'm hoping that I've got the last name right. It's Sayan.
Mhm.
Kristen Sayan, Isabella Sayan,
Yes.
Lisa Jordan. Okay, there you are. I see you. All right. Lisa Jordan, Lori Ruth, Melanie Shapiro are the people signed up to testify. We'll start off with the delegate. We'll then go to the Sayans, and then we will go to Ms. Jordan, Ms. Ruth, Ms. Shapiro.
All right. Thank you so much, Mr. Chair. And thank you, Madam Vice Chair and members of the Judiciary Committee. For the record, I am Delegate Michelle Guyton from District 40 in Baltimore County, and I'm here to ask for your consideration and favorable report, hopefully, on House Bill 193, to require law enforcement agencies to provide a private room upon request for victims reporting crimes of a sensitive nature, and to post signage to that effect. This bill was presented to you last year at the very end of our session as House Bill 1294. I also want to let you know that in addition to the witnesses that you're going to hear today, this bill has been endorsed by the Women's Caucus, and you'll be receiving a letter to that effect shortly. So best practices for sexual assault investigations, you all know as well as anyone, include ensuring the privacy of victims and providing sensitive and respectful trauma-informed support to victims of sexual assault from the very first encounter with law enforcement throughout the investigation and prosecution. So this is not only important for reducing re-victimization, but it also encourages reporting of a seriously underreported offense. So House Bill 193 was born of specific constituent concerns after a police precinct in my district required a minor female to describe the specific nature of her sensitive complaint, her assault, in the public lobby and through a security window while others were available to look on. Obviously, this incident was traumatic and it was inappropriate. So assuming that this was an isolated event, I tried to do my research before I introduced legislation, and I contacted local and state law enforcement agencies, requested copies of sexual assault reporting procedures, and I did hear back from quite a few of them: Prince George's, Anne Arundel, Baltimore, Howard, Calvert, Carroll, Kent, Queen Anne's, Caroline, and Baltimore City. However, none of those jurisdictions actually have a policy requiring a private room for reporting sensitive issues, such as sexual assault. Most of the counties responded that if somebody requested privacy, they'd be willing to provide it, but it was not something that they actively provide for them. So in response to this lack of guidance on best practices, I introduced HB 193. It requires signage that a private room is available to anyone reporting crimes of a sensitive nature, and it requires that law enforcement agencies honor that request. I asked for a favorable report on HB 193. It's a simple bill to protect victims of sexual assault from further traumatization and invasion of privacy. I also want to let you know that a minor witness will be testifying on this bill. I did offer to allow her to keep her camera off for this procedure, and she opted to keep it on. So I'm very grateful for her participation and bravery. Thank you very much.
Thank you very much, and we thank them very much indeed for their bravery and being willing to talk with us today. So we will go now to the Sayans. And please, if I've mispronounced your name 14 different ways, that's par for the course for me. So please, whoever would like to go first, you're both on the same camera.
All right, good afternoon. On August 25th, 2019, I went to the Cockeysville Police Precinct with my father to report an incident that occurred in a restaurant where I worked. The police station there has a lobby where officers sit behind a glass wall. My father explained to the officer why we were there, and the officer then asked me to relay what happened to me in a public lobby. What happened to me was very embarrassing, and it made it I'm sorry.
Take your time. You're okay.
It made it even more so by not being able to tell the male officer my story in private. I returned to the police station the next day with my mother, and we experienced the same thing. I was made to give my explanation in a public lobby to another male police officer. This caused me to feel very uncomfortable again, and overall felt like an experience that anyone could easily walk in on. It was not until my mother consulted an attorney who had been a police officer that she was able to demand we be taken into a private room to let me explain what happened. This was it was my feeling that anyone could come into the police station to report a crime like assault, which may be sensitive or embarrassing for them. That they should have the option to do so in a private room that was away from the public eye.
Thank you very much. Very well done. Thank you. If you'd like to, Ms. Sayan.
Okay. On August 25th, my husband took our daughter to the Cockeysville Police Station to file a police report. I was appalled to find out that she was made to tell her story, not in a room face-to-face with an officer, but in the public lobby of a police station. The lobby in that building is similar to a bank lobby with an open space and officers behind glass and no privacy whatsoever from anyone who entered the building. It's also necessary to speak loudly because of the space and the glass. The questions my daughter was asked were personal, and the experience she had to describe was embarrassing enough without being asked to speak up and repeat herself to the officer. In the end, she and I returned to the police station 2 more times. Each time she was made to retell her experience right in the public lobby with whomever was there for whatever reason listening in. As a mother, this was infuriating and unacceptable. My daughter was unprotected. She was brave enough to walk into the police station and tell them what happened to her, yet she was not given the dignity and safety of being able to tell her story in private. She was 15, and this was a terribly embarrassing and humiliating experience for her. And as a mother, I was helpless, as this is the way it was done. Victims who enter a police station to tell their stories, to file charges, and to seek guidance and protection should have the option to tell what happened to them in a private, safe space. Thank you.
All right. Thank you very much. Lisa Jordan, please.
Thank you, Mr. Chairman, Madam Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're here in support of House Bill 193. I want to thank Delegate Guyton and also thank her constituents. I'm going to butcher their names as well, but I believe it's Ms. Sion and Ms. Sion. You're brave to come forward. When Delegate Guyton brought this bill forward, she called the Maryland Coalition Against Sexual Assault to ask for our input on it, which I very much appreciate. I was able to share with her that in the hospital setting, in the medical care setting, this is already the rule. Our regulations in Maryland say that rape survivors, sexual offense survivors shall be considered emergency patients with special needs, that the victims shall be immediately taken to a quiet, private area. This is just requiring the same thing out of law enforcement. So I encourage you to issue a favorable report on this. I also want to say that I very much appreciate the delegates' willingness to expand this to all personal crimes, all crimes against the person. Yes, it's absolutely correct that sexual assault has particular sensitivities, but there are other crimes as well, and we should treat all crime victims with respect and give them these sorts of options. So we ask the committee to issue a favorable report.
Lori Ruth, please. Right here. Lori.
Good afternoon, Mr. Chair, Madam Vice Chair, members of the committee. My name is Lori Ruth. I'm the legal director at the Women's Law Center of Maryland. I want to thank Delegate Guyton for bringing this back this year. I don't want to repeat what anybody said, but I agree with Delegate Guyton that it's a simple and yet important bill. It is attempting to offer victims of the Title III other crimes against the person, as Ms. Jordan alluded to, the dignity and privacy and trauma-informed approach that really, really matters for people like the young woman who just testified before me. I will mostly just say me too at this point and urge a favorable report. It's easy. There's no fiscal note. Thank you.
All right. Thank you. And then Melanie Shapiro, please.
Thank you, Mr. Chairman, Madam Vice Chair, members of the committee. Melanie Shapiro with the Maryland Network Against Domestic Violence. I just want to reiterate the thank yous to Delegate Guyton as well as to our constituents. It's very brave of you to come and testify before this body. So thank you so much for that and sharing your story. Domestic violence is one of the offenses covered under Title III of the Criminal Law Code. And, you know, as words such as trauma-informed, trauma-centered, victim-centered become part of our everyday language, that is exactly what this bill is. It is a victim-centered bill. And saying we urge a favorable report on House Bill 193.
All right, there are several questions. We're going to start with Delegate McComas, then Delegates Williams and Arakan. Let's go to Delegate McComas first.
I want to thank Mother and the young lady of their testimony. I missed what jurisdiction it was where you went to the police station. I didn't catch that.
Cockeysville, Baltimore County.
Oh, okay. The other question is, how big was the police station there? The only reason I'm asking is, was it large enough that they had interview rooms that they could have taken you at the time?
When we returned for the fourth time, we were taken into an interview room at that time.
So did you request it at that point?
I didn't. That was after I had spoken with an attorney. At the first 3 times we went to the police station, the officers declined to even take an incident report. So it was not until I spoke with an attorney that he gave me the language to use in the police station to have them file a police report.
Did just a quick follow-up, did it result in any type of prosecution?
They were never able to find the man.
Okay, all right. If they had been able to find the man, do you believe they would have prosecuted the individual?
I was led to believe that they would have.
Okay. Thank you very much.
You're welcome.
We will go now to Delegate Williams and then Delegate Arakan.
Yes, thank you. My question is really for the bill sponsor. One, Delegate Guyton, thank you for bringing this legislation again before us. Is there any reason that you can suspect or that you're aware of as to why something like this couldn't, why a police officer or police station wouldn't be able to provide such services?
I'm sorry, Delegate Williams, why they would not be able to provide the services?
Yes. Is there
No,
any
when
circumstance
speaking
that
to-
you're aware of?
Sure, no. When speaking to all of the jurisdictions that I mentioned before, it seemed as if they just really hadn't thought of putting
Hadn't
that front
thought
and
about
center. That they would do it, but they didn't have to do it, and they didn't have sign. So it wasn't that there was any real opposition to the idea. They recognized the need for such a thing. It just wasn't something they had to do. So that's why I introduced the bill. And it's been a year now, just to point out, since I introduced the first draft of the bill. So it's been almost 2 years since this event occurred. And I have been in contact, at least with our law enforcement since that time. And they have yet to put this provision into their policy. So it's time for a bill. All right. Thank you. Thank you very much.
All right, now we'll go to Delegate Arakan, please.
Thank you very much, Mr. Chair. Thank you so much, Delegate Guyton, for this bill. I guess I'm just going to do a really small, isn't that so? I sit on the Women's Legislative Caucus Review. It's very hard to get a bill through the Women's Caucus Review, and it has to be bipartisan. Isn't that so, Delegate Guyton?
That is so, Delegate Arakan. Thank you so much for making that point.
So brazen abuse of the isn't that so policy, but all right, that's fine. We'll let that go. All right. Are there, I don't know whether Ms. Jordan was actually waving to be recognized or no. Okay, that's fine. Are there further questions for this panel? Yes, Delegate Bartlett.
Thank you. My question is for Delegate Guyton. As I mentioned in the Women's Legislative Review Committee, would you be interested in a friendly amendment to allow the victim to have a right to an advocate to be in the room when reporting? Excuse me if you can hear that background. Yeah, when reporting.
Delegate Bartlett, thank you so much for that question. I would certainly welcome that. I think that takes this bill to another level. It may be a more complex level, but if this committee wanted to take that on, I would certainly be appreciative of that. And I think it would really go a long way toward alleviating these problems.
Okay, thank you.
Are there further questions for the panel? I don't see any further questions, so thank you all very much for your time. Thank you again to you for being courageous and coming and speaking with us today. We really do greatly appreciate that. And thank you for your time today.
Thank you so much, Mr. Chair.
Thank you. Thank you. That concludes the testimony on House Bill 193. All right, committee, here's what we're going to do. This is going to be probably one of the first days that we have had a prolonged set of hearings, and I don't necessarily mean to prolong it any further than I need to. However, we're going to hear Delegate Crutchfield's bill first, House Bill 385, and I'll go into that here in a moment. After that is Delegate Jazz Lewis, and I will just insert for the record that he's abandoned us and et cetera, just so I can get that off my chest right now. We all know that and appreciate that. But he has a bill that is very important, very significant, and has quite a few witnesses. What I am inclined to do is hear Delegate Crutchfield's bill and then take a 30-minute break after that, given that we are, doing Zoom hearings is a little bit different than if we were in the committee room and people aren't as able to get up and get around. We might take a break after this and then come back in 30 minutes. I will see how we're doing this isn't trying to disincentivize anybody from asking questions or make Delegate Crutchfield rush or anything else. It's just trying to keep the attention of the committee here as we deal with some very, very important issues through the rest of the afternoon and into the early evening. So with that, we will go to, and I'm saying that also for the people who are watching at home, that it is likely that we will take a 30-minute break after this bill and then start the next one. This is a 3 and 2. The sponsor gets 3 minutes. The witnesses get 2. There are 11 witnesses on top of Delegate Crutchfield. And is the order in which we're going to call them. It's likely that we will take a 30 minutes. The first obviously will be Delegate Crutchfield, and we will hear from Lila Meadows, Erica Suter, Rachel Cammons from the Office of the Public Defender, Judge Gary Baer, Judge Karoom, and then Keith Wallington. We're going to let those first 6 people in the room, and then we will go to the remaining 5 people who will testify after that. We'll take questions after the first, after the delegate and the first 6 people testify. So with that, and making sure that everybody's on mute before, okay, thank you. We're all getting used to it too. We'll start now with Delegate Crutchfield. Delegate Crutchfield, please, for 3 minutes.
All right, thank you. So good afternoon, Chair Clippinger, Vice Chair Atterbury, and members of the Judiciary Committee. And for the record, I am Delegate Charlotte Crutchfield from District 19 in Montgomery County. And thank you so much for allowing me to testify today in support of House Bill 385. House Bill 385 will end the practice of charging juveniles with felony murder. It also provides a mechanism for those already serving a life sentence for a felony murder that occurred at the time that he or she was a juvenile to petition the courts for resentencing. So under our existing law, felony murder is codified under the statute for first-degree murder. Typically, the state would need to prove premeditation to sustain a first-degree murder conviction. The felony murder doctrine allows the state to waive intent altogether. The only showing the state needs to make is that there was a loss of life and there was an underlying felony. Because felony murder is charged as first-degree murder, it carries a mandatory life sentence. Let that sink in for a minute. Today, in the state of Maryland, there are individuals who have been sentenced to die in prison for murders that they did not actually commit and that occurred when they were children. This reality is shocking and poses grave constitutional issues in light of the 8th Amendment and recent decisions from the Supreme Court that recognize that children must be treated differently than adults in our criminal justice system, due to their lessened culpability and their tremendous capacity for change. While we do not know the exact number of individuals serving life sentences for felony murder that occurred as a juvenile, we do know that there are over 300 juvenile lifers in Maryland. They are overwhelmingly Black. Make no mistake, reforming felony murder is an urgent matter for racial justice. I want to be clear that this bill does not erase accountability for juveniles. As a former prosecutor, I understand the important role that accountability and deterrence play in our system. Under this legislation, juveniles involved in the commission of a crime that leads to a loss of life will still be charged with that underlying felony and may still be charged as adults. Those underlying felonies carry the possibility of a significant sentence. This bill simply prevents the state from charging a child with a murder that he or she did not actually commit and prevents the courts from imposing a life sentence. I'm asking you to support House Bill 385 to end this practice in Maryland. This is not a radical change. It's just a step in the right direction. And it is also in step with many of our colleagues in other states. In fact, Illinois just passed the same type of legislation last week. Now, there is an amendment to this bill, and it's a procedural amendment. And unfortunately, I was not able to get that from the amendment office as I wanted to present today. But what that amendment does is it simply says that even though establishing clear and convincing evidence, the person has to have been guilty of the actual charge. Right now, the way the bill is written, it does not state that. And I wanted to be clear of that. So what I'm looking for from you is a favorable report on House Bill 385. Thank you.
Thank you very much. We'll go to Lila Meadows now, please.
Good afternoon. My name is Lila Meadows, and I'm a faculty member at the University of Maryland School of Law. For all the reasons that you'll hear from my colleagues who follow me, I urge you to support House Bill 385. Maryland is in the midst of a mass incarceration crisis. As you'll hear from Keith Wallington, we lead the nation in racial disparities in our incarcerated population. I'm encouraged that this committee is considering a number of pieces of legislation that would begin to dismantle that system. I have already this session and in previous sessions, and will continue to appear in front of this committee in support of those bills, chiefly the bill to remove the governor from the parole process and the JRA, which you'll hear later today. But the truth is there's no one piece of legislation that's going to break this dam, just as no one law was responsible for building it. We need all of these reforms to make a difference in Maryland. This bill, as Delegate Crutchfield already noted, is about accountability and proportionality. And I talk a lot about that in my written testimony. This is about having a legal system that holds children accountable for crimes they commit, not for the crimes of their co-defendant. No one in support of this bill is asking that juveniles not be held accountable. As Delegate Crutchfield noted, they're still liable for the underlying felony. They can still be charged as adults. And in cases where it's appropriate, they can be charged with traditional premeditated first-degree murder and also with conspiracy where the state can make that case. Proportionality is one of the most important principles in our legal system. When punishing children, the Eighth Amendment requires it. The prospective piece of this bill will ensure that children are not sentenced to life in prison for a murder he or she has not actually committed. The retroactive piece will still require a substantial period of incarceration, 30 to 40 years. Accountability will remain, but with the passage of this bill, it will be in proportion to the crime actually committed. I urge a favorable report.
Okay, let's go to Erica Suter, please.
Good afternoon. My name is Erica Suter. I'm a post-conviction and appellate criminal defense attorney, and I'm vice president of the Maryland Criminal Defense Attorneys Association, and I'm here on its behalf. I wanted to take a moment just to talk about how the process would work as outlined in the bill. Going forward, juveniles, children, could not be charged with felony murder. They could still be charged with the underlying felony. They could still be charged with premeditated first-degree murder, conspiracy to commit premeditated first-degree murder, or under a theory of accomplice liability. And of course, second-degree murder would remain available as a potential charge. Retroactively, a person who was a juvenile at the time, who was a child at the time that they were convicted of felony murder, could petition the court. So they would be the moving party. And if they made a showing in a pleading, then the court would hold a hearing and the state would demonstrate that the person was in fact, if the state could not demonstrate that the person was in fact not convicted of premeditated first-degree murder, then the court would resentence that individual up to the maximum penalty for second-degree murder at the time, either 30 years or 40 years post-2017. And the reason why we have that piece in the legislation, the reason why that piece is in the legislation is, as Delegate Crutchfield explained, we do not know exactly how many juveniles have been convicted of and sentenced for felony murder because the Department of Corrections, and we've tried in a number of ways to try to get a handle on this, but felony murder and premeditated first-degree murder are both reflected in people's records as first-degree murder. And so there is a bit of sorting out that would have to happen in order to identify who fell under which particular theory. And I, on behalf of the Maryland Criminal Defense Attorneys Association, would urge a favorable report on this bill.
All right, thank you very much. We'll go now to Rachel Kamens from the Office of the Public Defender.
Thank you. Good afternoon. My name is Rachel Kamens, and I'm testifying on behalf of the Public Defender in support of House Bill 385. The felony murder doctrine rests on the premise that a killing that occurs during the commission of a felony is foreseeable to everyone involved in the felony. Maryland law mandates that a person convicted of felony murder be sentenced to life in prison, which is the harshest mandatory penalty allowed in the state. As applied to children, this law is cruel and unusual in violation of the Eighth Amendment, which prohibits excessive and disproportionate sentences. Sentencing a child to spend the rest of his life in a cage for a crime premised on foreseeability is excessive, not to mention that a child will spend more years incarcerated than his adult counterpart. We know from neurological and social science, which the Supreme Court has recognized time and again, that children have intrinsically lower moral culpability, are more impulsive, have less ability to foresee risk and anticipate the consequences of their actions, and have a greater capacity for change than adults. Passing felony murder reform aligns with the national trend, as has been stated, to treat juvenile offenders differently based on the vastly different penological considerations in play. The Office of the Public Defender urges a favorable report on House Bill 385. Thank you very much.
Okay, Judge Gary Bear, please.
All right, thank you, Chairman. Thank the committee members, Vice Chair Atterbury, and the committee members for this opportunity to speak in favor of House Bill 385. My name is Gary Bear. I am a retired Montgomery County Circuit Court judge as of about 2 months ago. Over the past 8 years, I heard hundreds, if not thousands, of juvenile delinquency cases and criminal cases where juveniles were charged as adults. I also dealt with juvenile justice issues as a prosecutor, as a defense attorney, as a law school professor over the past 45 years. And also, as I've seen some of my former members, I've also served on the Department of Juvenile Services State Advisory Board for the past several years, meeting with Secretary Abbott and others. Now, based on all my experience, and in particular from all the juvenile court experience I had as a judge, juveniles at the age of 15, 16, 17, and even young adults who are charged as adults are not fully mature. As Ms. Kamen said, they are impulsive, they are easily swayed by their peers, they often engage in group conduct that is reckless without thought to the short-term or the long-term consequences of what they do. Maryland's felony murder doctrine is an especially ill-suited one as applied to juveniles. It allows for the imposition of a life sentence where an accidental or unintentional death occurs during the course of a felony, such as a robbery or a burglary. It further allows for the imposition of a life sentence for all those who participate in a crime, even accomplices who may have played a very minor role in the offense. This is really not justice or fair to juveniles. Many other states have lowered the penalty for felony murder, and Maryland should do likewise. In the meantime, however, the crime of felony murder should not be applied to juveniles who are being prosecuted as adults. The bill recognizes this going forward, and for those juveniles convicted of felony murder in the past, it would do likewise to permit a modification of sentence. So this is simply a recognition that current felony murder law is arcane and too harsh as applied to young offenders whose brains are not fully developed. Thank you for your
very
time.
much. Thank you. All right, we will go now to Judge Karoum, not speaking for the judiciary, speaking for himself.
Thank you, Mr. Chairman, members of the committee. I would like to echo things that were said by Ms. and by Judge Bear just now as to the inappropriateness of the felony murder rule when it applies especially to juveniles. In terms of the foreseeability, I'd like to give you some examples of actual cases that are reported cases in our Maryland courts. One of them, Jeter, from 1970, involved someone who was under arrest and in police custody when another member of a group breaking into a warehouse shot someone, and Mr. Jeter was found guilty even though he was in police custody and had no participation whatsoever. In a case called Jackson, Mr. Jackson was found guilty when police accidentally shot a store employee and no one was actually shot or killed by those involved in the crime. In a case called Stewart, there was not even a gun involved in an attempt to rob a motel. And the motel clerk later, a day later, had a heart attack, which was attributed to her anxiety and fear from the robbery. These are just a few examples, and I suspect that the committee knows of more, demonstrating that foreseeability and deliberate killing is really not even a part of felony murder. The result is that the felony murder doctrine turns out to be more a huge, powerful lever for prosecutors to get guilty pleas, as I did in my days of a prosecutor, in cases for folks who have actually less involvement in the offenses. The last thing I'd like to mention is that felony murder doctrine is one that is hundreds of years old. It was invented in Great Britain. And in Great Britain, Canada, and Australia, it was repealed 50 to 75 years ago. And across the United States, so many states also have joined that trend, that it is very appropriate for our state to join them, particularly as to juveniles.
Thank you very much. Thank you. We're going to go now to Keith Wallington, please. And then we will take questions. And I already see Delegate Fisher. If members have questions, they should begin to raise their hands in the chat and the participant section, or write question in the chat. Thank you. Mr. Wallington, please.
Thank you, Mr. Chair and Madam Vice Chair. My name is Keith Wallington, and I am here today with the Justice Policy Institute in support of HB 385. Maryland's practice of extreme sentencing and restrictive parole release has run counter to the spirit of the Supreme Court's opinions on this issue for years. In Miller versus Alabama, the Supreme Court held that the mandatory sentences, as you all know, of life without possibility of parole are unconstitutional for crimes committed when one is a juvenile. I'm here mostly because this is particularly troubling in a state like Maryland that leads the country in racial disparities. Maryland has the worst racial disparities throughout the justice system, and juvenile felony murder convictions are not exempt from that trend. More than 70% of all people in Maryland's prisons, double the national average, and almost 80% of people serving at least 10 years are Black. These are the highest rates in the country, outpacing states like Mississippi, Georgia, Alabama. Maryland's practice of skirting the Supreme Court decision against mandatory life with the possibility of parole for youth by imposing extreme sentences and restrictive parole ignores advances in understanding of youth and emerging adult development, as you've heard today. These young people offer tremendous opportunities for change and redemption, and given a chance to learn and participate in supportive programming. Failure to invest in our young people involved in the justice system has been catastrophic for the Black community. And it is long past time that we chart a new course. For this, JPI asks for a favorable consideration for HB 385. Thank you very much.
All right, are there questions for this first panel, for the delegate and for the first panel? We'll start with Delegate Fisher, Juanica Fisher.
Thank you, Mr. Chair. Thank you, Delegate, for bringing this legislation. This question is either for you or if you want to direct it to one of your panelists. I think it's, to me, would be said and what would be your response to that? Because I don't see it and I want to sort of understand that better.
Would Professor Meadows, would you like to address?
Sure. Sure, I can address it first and others may have thoughts too. But, you know, I think the traditional thinking around this is that the felony murder doctrine is a deterrent. And that turns, of course, on the foreseeability. If you're going to participate in what is considered an inherently dangerous felony, you should know that when you go into that store to rob somebody, that your co-defendant may have a gun. Or if you know that your co-defendant has a gun, that your co-defendant may use it to shoot and kill someone. You should know that if you're going to commit robbery. And, you know, I don't think that there's any evidence that the felony murder doctrine really does present much of a deterrent for anyone, because a lot of people don't know about it. I can't tell you how many clients I've represented convicted of felony murder who said to me, you know, part of the reason I didn't take a plea in this case is because I didn't understand the felony murder doctrine. I thought, but I didn't commit murder. How are they going to convict me of first-degree murder and sentence me to die in prison when I didn't touch the gun? I didn't know he had a gun. And so most people, I think, don't know about the doctrine, are surprised to learn it exists. And if you don't know about a law, I'm not sure how it can deter you. But also all of the issues that Rachel, Judge Baer, Judge Karoum raised about juvenile brain development suggest that juveniles are less able to weigh risks and consequences. They don't. Foreseeability just doesn't work in the same way, which is what I think makes this doctrine especially unjust and unworkable.
Judge Karoum, in response.
There is a study which I have seen, and it may be in my written testimony, that says someone surveyed hundreds of people who were convicted of the felony murder doctrine to see how many of them were familiar with it. The surveys had heard of it before they actually went to court and were convicted.
I'm sorry, I didn't hear the part. Can you repeat that, Judge? I'm sorry.
Who were convicted of the felony murder doctrine. I think this showed that only 1% of them acknowledged any familiarity with the felony murder doctrine before they actually went to court and were convicted with it.
Okay. All right, we will go now to Delegate Moon.
Thank you, Mr. Chair. Just a quick question. I'm just trying to, I feel like I should know this, but is a juvenile convicted under felony murder eligible for life without parole, or is this a parole eligible situation? And the reason I ask is I'm trying to understand how much overlap there is between people covered under this bill and people covered under how many of them would be impacted by getting the governor out of a parole decision. So just trying to see where the Venn diagrams lie with these bills.
Right. And it's my understanding, Delegate Moon, and of course, Ms. Sutter, because I know you deal specifically with this, but it's my understanding that it's either life or life without parole that you are given as a sentence for this.
Yes, so if the state chooses to, if the state files notice to seek life without parole currently under Maryland law as a juvenile, you could receive life without parole. And of course, life is a mandatory sentence for first-degree murder. I mean, I think the bigger issue of what you're asking about is if the governor were removed from the parole process, and I think this really speaks to what Professor Meadows was talking about, you know, will that solve the problem? Is that the tool that gets us out of the incarceration crisis that we have right now? And I think the answer to that is no, because even if you look at how the parole system is functioning right now and the backlog that they have with people getting risk assessments, I just got a call the other day from someone who has been waiting. I think the wait to actually get a risk assessment done, which is part of the process before you would even get to the point of being currently recommended by the governor, but if the governor were removed, getting that recommendation for parole, I think the backlog is up to 18 months. And Lila, you may be able to speak to this better. So there is currently, as things stand, such a huge backlog that I think what we see is that, as Lila was saying, you know, we didn't get to this particular circumstance, this level of crisis with, you know, one law. And it's going to take, I think, a number of tools to be able to adequately address it, both retrospectively and going forward, so that we're not continuing to contribute to being, you know, the state with the highest proportion of Black people incarcerated in the nation.
Here's what we're going to do. There are several questions. Delegate, okay, and I see Mr. Karoum has a response. So we'll take Mr. Karoum's response here, and then I'm going Erican, Cham, Conaway.
So a direct response is the state of Maryland does not keep statistics on the number of people who have life sentences from felony murder as to the percentage of premeditated murder. So no one can say with certainty. To my knowledge, no one has actually delved through. You'd have to go case by case to look at the verdict sheets and the jury instructions to figure that out. But it is well known that there's a substantial proportion of especially juveniles who are convicted by felony murder because they tend to have a ancillary role, not the primary role. And even if you got the governor out of parole, felony murder would still have a big impact because it is this huge lever and bargaining chip that permits prosecutors to get guilty pleas for even lesser offenses. The case may be weak, but if a young person is facing a life sentence, if they go to trial, they may plead guilty and accept a conviction that they otherwise could have fought to avoid the possibility of that life sentence. So you get a lot of felony sentences when felony murder was the top count, even if the conviction isn't felony murder, it's still resulting in an increase in the number of young people who are going to the prisons.
Okay, we're going to go now to Delegate Cham and then Delegate, oh, I'm sorry, no, Arakan. I'm sorry, Arakan, then Cham. Arakan, Cham, Conaway. Arakan.
Thank you, Mr. Chairman. Thank you, Delegate, for this bill. So listening to some of this testimony, I'm a little concerned that people are showing up to be convicted and they haven't been explained what felony murder is. I feel like that might be an OPD problem. I mean, how is that even possible? Is it malpractice? Why is no one's attorney telling them this stuff? That's my first concern. I didn't really get a clear line on Delegate Moon's question about parole eligible. I'm assuming that they are parole eligible if they're convicted of felony murder. So what are we looking at, like 15 years that they could be eligible for parole there? And then, so if they're eligible in 15 years, when does the risk assessment get triggered? So when can they get on the docket to get the risk assessment? And could we make it a law that 18 months before you will be eligible, you can get on the list for risk assessment so that you're not becoming eligible for parole and then waiting another 18 months before you can get on the docket? Or is that how it already works? And Delegate Crutchfield, you can pick whoever should answer those questions.
Yeah, I'd like to OPD's office to respond to that, please, if you don't mind. Ms. Kimmons.
Absolutely, Delegate Crutchfield and Delegate Arakan. I'll do my best. So I hear you asking, how is it that folks are becoming convicted of felony murder without understanding what is felony murder? And what I understood the testimony to convey was that, first of all, there is a lack of understanding in general based on actual empirical data among juveniles as to the fact that involvement in a felony leading to a killing can actually wind them up with a murder conviction. So in addition to the polling that has been referenced, there is the data, and the Supreme Court has discussed this in its cases, where the effect of deterrence, even if that knowledge was more prevalent among juveniles, the effect of that deterrence is virtually nil among juveniles, that it is not going to deter their involvement in a felony because of their inherent inability to sort of foresee and anticipate the risks of their behavior. So I think once we get into a courtroom, though, clearly a conviction is going to be hopefully universally, the elements of the crime are going to be explained. If it's a guilty plea, the juvenile is going to be voir dired by the court to ensure a full understanding of the elements of the crime to which the plea is being entered. And certainly at a trial, the explanation of the elements of the offense is communicated through by counsel to the client, but also through jury instructions and closing arguments. So I don't know that we have an epidemic of juveniles being convicted of a crime that, you know, they're oblivious exists once they're in the courtroom. Does that answer your question? Thank you. There was another part of the question that I think is probably suitable for Professor Meadows to address. So if I can defer to her.
Sure. So your question about the risk assessment process, Delegate Erickson, the way that that works is a lifer does become parole eligible after serving 15 years of their sentence. And what happens at that point is they'll have a parole hearing in front of 2 commissioners. And only if those 2 commissioners find that person suitable to move forward in the process does the person receive a risk assessment. Do they go in line for that? The vast majority of people, by the way, serving life will not get a recommendation for a risk assessment at their first parole hearing. They're going to be told, come back in a few years before we talk about a risk assessment. So there's kind of no way based on eligibility to queue someone up for an assessment. And my understanding of the backlog is that we just haven't devoted enough resources to this. For many years, we only had 1 clinician in the entire state who was responsible for administering risk assessments. And I understand that there's been some additional hiring that I hope will help that backlog, but it's not an issue that we can easily solve based on eligibility.
Okay, thank you very much. I appreciate it. Thanks, Mr. Chairman.
Okay, we're going to go to Delegate Cham now and then Delegate Conaway.
Thank you, Chairman, and to Vice Chair and the committee, Delegate Crutchfield, for submitting this bill. My question is regarding juveniles who are currently in prison for committing egregious crimes and serving long sentences, and for those who have are now out of prison and serve their time. Does any data, credible data, exist that may tell us the family dynamics of these juveniles? Like, does it contribute to, I'm not suggesting that it does, but does it contribute to lack of family involvement, the father not in the home, they're raised in foster care, things of that nature? I'm just trying to get, what does the background of these juveniles look like regarding family involvement or not?
So it's my understanding, Delegate Cham, that usually as juveniles go in the DJS process, there's some point of intake where information like that is gathered, but most likely a lot of it is not available. And especially when you are out processing, you know, as you mentioned earlier, they may have actually get an opportunity to be out of prison, but that is probably unlikely in these situations. We're talking about most likely juveniles that are lifers, okay? And so with that in mind, there may, like I said before, there may not be data to indicate what their family structure was or what led them to be in a situation. And in most cases, as we've discussed earlier, these are not juveniles that have actually pulled the trigger. They are not the ones that, you know, actually did the deed, okay, actually, and they're there because of an underlying felony in which a loss of life occurred. If there are some other comments that any of the other presenters want to make, you are welcome to chime in. Mr. Wallington, I don't know if you have maybe some data, but that is my understanding from DJS, that data just probably is not there.
I would agree that it's not there, but that it is a qualitative study. I would love to see one day.
If I could respond, and I'm tempted to call on Judge Baer. I also have been a juvenile judge for many, many years. And I think it's pretty well recognized that the juveniles who are the highest risk for further serious criminal involvement tend to be those who have limited education. They dropped out of school, makes you higher risk, who have substance involvement, especially alcohol, even more than drugs, and who have a dysfunctional family in some way. that is not the same thing as saying that every dropout who drinks beer is likely to commit a felony murder. There are certainly cases with which I am familiar where a kid who is low risk, but is a teenager with poor judgment and immaturity gets involved with a bunch of folks or just gets all wound up in his or her emotions and commits a serious offense, sometimes from a high income family, sometimes even though they were doing well in school. But the largest percentage, the reason that the high risk term is created to go with these facts is because it's more common to have kids involved who are school dropouts, who don't have good parental supervision, and who are involved with substance abuse, especially alcohol.
Mr. Chairman, may I follow up with that? There is a study, it doesn't speak directly to this, but there was a study called The Right Investment that looked at each neighborhood in Baltimore, and it looked at how much the justice system spent on each neighborhood to incarcerate folks in those neighborhoods. And what we saw, what the findings of the study saw was that those that come from neighborhoods that the county spends, the state spends the most on, also are, those are neighborhoods that when you look at indicators of a healthy neighborhood, they have the opportunities for the most investment. For example, when you look at Sandtown, Winchester, who the state spends the most money on incarcerating folks in those neighborhoods, when you look at the high school, they have the lowest high school graduation rates, the lowest job rates, the longest distances to and from work, the highest number of 911 calls. So when you start to look at the indicators of a healthy neighborhood, then you can really start to begin to kind of identify where investments are needed, to kind of keep, disrupt the trajectory of kids from those neighborhoods going into the system. So again, it's a very, I was hesitant to even respond to that because it's a great question, but it's a very complicated, multi-tiered answer. And I think it really deserves a broader, discussion on its own.
Okay. All right. We're going to Delegate Conaway next. Delegate Conaway.
Thank you, Mr. Chairman and committee. To Ms. Kamens, I think I said that correctly. You said even if a juvenile knows that they're potentially going to be involved with a bad situation, they will still participate. Where are you getting that data from?
Delegate Conway, that assertion is premised on recognition by the United States Supreme Court in the series of cases dealing with recognizing the differences between juveniles and adults. And so what I mean to convey by that is that the Supreme Court has recognized that the sentencing consideration of deterrence is much less effective on a juvenile than it is on an adult. So if you know that if you engage in this behavior and you can anticipate that potentially a killing is going to occur committed by somebody else, completely unintended or unanticipated by yourself, but if you can contemplate that a killing might arise, even if you know that, by definition, a child's brain doesn't pause and say, I better not engage in that behavior that several layers away may result in the loss of life. It's simply not an effective phenomenon for a juvenile in the same way that it is for an adult. So it's not a knowing, I'm going to do it anyway. It's just this lack of connection.
Now, if you add that to what the judge was speaking on in the juvenile cases, so what happens if you're not addicted to a substance, you're not drinking, but you're just tired of being poor and broke in America? Have you thought about that? I mean, everything is always about a substance or something. You're just tired of being poor, broke in America. You've evaluated the situation. You believe that you're getting the wrong type of education or not an equal education, and you want a moped. You want some nice clothes. You want a car. So then you take action and you take things into your own hands. What about that? Do we have any thoughts on that?
Oh, so many thoughts on that. so many thoughts on that. And so what I would say is that I think it's a great point that you're making, because there are so many motivations for committing in a variety of felonies, the underlying felonies that can support a conviction for felony murder. So let's take your example. You want some nice clothes, you do a stick up. You do a stick up robbery on the street because you want some money, or you want your victim's watch because it's, you know, shiny and pretty. The point of this is that you are absolutely guilty of the felony of robbery. You have the intent to commit a robbery, but you do not intend that perhaps your co-defendant is going to get a little impatient with how long it's taking for your victim to take that watch off his wrist and hand it over, and he pops him. You did not intend for that killing to occur.
Don't forget the other side. The person who you're robbing, they do what we call in the city, it's called to buck, and they buck you. So then you have a choice. I just don't believe you're going to shoot me. And then you have to make them a believer, or you have to run.
Well, that's absolutely true. But what we're talking about, Douglas Conaway, is when you do not intend for a killing to take place. You didn't do it yourself. You didn't bring a gun to that robbery.
Right.
You did not intend to have anybody bring a gun to that robbery, much less use it. So
Okay.
if that happens, you know, felony murder doesn't absolve a person of guilt in any way for that felony. It's just that your intent to commit the felony under the felony murder doctrine it's sort of borrowed to establish the malice for the murder. There's a better word than borrowed, but it's sort of like extracted from the intent to commit the felony, and it plugs in what ordinarily would be for premeditated murder, that it's a murder committed by malice. Suddenly there's malice for a murder when all you did was intend to commit a felony. You're going to get nailed for that felony. You're going to get the conviction for that felony. And if you did intend to shoot the victim, let's say you intended or you incited your co-defendant to shoot, then you can be convicted of conspiracy to murder. You can be convicted of being an accessory to the first-degree murder. But what we're saying is you can't be convicted of a murder that you did not intend to happen. And you didn't even foresee it.
That's good. Thank you. Thank you very much.
Chairman Clevenger, you're muted.
I thought I unmuted and then there we go. Great. First, I'm looking to see if there are any other questions in the chat for this panel. I don't see any more. I'm going to ask a couple quick ones and get on to the next panel. And it goes to the comments that were just made. So if there are two young people who go and they plan to commit an armed robbery, and the one shows the other that they're carrying a firearm, and then they go off to engage in the armed robbery, and then that turns into a murder. That the person who was carrying the handgun shoots the victim of that crime. First, you could still make the argument that there is a conspiracy there, correct? So that would still be a conspiracy to commit murder, correct?
That is correct.
Okay.
It certainly could be.
All right. And obviously these are fact specific, and I think that's where the challenge comes into play with the felony murder rule, and that is you kind of go from that to what happened in Baltimore County, where the police officer was killed by the young man in the moving truck, whose friends were inside burglarizing the house. He was clearly part of the burglary, but then he was part of the burglary, but then he committed the murder. They were inside committing the burglary. And I think that becomes the question, and any words in Delegate Crutchfield's mouth, but in our discussions about this, that has been the the issue that has caused the most the most concern as to the culpability of the people who are inside the house at that point. And I understand that. Let me go in a slightly different direction, though. What I have heard in the testimony today is that there is a clear distinction between a child whose brain is not fully developed and is, in some cases, with the brain science that we have, is sometimes makes decisions that they don't that are at times not well reasoned. There would be a clear distinction between a juvenile who's being charged with felony murder and an adult who's being charged with felony murder, who would conceivably have a greater grasp and certainly a stronger grasp on the effects of their actions in this kind of scenario. Any of you can answer. Delegate Conway, you've turned your camera down to see your desk. There you go. But Delegate, you're fine. Mr. Karoum, you're okay, Delegate Conway. Judge Karoum, go ahead.
So I would comment that neurological studies suggest that brain maturity isn't really reached until age 25, but this bill is only looking for those who were involved in the offense under the age of 18, even more immature. On the issue of juvenile, awareness of foreseeability of their consequences, I would just point out the Center of Disease Control statistics to show that the top cause of death and serious injury of all children in that they study is accidents, which translates into stupid judgment. I should not have ridden the bike, into the intersection. I should not have done this or that. And it transfers to the same thing when a juvenile is involved in committing an offense. They may have thought they were committing an offense and they would just get some money or some property or whatever they thought. And they just don't foresee all of the consequences. It's really the same phenomenon as what I would add to Delegate Conaway.
So, but again, just to come back to my maybe inartfully worded question, there is a clear distinction between a child who is conceivably involved in a felony murder and an adult who is involved in a felony murder.
Under this bill.
Well, I'm going beyond the scope of the bill here a little bit. What I have heard in the testimony here today is that there is a clear distinction, and I know Delegate Crutchfield's and if Delegate, if you want to answer that, obviously perfectly fine. But I think there's a clear distinction in judgment, impulse control between a juvenile and an adult. And I guess I'm trying to, again, I understand what the bill does, and I understand that it's focused on juveniles 100%. I'm just kind of trying to further illuminate that distinction that we're talking about kids here and we're not talking about adults.
That is correct. We are definitely talking about kids. And if any of the presenters have any further data on specifically children and what the chair is mentioning, please feel free to chime in on that.
What I will say, and I will defer, really anybody on the panel is more than equipped to respond to your statement, but what you were saying is correct. There is a neurological difference in frontal lobe development, and that's about all I can expound upon when it comes to the science. The Supreme Court has embraced this neurological science about the delay in frontal lobe development, which is the part of the brain that addresses or encompasses impulsivity, reckless behavior, the ability to form reasoned judgments and anticipate risks and consequences. So there is no question that what you are saying is accurate. Anybody else would like to take that a step further or elaborate?
If no one else would, I just then one last question. Just sure I've got the sum and substance of the bill, it seems to me, is that if a juvenile were charged with felony murder, convicted of felony murder, this would just lower the standard, the penalty for and the crime for which they could be committed from first-degree murder to second-degree murder. So it's not like they're not able to be convicted of some form of murder. It is just that they would be able to be convicted of second. They would come down from first to second.
Correct. They would no longer have that first-degree penalty of life in front of them.
Got it. Delegate Arakan has a second bite of the apple question. Delegate Cox after that. And then Delegate Conway, I believe, is waving his hand. So we'll go Arakan, Cox, Conway, and then I think we're going to move on to the next panel.
Thanks, Mr. Chair. Some of your questions just drew up a few more questions about the brain development. So the goal is to get them, instead of the first-degree murder charged, down to the second degree. Are they still going to be charged as adults, or are we looking at now juvenile charges? What is the goal here? Do we not want people to be charged as adults anymore, or whoever can answer?
Well, Delegate Arakan, you bring up a really interesting thing. I do have a bill coming up.
On the bill.
On the bill. Okay, so
what we are saying is you're going to get charged with what it is that you should be convicted for. Okay. If it's that felony, that burglary, that's what you get convicted for. Okay. Versus being in the room and now getting charged with felony murder. Okay.
Right. So I'm trying to combine the two concepts. So if our goal then is to make sure you're charged with what you want, then we decide, because of brain development, you really shouldn't be charged as the adult. Let's do a juvenile. Then they're out by 21, which is before the brain is finished developing at 25.
No, we're not. Okay. So totally eliminate the charge as an adult. Let's just talk about what it is you want to talk about, which is murder. Okay. If the juvenile is charged with murder, we're saying that conviction can only carry up to 40 years instead of what it currently carries, which is a life sentence. Second-degree murder is a conviction of 40 years, and that's what we're saying. Okay. So
it's not automatic. The judge, it's discretionary.
Well, no. If you're convicted of felony murder, you are convicted as a first-degree murderer, even though right.
Okay, so the second-degree murder charge is up to 40.
Correct.
Right.
Correct.
Okay. And then if that's only if they're charged as an adult. If they're charged as a juvenile,
no,
it doesn't work like that.
No. It doesn't matter. Felony murder.
Oh, it doesn't matter.
Felony murder. Felony murder is felony murder. Okay.
Even if it's second degree. So there's a second degree felony murder now.
No, there is not.
No. Yeah. So our goal is to get from the first degree felony murder over to people being charged with a second degree murder instead.
So what it is again, if you are convicted of felony murder, the sentence that you will be, if you are convicted, you will be given is a life sentence. That is it. So what we're saying here is that no longer should that be what automatically happens. Felony murder will be wiped out for juveniles. That means that they would only be eligible for a conviction that would fall under the highest term of 40 years.
Okay. All right. I think
Can I just add one statement?
Please do.
Just to clarify, the juvenile that we're talking about can still be convicted of premeditated murder, can still be convicted of first-degree murder under this bill when it's appropriate, when the state establishes that it was an intentional killing or premeditated and deliberate killing as defined under the first-degree murder statute. They can also be convicted even if they're not the person that, say, pulled the trigger in the fancy watch robbery scenario. They can still be convicted under an accomplice theory of first-degree premeditated murder. They can also be convicted of the felony. They can be convicted of conspiracy to commit murder, which does carry a life sentence as well. And then they can get consecutive life sentences. This bill simply eliminates a juvenile being convicted of a murder committed by somebody else that person didn't know was going to happen and could not reasonably have anticipated was going to happen. So it's just cutting into a little portion of the overall law. It is not eliminating murder or first-degree murder in any way, shape, or form for a child.
Okay. Okay. All right. Thank you very much. Thank you, Mr. Chair, for indulging me.
No, that's fine. And I won't get into the charging a child as an adult anymore, because I feel like we'd be muddying the waters even more. And we will be hearing bills related to that later on in session that may help make that piece of the puzzle clearer. Let's go to Delegate Cox, and then I think we're going to move on. Delegate Cox.
Thank you, Mr. Chairman, and Delegate Crutchfield. Appreciate the opportunity to just ask a real quick clarity question. I heard it mentioned that the history of this goes back to, I guess, Old English common law, and I pulled out an old Blackstone I have, and it seems that the felony murder in that context was if someone was trying to shoot, I think they describe it as shooting subject A, but misses and hits subject B, who they had no intent to kill, that would be felony murder. It transposes because the actus reus, or the act was to commit the murder. That seems different to me than if you're committing a felony, say burglary, as in the case in Baltimore, and someone else, unbeknownst to you, so you have no knowledge that they had any intent to murder, commits a murder. And I'm trying to understand, is there clarity in that? And my question, I guess, about this particular bill is, what would this potentially need an amendment or something to make sure that if an individual, if a juvenile, for instance, intended to kill subject A but did kill subject B, that they could therefore, if this were to pass, get off of any felony murder at that point? And then the flip side of the coin as well, what's the clarity? Why can someone presently be argued? Because I looked at the statute, it looks like it says the person has to actually commit the act. I don't understand how someone who's not involved in the act of murder could be charged with felony murder in that context, and if you know, or anyone else.
Delegate Judge Karoum has raised his hand. If you want to defer to him, or if you wish to answer the question, go right ahead.
Thank you.
No, I'd like to defer to Judge Karoum.
Judge Karoum.
So the doctrine you're describing from that Black's definition is actually one which I would call transferred intent. And transferred intent is really kind of separate from a felony murder. It could also get involved depending on the facts of a case, but in essence, one could get convicted of first-degree premeditated murder if one is, deliberately shooting at person A and kills person B. But by the same token, as we described in a felony murder situation, suppose you don't intend to kill anyone, but in the course of the getaway from the place that was robbed, you run someone over. Again, that accidental death, unintended, can still be the felony murder. Or if you intended to run over the police officer and instead you run over a pedestrian, there could be transferred intent in different ways. So I would suggest to you that particular definition in Black's is a little misleading, and I would be happy to send you, and I suspect some other folks, advocates, would be happy to send you more extensive definitions of what felony murder is as it is applied in Maryland.
So if I could clarify my question, Mr. Chair, real briefly.
Go ahead.
So if a juvenile is intending a crime, a felony, and the act that juvenile commits actually causes murder, unintended, but they can be charged with murder, felony murder now, would this bill excuse that? And then I guess on the flip side of that, if, as you were just saying, it seems a little bit of a stretch, and I don't understand why the statute is not strictly construed to say that they cannot be charged with felony murder if their accomplice committed the murder and they had no knowledge beforehand, no malice of aforethought that that was going to occur. So that's the two-sided coin that I'm not quite understanding how this bill will address that. And maybe it's for another time if it's too much, but thanks so much.
Professor Meadows has taken herself off mute. Go ahead.
Yes.
Yeah, if I could just address it briefly, Delegate Cox. So the way the statute is constricted is, I think a good way to think about it is strict liability. Basically, what the first degree murder statute says is if a murder is convicted in the course, the act that matters is your participation in one of the enumerated underlying felonies. For the purpose of felony murder, that's the act we care about, the act of robbery, the act of burglary. That act alone is enough. That if your co-defendant kills someone in the course of that robbery, that's enough for you to be held liable for the murder as well. Strict liability, concept from tort law that we've imparted into our criminal law in a scenario that holds, as Ms. Kamens mentioned, sort of the highest possible penalty, mandatory sentence in the state of Maryland. And that's what makes this, I think, a particular injustice as applied to children.
Okay, I think we have taken care of this first panel pretty good. That's fine. And we're going to move on to our second panel. Thank you to the first panel. And if we could move them from the Zoom, and then we will ask to come in the second panel, Megan Coleman, Martina Hazelton, John Gianetti, Olinda Moyd, and James Dold. Then we will have the opponents to the bill. So these first five, the first five that I just, well, the five that I just listed are going to get 2 minutes each. Committee, we will definitely take a break after this bill. All right, is Megan Coleman, there's Megan Coleman. Megan Coleman, you have 2 minutes.
Yes. Good afternoon. Thank you, Chairman Klippinger and the committee. My name is Megan Coleman, and I've been practicing criminal defense for the last 12 years. I currently represent an African-American juvenile who was convicted of felony murder and sentenced to life imprisonment. I submitted written testimony in support of this bill. I submit that this bill is in line with the felony murder reforms that we have seen nationwide in other states. Currently, there are 18 states nationwide that no longer apply the traditional felony murder doctrine that we have in Maryland to adults, let alone to juveniles. Even the Supreme Court, in the case Miller versus Alabama, has questioned the legitimacy of holding a juvenile responsible for felony murder, noting if the theory of transferring intent for felony murder is that one engaged in a dangerous felony should understand the risk of death, this cannot be reconciled with what we, the courts, know about a juvenile's lack of capacity to foresee consequences and to adjust one's conduct accordingly. The Supreme Court further determined in Graham versus Florida that a juvenile offender who did not kill or intend to kill has twice diminished moral culpability than an adult offender, yet the juvenile faces the same life sentence and will serve more years overall. Chairman Klippinger, you had asked about the clear distinction between adults and children when it comes to the crime of felony murder. And I would refer you and the committee to my written testimony where I was able to more fully elaborate on those distinctions. But when you look to Miller versus Alabama, Roper versus Simmons, and Graham versus Florida, those distinctions are clearly laid out over and over and over. And the support in the court's opinions come from scientific findings, psychologists, neuropsychologists, and people who have studied juveniles, their behavior, whether deterrence works when it comes to having a felony murder doctrine for juveniles. I would submit that House Bill 385 recognizes the shortcomings of felony murder that other states have recognized, and especially when applied to juveniles. But it still continues to hold the juvenile accountable for the loss of a life in a meaningful way, hopefully for the victims' families. And therefore, I urge a favorable report, and thank you for allowing me to testify today.
Thank you very much. Thank you. Martina Hazelton?
I am here.
Great, thank you very much.
Thank you so much. And thank you, Delegate Crutchfield, for bringing this piece of legislation forward. I want to give testimony from a personal experience. I am a co-founder of Family Support Network, which is a network of families who have incarcerated loved ones throughout the state of Maryland. I myself have a loved one who is in the state of Maryland and has been incarcerated on February 20th, will be 28 years, and he was convicted of felony murder. So there has been a lot of discussion about the critical and intricate parts of how this will all work out, but I would like to provide a practical example of what this actually looks like. There were 4 other juveniles along with my loved one, so a total of 5 who were all involved in an offense, and to which there was a loss of life. And they were all charged with felony murder. And as in previous testimony, you have heard that that was in an attempt in order to get people to plead out. In one specific case, there was the one defendant who did decide that they were going to turn state's evidence and to which testify against the other 4 people. Of the other 4 people, they were all convicted of first-degree murder and the underlying felonies that went along with that. So there was a stacked sentences in most cases. My loved one went to trial first and was convicted of 2 life sentences and was sentenced to 2 life sentences plus 53 years. And the other ones received more extreme sentences than even that. To date, one of them unfortunately passed away while incarcerated, so that not left 3 people, of which, again, there was only one specific person who committed the crime that resulted in someone losing their life, and there were 3 people who now are serving sentences. The person who was the primary actually was released on December 17th of 2020, and my loved one and also the other person who also decided to take a plea and was given life sentences, but he is still in prison. So together they have all served over 100 years. So this is the practical application of what we're talking about. There was one person.
Thank you. I feel confident that the committee, as you noted in the previous panel, they are not shy about asking questions. I feel confident, Ms. Hazelton, they will ask you further questions about what happened in those cases. But thank you very much for the moment. Thank you. Mr. Giannetti. You're muted, Mr. Giannetti.
Am I here?
There you go.
There I am. Thank you very much, Mr. Chairman, members of the committee. It's an honor to be before you. I'm here to urge your positive report out for House Bill 385. You know, this is, I'm bringing up the rear for the Maryland Criminal Defense Attorneys Association. This is our #1 legislative priority, getting some changes in the felony murder bill. And, you know, I think that as public policy, I'm going to be speaking about it prospectively. You know, this bill has 2 different sections, one dealing with the retroactive of those people currently in jail right now for felony murder, but also, you know, as a group, public policy wise, I'm urging you, you know, to deal with this backlog of offenders that we have. Not only are there racial disparities, it brings in a racial justice inequality, but also, you know, we have 3 different approaches. I think the chairman's approach to deal with it in House Bill 3 to deal with it from the parole perspective. We got to fix parole, everyone's sitting in jail. There's also another bill coming up right after this, House Bill 409, Jazz Lewis, hey, we're going to allow for a second look for juveniles now. Okay, great. Well, I'm going to urge you to do a tripartite approach to this and to say, listen, we're going to deal with the parole part, we're going to deal with the resentencing part and a reconsideration, but also let's look at the prosecution of these crimes and to stop the stream of people, you know, who we don't want sitting in jails for their lives. Say, listen, we're just not going to allow prosecution of juveniles for felony murder. You know, there's all sorts of questions about the felony murder statute. Last year we had in a bill to totally get rid of it. We love Delegate Crutchfield's bill. We're commending her for what she's doing, and it makes a lot of sense. It makes an incremental step in the right direction where we're going to fight this from the parole perspective, reconsideration perspective, but also from the perspective of we're not going to give this tool to prosecutors for this transferred intent based on their juvenile foreseeability of these crimes. Thank you very much.
Okay, we're going to go now to Olinda Moyd.
Hello, my name is Olinda Moyd. Thank you, Chairman Clippinger and other members of the committee. I am a member of the Maryland Alliance for Justice Reform. You've already heard from Judge Karoom, and so I just want to make a few points regarding this legislation in which we urge you to present a favorable report. One thing I'd like to highlight that has not been brought up before. I know we've talked about the impact that the felony murder doctrine has on juveniles. It also has a significant impact on women. And so when we talk to women who are behind bars in Maryland and throughout the country, we see that many of them are sitting in jail pursuant to the felony murder doctrine. And I know that the Department of Corrections does not sort out sentences, and so we're not able to know what the exact numbers are in the state of Maryland. But when we look at the estimates from other jurisdictions, somewhere around 72% of women sentenced under the felony murder doctrine did not commit the killing themselves. And the same is true with juveniles. We know that in many cases, they were not the principal. They were not the mastermind behind the crime. Very often, they were the person who was coaxed into going along, serving as the decoy or being a distraction when the offense was committed. And so we urge you to take that into consideration as you are reviewing this bill. The last point I would like to make, a point that was raised by Mr. Giannetti, and that is a second part of this bill is to allow people who are sitting in jail who've been sentenced under the felony murder doctrine to have an opportunity to review. So what we've done in the state of Maryland, as we've seen done throughout the country, is it's very easy for someone to get involved in the system, to go to jail, to sit behind bars for decades. The gate is wide open. But when we look at the opportunities for a person to exit the system, the door is very narrow. It's just cracked open. And so one thing that this bill does do is allow for individuals to file a motion for review. And so we ask that you support this bill.
Thank you. Thank you very much.
Thank you.
Mr. Dold, James Dold.
Thank you so much, Mr. Chairman. James Dold for the record. I'm representing Human Rights for Kids, an organization I'm the CEO and founder of. I'm also a human rights abuser myself. Last year, we actually published a national state ratings report ranking all of the states on how well or how poorly they were protecting the human rights of kids in the justice system based on 12 categories of law, including the elimination of the felony murder doctrine for children. It's important to note that Maryland ranked last in the nation when it comes to protecting the human rights of children in the justice system. It was at the bottom of the list alongside states like Georgia and Alabama. On the other side of that, just for context, the best states in the nation, some people might be surprised about this, were California, North Dakota, and Arkansas, which I think highlights the broad bipartisan support which these issues have generated over the last several years. So for those reasons, we would really urge this committee to act favorably on House Bill 385 to make sure that children are not eligible to be sentenced and convicted under the felony murder doctrine. California passed similar legislation in 2018. Over between 400 and 800 people were eligible for resentencing under legislation just like this. The system was completely able to handle it, and it gave children the opportunity to demonstrate that they were more than the worst thing that they had ever done. I also just want to point out real quickly the fact that most of the kids in the justice system, and the reason why we frame this issue through a human rights lens, is that most of these kids have experienced severe amounts of adverse childhood experiences and early childhood trauma, which is why they ended up in the justice system to begin with. A DOJ-funded study during the Obama administration found that 90% of kids in the justice system had experienced at least 2 adverse childhood experiences, and 50% had experienced at least 4. And that's everything from physical and sexual abuse to neglect, to having a parent who is incarcerated. So we are talking about children who have experienced severe amounts of trauma and harm, which is why they end up in the justice system to begin with. I'll lastly just note that our organization has 11 state current or former state legislators, including the great Delegate Dana Stein, who I'm sure many folks are familiar with, who serve on our board of directors. We have 6 Republicans, 5 Democrats, all united from states around the country who are pushing for reforms in line with international human rights principles that are found in the ICCPR, as well as the UN Convention on the Rights of the Children, which categorically prohibit children from being sentenced by the same standards as adults, which is what's currently happening with the felony murder doctrine in Maryland. We plan to release another report in the summer of 2021, highlighting which states are continuing the human rights of children. So we would urge this committee to pass House Bill 385 and bring Maryland into compliance with those human rights standards. Thank you.
Thank you very much. Are there questions for this panel? Okay, it doesn't appear that there are questions for this panel. Seeing none, okay, we're going to have to keep moving then. Thank you all very much for your time. And particularly thank you to Ms. Hazelton for telling the story of the people who the people she raised in her testimony today. All right, with that, we are going to go to the opponents of the bill. There are 3 who are signed up to testify: Joe Riley, Edward Coyne, and Vince McAvoy. We will go to Mr. Riley first. If he's just coming into the room, we'll give him a second here. Hold on. All right, Mr. Riley is going to be first, followed by Mr. Coyne, then Mr. McAvoy. There'll be 2 minutes for each. Go first. Go ahead, Mr. Riley. There you go.
Thank you, Chair Clevenger. My name is Joe Riley. I'm the state's attorney in Caroline County and the chair of the Maryland States Attorneys Association Legislative Committee. We are seeking an unfavorable report on House Bill 385. In Caroline County, we had a case that proceeded on a felony first-degree murder theory in 2015. Trayvon Farrow was killed by a single gunshot wound to the chest at the age of 23. In the house was his pregnant wife and 2 stepchildren. The defendant, William Willis, at the time of the murder was a juvenile. Willis was found guilty of first-degree murder, felony murder, after a not guilty agreed statement of facts was read into the record. Written pages detailed how Willis obtained or found a 12-gauge shotgun, stole ammunition, sold the gun and ammunition to the eventual shooter of Mr. Farrow, planned the robbery of Mr. Farrow, whom he suspected possessed marijuana, cash, and was unlikely to contact police if he was robbed. One of the few individuals who had knowledge of Mr. Farrow's hidden console in his residence where he kept items, provided the masks that were used for the robbery, participated in the robbery where Mr. Farrow was murdered, and later approached Mr. Farrow's widow on the street asking what occurred while knowing exactly what had occurred and who was responsible. Willis was found guilty and sentenced to life suspending all but 25 years active by Judge Karen Murphy Jensen. I think it's important to stress because I heard the proponents talk about the life sentence. Life suspend all but 25, so it's not always life and life sentence. If House Bill 385 were law at the time, the most Mr. Willis could be charged with is the home invasion in the case. That would start in the juvenile court. He could not be charged as an adult for home invasion. This would not be a just result of the surviving members of Mr. Farrow's family. Also, 385 contains a look-back provision that would vacate the first-degree murder conviction and would force the state, in my case, to attempt to prove second-degree murder and limit the state to presenting the 4-page document that was read into the record. It's my belief as well that this bill would allow the state to prove second-degree murder by clear and convincing evidence. All of the defense attorneys that were arguing for this bill would immediately be arguing that that is unconstitutional. If a crime as serious as a homicide needs to be retried, it is not justice to handcuff the state to a case on the record. The family of Trayvon Farrow should not have to face the possibility that the conviction should be vacated and retried in such a haphazard manner. My office is joining the Maryland States Attorneys Association seeking an unfavorable report.
Mr. Riley, to Mr. Coyne.
Good morning, good afternoon, Mr. Chairman, members of the committee. I'm also testifying for the committee on behalf of the Maryland States Attorneys Association. I'm the Deputy State's Attorney for Carroll County, and I agree with Mr. Riley that we're requesting an unfavorable report of House Bill 385. This first-degree felony murder presupposes that they've committed, the juveniles or adults have committed a violent felony. things that cause a danger to one's life or limb inherently. And so the implied malice is carried over because if you're participating in a violent felony, you know that it's a danger to life and limb. We're talking about rape, arson. Notice that the proponents didn't mention the actual underlying crimes. These aren't felony thefts or stealing a car. Arson, rape, carjacking, serious home invasion, burglaries. And the current law does allow for deterrence. It deters behavior to engage in these kinds of behavior that are such inherent risks to life and limb of victims, the victims here. And I would suggest that we had a case in Carroll County that oftentimes it's difficult to determine who the principal, who the actual hand, which defendant's hand caused the death. We had a home invasion burglary where two men broke into a home of a victim. The victim was stabbed. Each offender pointed the finger at each other. He did it, he did. I was there and I broke in, but he did it. The other one, I was there, but he did it. So this felony murder allows to hold both offenders accountable, because sometimes the only persons who know who the actual principal killer are the deceased victim and the two offenders. And oftentimes, I know it'd be a big shock that they're not honest about who the actual principal offender was, whose hand killed the victim. This offense holds people accountable. About 10 years ago, that case happened in Carroll County, and both were held accountable. And I would suggest that there are cases where it's difficult to determine because the only persons present are the offenders and the deceased victim, that you're never going to know who the principal offender is. And this holds all persons accountable. And I agree with State's Attorney Riley that it's been mischaracterized what judges can do. Judges have full discretion on these cases. And as the written testimony from State's Attorney Rich Gibson from Howard County says, a judge could do a life suspend all but time served if justice determined it. Judges have the unique ability to consider the individual circumstances of the case, which are the facts, the person's role, the individual circumstances about brain development. Was the person on an IEP? Do they have psychological problems, substance use problems, all individual characteristics? And I would suggest let the judges do it. There's no mass incarceration if the judges do their job and uphold their sworn duty.
Mr. Coyne?
Yes, Your Honor.
Well, okay. But the chairman's fine. But thank you. We have to, if you want to wrap up quickly, that's fine. Oh, you muted yourself.
Sorry about that. I concur with State's Attorney Riley about this would unnecessarily re-traumatize the victims as well by having them go through these review hearings. They're never going to get closure because now it's being regurgitated. Defendants have more than a dozen ways to get a conviction reviewed, and now this is an additional way to drag the victims and re-traumatize them through the process. Thank you.
Okay, thank you very much. Mr. McAvoy for 2 minutes.
Thank you so much, committee. I want to say that the last State's Attorney just detailed many of my points, so I'm just going to try and chop through what I have left that he did not mention, because what I bolded out was burglary, carjacking, kidnapping, rape, robbery, sexual offense, sodomy. All these things will be underlined, but I guess if you read the code there about how you got to the first degree in the first place, this is premeditated. These are violent issues. These are people that need to pay that consequence. And as I so often testify, this is not just the text of the bill, it is actually how it will be enacted through our system. And as a for instance, look at what Senator Hoff has pointed out in the past, look at testimony where he's mentioned second degree murder serving longer than first degree. So when you see where the rubber hits the road, what the previous State's Attorney said is very true. I would also point out that over in JPR, they listened to the numerous long lines of victims for various matters, parole, increases, decreases of DIMMYs and the rest. And I didn't listen to, I was in JPR for a little bit. I didn't listen to everything, but you know what? I heard a lot of excuses about child brain development. I heard about they didn't know what they're doing, but they knew it was wrong. If they got the first degree, the judge is satisfied. They very much knew it was wrong and a life was taken. I haven't heard anyone talk about the life. I mean, maybe I missed it, but I didn't hear anybody say there was a murder. We're making excuses on this issue. And the fact is that the judges have latitude, and where the rubber hits the road, just check with Senator Hoff. He was working on sentencing with Bobby Zirkin. these people are not always spending all that time in jail. I don't know the details, I'm sorry, but look at his previous testimony, and I thank you for listening.
All right, thank you very much. Questions for the opposition? Delegate Shetty to begin.
Thank you, Mr. Chairman, and thank you to those who have testified today. I am curious, Mr. Coyne, this question is for you. I'm very sensitive about this argument that we hear frequently on this set of bills around the trauma that is being inflicted upon victims. And I'm just curious if you can expand a little bit by sharing, are victims compelled to participate? Are there different ways they can participate in like a parole review or a sentencing review? Can they submit a statement via writing if that is something that they want to get in the record so that they're not participating in person?
Thank you, Delegate, for the question. I appreciate it. Yes, they can participate in numerous ways. However, remember, this review hearing can bring up cases that could be 15, 20 years ago. So every time a case gets this far, that's been a conviction, they've had the motions hearing before court, oftentimes to transfer back to juvenile. They've had a motions hearing to suppress evidence. They've had a trial. They've had a sentencing. They've had a possibly an appeal, a 3-judge panel review. They potentially had a post-conviction. There's about 13 of them. State's Attorney Schellenberger detailed in his letter, I think, opposing this legislation. And I would suggest every time it's not the fact that they have to physically be somewhere, but they're re-traumatized by they're reliving the loss of their loved ones. So the details of when they got that call and said your relative has been murdered. It's bad enough if someone dies of a car accident or natural causes, but this is a violent way to end someone. You can only imagine the family of Officer Caprio when when her husband got notified that she had passed, or her relatives. And so every time a proceeding happens, it's traumatic for them. And this is one more opportunity to traumatize or re-traumatize the family of the victim in any means, whether they want to submit something in writing opposing a modification. And then here, it wouldn't even matter about what their statements are, the impact of them, because the court would be forced to transfer it back to second degree in spite of all the due process problems of evidentiary, anything else beyond a reasonable doubt, clear and convincing, those types of things. So it's not necessarily the physical or the practical way they're a part of the case. They're not forced to participate. Most do voluntarily. It's the substance and the re-traumatizing them about the topic and the feelings they had to go through again now because of this legislation.
All right, Delegate Juanita Fisher.
Thank you, Mr. Chair. Good afternoon, State's Attorney Riley. This question is for you. I mean, isn't it clear that you all can bring other charges, that you have the whole gamut of criminal charges to bring in any of these cases where there are juveniles doing any felony? You can charge them with anything that you feel like you have enough facts to support, correct? You look at me like you look confused.
As adults?
No, what you can bring up any charge that you would think would be appropriate, whether you can charge them as an adult or whether it would be for in the juvenile section.
I think the proponents of this bill were arguing that that they could be charged as adults, and that's not always the case. Sometimes the most that you could charge a person that would be substantiated by probable cause that you could possibly prove beyond a reasonable doubt would be a charge that would start in the juvenile court. Not only is something that's in the criminal court, but you can charge people with any charge that you have probable cause that you believe that you can prove beyond a reasonable doubt. You just can't throw a charge against someone because there's an allegation out there. That's unethical.
Right. I just wanted to clarify to the committee because I feel like in your testimony, it was sounding like if you didn't have this tool, like you have any other means to.
The facts in my case were very specific. The facts in my case, Mr. Be charged with anything more than home invasion under the facts that were presented to the court on that 4-page document, because there was nothing in that 4-page document that talked about premeditation to commit any homicide. So we wouldn't be allowed in this bill to present any of that information on premeditation. Because you're not going to talk about premeditation for first-degree murder when you're going on a felony murder theory, as you know, as a former prosecutor. You're not going to take the time to do that. And this bill limits you to the record that was done.
But I think the question for me,
guilty plea.
Yeah, and I was just building to my other question, State's Attorney Riley, is, and I do understand that, but I think there's the other question of, but is it really getting you to justice overall in our system for your one case that you're saying? And I would honestly have to review the case myself to really want to feel that way. And if you send it, I will totally do that.
Well, you can come over, come on over.
I will definitely do that. But I just, you know what I mean? It's like, I understand you're saying, and that could be true, that it could have prevented you to go forward on that. You would have only been already to go forward on lower charges. It might not have been charged as an adult. He may have been charged as a juvenile. But does us keeping this statute bring us to the point of overall justice? That's our job, versus your job is each case on the docket and where you're going to go, right? And
my job is to be an administrator of justice.
That's what I think we're trying to figure out. Is that one
administrator of
case
justice,
enough?
I look at each case by case and make a determination on each case by case. I don't make a blanket decision that I'm always going to charge juveniles with felony first-degree murder. You make a decision if the facts fit the case. In this particular case, Mr. Willis was clearly the mastermind of the crime. So this was appropriate. And not only that, his attorney had him plead guilty under a not guilty agreed statement of facts, which is essentially a guilty plea. So it was also something that the defense attorney agreed with as well.
Yeah, I guess my question, I think, will be throughout this year is if one case is really, or the one example is enough to justify the law still being on the books. And still, I think maybe the chairman can help me remember our witness's name from the proponent. She didn't finish her story, but is that enough that those two other boys are still sitting in our prison system now? That's really the question that I posed, but I'll hold there, Mr. Chair. I know you've indulged me.
All right, we're going to go to Delegate Crutchfield, then Delegate McComas.
So, Mr. Riley, I just want to make sure I understand, in your testimony. So to you, wouldn't you say is it appropriate then to charge a child with first-degree murder and convict them, but yet you're saying on the other side that you wouldn't charge them as an adult with an underlying felony? I want to make sure I'm understanding what you're saying.
No, I said you couldn't begin
to charge them for murder, but not appropriate. Go ahead.
In the home invasion, you could not begin in the adult jurisdiction. You would have to begin in the juvenile jurisdiction.
Right, but we're still talking about murder, but it's okay to...
You were talking about my particular case.
Okay, all right. So then you talked a little bit about the court's discretion. And I do know prosecutors have a little bit of, the ability to also talk to the judges about sentencing. So in felony murder cases, and I'm sure you've had several, have you ever sought to suspend a sentence for someone that you knew was not the principal involved in that felony murder?
The Willis case was life, suspend all but 25.
Okay, but did you seek that suspension?
That was the agreed suspension. That was the agreed.
Okay.
Correction. The prosecutor on that case was now Judge Jonathan Newell. I cannot state what he sought in that case.
Okay, but not just
talking by Judge Karen Murphy Jensen. I don't know if it was a free to argue sentence. I just don't want to mislead this panel.
But not just talking about that case in particular, because I know you've kind of horned in on that one, but I'm just talking generally. Do you ever seek anything different for that person that was not the actor, that did not actually commit it, but that was standing there and is charged with felony murder? Have you ever sought to do anything less than a life sentence?
I have not had the opportunity to prosecute a felony murder case for an adult or a juvenile as you're describing.
Okay. And do you have any information from your fellow colleagues as to what they would do or if they've done that?
I can tell you that I can tell you what the sentence was in Mr. Schellenberger from Baltimore County's case. That seemed to be the impetus for this bill. I don't know what he sought, but I would be surprised if he sought active on all of those cases. But I will ask him and get back to the committee, but I know that was not the sentence that they received.
Okay. All right. Thank you, Mr. Riley. I appreciate it.
You're welcome.
Thank you, Delegate McComas.
Thank you, Mr. Chair. This is for the state's attorneys. My question is, in other words, there are all the tools that the defense has at their disposal in a sentencing hearing. There's probably a pre-sentence investigation report. I assume they can call in psychologists or psychiatrists. They could call in the teachers if there needs to be there's an IEP. They can also have the child tested for their intellectual ability, like if there's borderline retarded or anything like that. They could bring in social worker that said, hey, this poor kid was beaten to a pulp as a child, has X amount of ACEs, adverse childhood experiences. So in other words, the defense can be very creative in a sentencing hearing. Is that fair to say?
It would almost be an immediate post-conviction victory for the person if they were not doing all of the things that the delegate suggested, in my opinion.
Okay. Then I guess the question is that a judge would, if a judge was persuaded by the defense's arguments, the judge would have the discretion to say, hey, I'm gonna give this kid only 10 years or whatever. Is that fair?
They could go all the way down to life completely suspended. Life suspending all the time served. They can do all of those things. This is not a mandatory sentence.
Okay. All right. Thank you, sir.
And that's
good for seconds.
Colleen, go ahead.
And that's both for adults and juveniles. The judges can and do consider all the individual circumstances, and adults also call experts as well. And if they have a mental illness, they call experts in the trial and the sentencing.
Oh, just a quick. If I may, sir, basically the public, I assume that a lot of these folks are going to be defended through the public defender's office. Is that fair to say? And is it also fair to say that the public defender's office, if it's a serious case, which these certainly are, they have the ability to hire and get experts in or have them on retainer through that office? Is that fair to say?
I'll take this one, Joe. I've had cases with both public defender and private. One of your prior panelists was a defense attorney in one of my cases. They had a mental health expert, one of the best in the state. They had a firearms expert because it wasn't a juvenile, but it was someone, I think under the age of 21. He was a young person. So they had all those types of experts. And so it's really resources. If they're not of means, they hire the public defender and they have access. If they're of means, they hire a private attorney. Yes, but both sides.
Okay. Thank you, sir. Thank you, Mr. Chair.
All right, are there further questions for this panel? I have a couple questions here, and then if depending on whether there are further questions, I think we will take a break after this, and we will start back up at 5:45. So let me ask a few questions, and then we'll shut down for a little bit. I guess I want to go to the part of the bill that starts on page 3 in section F, and it's the look back. I want to go to the standard, I guess the burden that has to be met. And you touched on this a little bit, and I will also ask the proponents of this offline, but I want to ask, since you raised this issue, and I think it's an important issue. In F1, it says that effectively the defense can file a motion for review of conviction, and then in F2, it says that if the court determines that the moving party has presented prima facie evidence to meet the requirements under paragraph 1, then the court holds a hearing limited to the record at trial, at which the state must establish by clear and convincing evidence that the moving party could be found guilty of murder. You touched briefly in your comments, I think, State's Attorney Riley, or you may have both done, but about the impact of that and sort of the constitutional questions regarding that. Could you talk about that a little bit more?
It's my reading of the bill, Chairman, thank you for the question, that that is clearly unconstitutional because you would be enacting a criminal sentence, a criminal penalty under second-degree murder, which is the statute that it quotes the statute number, but not the crime. It's second-degree murder, and you would be found guilty of that to a standard of clear and convincing evidence, which is clearly not constitutional, in my opinion.
So the question then becomes, if they wanted to somehow fix that, or address that constitutional issue, then I guess their option would be to require you to prove beyond a reasonable doubt that they would be convicted found guilty for murder in the first degree. Is that correct?
I think that is a way to fix it. Also, my problem is mainly with forcing the state to try a case that's important as a homicide, but handcuffing us with what we can use to prove our case. So if you're asking us to prove a case beyond a reasonable doubt and say you can only use the record, I don't know what case you can prove beyond a reasonable doubt just on a record of a case that was done however many years prior.
I guess the broader question is whether or not, I guess there becomes a question, at least in my mind, as to whether there is something that could be, this is something that could be looked at to go forward with and be prospective as opposed to looking backward. Because I wonder whether there isn't that constitutional, I believe there is a constitutional issue where you couldn't convict somebody of a standard beyond a reasonable doubt. So but I will be talking to the proponents of the bill to find out in their mind how you square that. I'm not entirely sure, and I do want to be fair here. I've waited to the end to ask this question. So with respect to Delegate Crutchfield and to the advocates, I will double back with them as well. But I do think there is that issue. I mean, the underlying point here, the bigger picture is in the first half of the bill, though, that it would effectively, it would lower the penalty, or it would lower the penalty. It would lower the conviction from a first degree murder to a second degree murder. And I guess I'd like you to respond to, I think there are stories all, there's a story, that you could have the child who's the getaway driver who is 16 and is driving the person away from robbing a bank, and they shoot a person who's inside robbing the bank. Now, I guess you can argue that if they knew they were there to, if you could prove the connection that they were there, the armed robbery, then you could show that you could argue that there was a conspiracy perhaps to commit murder, but that might be difficult. That might be difficult to prove. I guess where in my mind the challenge lies is there are some situations where a juvenile, either because of brain development, they act impulsively, something happens where they are not at the heart of the murder, but they are in effectively the wrong place at the wrong time. And I'm wondering where that line is. And again, it's prosecutorial discretion, and I hear that. And I also know, I mean, what was repeated in the previous, in the proponent side, that you can, you're going to get sentenced to life, and that's just the sentence. It's life. It's almost always life suspend all but something. But it's that fuzzy line that I struggle with. And can you speak to that a little bit?
I think I can a little bit, because one of the things that this bill, one of the reasons that we're of this bill is, again, the limitation to the record. You're talking about a conspiracy. The state's not going to have the opportunity to produce evidence of the agreement that they never charged in the first place.
But I'm not looking retrospectively. I'm talking about going, I'm talking about setting aside the look back that's in the second half of the bill. I'm talking about just going forward. Where is that line?
So you're asking, what are we losing going forward? Is there still a possibility of having? I would assume that there is a universe of cases that could fit your set of facts, that a automatic adult charge could exist on conspiracy to commit first-degree premeditated murder or conspiracy to commit second-degree murder. My understanding of the proponents of this bill, though, they aren't asking for the state to come up with a new way to prosecute juveniles as adults. The impetus of this bill is to stop the practice entirely. So if the state was going to do what you suggest, I think your very next session, there would be a bill that says we can't do that, in my opinion.
Okay. All right. Are there further questions for this panel? All right. Seeing none, then we will stop it right there. This is that'll conclude the testimony on House Bill 385, Delegate Crutchfield's bill, and I appreciate everyone's patience as we work through the first of our longer bills today. Now, committee, here's where we are. There are 39 people testified to speak on House Bill 409. It is a 3 and 2, so the sponsor is going to be able to get 3 minutes. The witnesses are going to get 2. What we're going to do is we're going to have a break until 5:45 to give people the opportunity to get up, to walk around, to maybe eat something, to come back. And then we will begin the testimony with Delegate Lewis at 5:45. Members of the committee should leave the Zoom open. You're going to see right here what Dylan is about to put on the screen. You should mute yourselves. Let me underline, make sure you are muted for the next 45 minutes because we will still be on the air. We will still be recording. We will still, people will be able to hear and see you. Please mute yourselves. All right. With that, we will go into a recess for 45 minutes to 5:45. Thank you all very much. And I should have said it's okay to turn off your video during this time.
Where you at, Carton? You on a ski slope somewhere? Look kind of cold there, buddy.
Hey, Ron, we're being recorded.
Sorry about that.
Leadership. We have a number of committee leaders with us tonight.
Okay, I think we're about to start up here again. I'm looking for Delegate Lewis.
He's not in the waiting room just yet, but I'll shoot him a message.
Okay, thank you. Committee, we are waiting for Delegate Jazz Lewis. As the committee knows, people from appropriations apparently sometimes are late. Oh, wait, there he is.
Alrighty.
All right. We are waiting for Delegate. All right, we're going to begin. This is again the House Judiciary Committee. This is 21st of January. It is about 10 minutes to 6, and we're going to begin our final bill of the evening, and this is, of the day, I should say. This is a bill from Delegate Jazz Lewis, House Bill 409. He's going to speak for 3 minutes. His witnesses will speak for 2. I want to emphasize the speaking for 2 part. They will be Gary, this is Judge Bear again, Paul LaRuffa, Eddie Ellis, and State's Attorneys Braveboy and Mosby. I'm going to do the best I can. Going to speak for 3 minutes. His witnesses. And somebody needs, there we go. And we're going to do the best we can to keep it under 2 minutes. To give everyone the opportunity to speak and to be heard today. Don't mean to totally make light of it, but there are the max number of people who can sign up in favor, signed up to speak orally, and then we have a favorable with amendment, and we have a couple in opposition. So with that, Delegate Jazz Lewis, for 3 minutes, please.
Committee Chair, Vice Chair, and members of the Judiciary Committee, thanks for having me. I come in support of House Bill 409. The Juvenile Restoration Act of 2021 would permit a person convicted of a crime committed while the person was under 18 to file a motion for a sentence reduction. Following a judicial hearing, the court has the option of reducing the sentence if the person has been imprisoned for at least 20 years, is not a danger to the public, and a sentence reduction serves the interests of justice. To be clear, this is not an entitlement. but an opportunity at making our system more just. In states that have already passed this measure, many who qualify are denied because the court deems them not ready. But there is an aggregate recidivism rate of less than 1% for those released. This legislation will bring Maryland into compliance with a recent U.S. Supreme Court decision and ban life without parole sentences for children. In September, I sent a public information request to the Department of Corrections or juvenile lifers. And here's what we found. First, there are over 400 people that are serving life sentences for crimes committed as children that have already served over 20 years and would be eligible under this bill. Second, 114 of them are 50 years of age or older, meaning that many of these individuals have already served over 40 years in prison. And third, the most egregious statistic to date is that out of the 400 individuals eligible under our bill, 87% are Black. Through judicial review, trial courts around the state are in the best position to expeditiously evaluate the merits of each case and determine whether modification of the sentence is appropriate in light of the evidence of rehabilitation and the interest of justice. A big misconception is that this bill will in some way undermine victims of crimes and their families. To debunk this myth, last year, Paul LaRufa, a victim of a shooting by the DC sniper, testified in support of this bill and will testify in support again in just a few minutes. HB 409 provides meaningful participation for victims and their representatives, as is the case in current law. We have garnered support from organizations like Victims of Youth Violence, conservative organizations such as R Street and the American Conservative Union, celebrities and sports activists such as actress Alyssa Milano and Torrey Smith of the Baltimore Ravens. We've even received support from several state prosecutors, the Attorney General, and retired judges, including Judge Gary Baer, who is with us on the panel. All of this support tells us one thing: it's time for a change in Maryland. I urge a favorable report on HB 409.
Okay, we will go first to Judge Baer, please. 2 minutes.
All right, thank you very much, Chairman, Vice Chair Atterbury, members of the Judiciary Committee. Thank you for the opportunity to address you and speak in favor of House Bill 409. As I mentioned earlier, I am Judge Gary Baer, recently retired from Montgomery County Circuit Court, and I stated previously in connection with the other bill conclusions I've reached over the years about juveniles and their criminal behavior. House Bill 409 prohibits a court from sentencing a juvenile to life without parole going forward and allows for resentencing of those who have served at least 20 years if the person can show rehabilitation and a lack of danger to the public. This is in line with national trends, both from the United States Supreme Court and from other state courts as well. The Supreme Court has recognized that juveniles are not miniature adults. The research and science tells us that their brains are not fully developed until age 25 or so, and they lack the full appreciation of the consequences of their actions. I've studied this in connection with my duties as a judge and also in teaching at American University, Washington College of Law. All this bill does is require that a court consider the factors that the Supreme Court has deemed relevant to juvenile sentencing. It is not unduly burdensome to require trial judges to do so, given the relatively small number of cases, again, roughly about 400 cases. And further, the decision that the trial court would render could be done either on the record, orally, at the time of the hearing, and then transcribed, or could be a separate written opinion. Now, juveniles who commit serious crimes need to be given second chances, particularly after they've served a significant period of time, 20 years or more. They are simply not the same person that they were when they committed that crime. So all this bill does is give children a second chance, children now adults, a second chance to mature and redeem themselves. Thank you very much.
All right. Thank you very much. We're going to go now to Paul LaRufa, please. Mr. LaRufa.
Yes. Thank you.
2 minutes, please.
Thank you. As Delegate Lewis mentioned my name, he quickly mentioned that, yes, I was shot in 2002. I was shot 5 times. I survived. I say that because there's a common thought that all victims of crime feel that the perpetrator should go to jail for life. They believe in life without parole. And I'm just here to say that that really isn't true, because I'm here in favor of HB 409. And I'd like to just say a few points, mention a few points of why, and address some common misunderstandings. So I just want to start by saying what the bill is not. It is not a get out of jail free card. It is not a release from prison with no conditions and no prerequisites. And it is not an elimination of punishment or personal responsibility by the person who committed the crime. And probably most of all, I could sum up by saying the bill is not a guarantee. It doesn't guarantee anything. What it does do is it gives hope. It gives hope to a 15, 16, or 17-year-old child who is facing 60 or 70 years in jail and knows that he or she will die in prison. So it provides hope is the main thing. And as the previous judge just mentioned, it's a second chance. We live in this country with second chances, and it provides a second chance to have freedom and chance to live a life that's meaningful. And I think Maryland should add their name to the other states who have had the wisdom and humanity to pass a similar laws to this one in Maryland.
Thank you
Thanks
very
for
much.
listening.
Thank you very much. Mr. Ellis, please. Eddie Ellis?
Yes. Thank you, Chairman Clevenger and committee. My name is Eddie Ellis, and I'm a resident of Maryland in Montgomery County. I work for the Campaign for the Fair Sentence of Youth as the Incarcerated Children Advocacy Network Coordinator. We have over 35 members in 25 states, including the District of Columbia, who were former life sentence children who are now home. I was once one of those children, and at the age of 16, I was arrested and charged with murder. And I take full responsibility for my actions. I spent 15 years in prison, and to date, I have been home for 14 years now. Being free has allowed me to get married, have my wife, my children, and I've dedicated my life to change and doing better in the community, and that's what I've done since I've been home. I support HB 409 because it is many more who are in the Maryland prison system who deserve a second chance also. I'm not here to tell you all that the facts in these cases are not bad, because a lot of them are. The facts in these cases, the facts in the cases of the 135 ICANN members were bad, but they're home doing what they need to do and being responsible in the community. I'm not here to make up any excuses for anything, but I'm here to tell you that, children do change. I've changed. I've committed myself to change, and that's all I've done for the 14 years I've been home. And I would love to see this bill pass to give people a chance to come out here and live their life as productive members of society and prove that they are worthy of a second chance. And for me, I've been given that chance, and I've shown that I've been worthy of that chance, because I've done nothing but commit myself to bettering myself, to being a good father, to being a good husband, and a good citizen. And I just hope that others, men and women, get that same opportunity. Thank you.
State's Attorney Braveboy.
Thank you, Mr. Chair, Madam Vice Chair, and members of the committee. For the record, I'm Aisha Braveboy, State's Attorney for Prince George's County. I'm here today partly because of a chance meeting I had years ago with Eddie Ellis. He taught me something very important about redemption. He taught me that it was real. And when I took on this role, when I took on this role as state's attorney, one of the first things I did was create a conviction and sentencing integrity unit to give a voice to other juveniles who have been in our system for 20, 30, 40 plus years, who, yes, committed very serious crimes, but have really been redeemed, who've changed their lives. And while we've had success in Prince George's County bringing these matters before the court on motions for reopening post-conviction, it's really a creative way of doing it, and it is not required. Judges aren't required to actually grant those motions and hear the merits of the case. And while we've had really good success with most of the cases that we've brought before Prince George's County, we had at least one instance where the judge refused to hear the merits of the case. And so we believe that this bill is so important, and it's narrowly crafted to address a very specific problem, which is the continued incarceration of juvenile offenders, who served 20 years or more in prison, who have shown tremendous maturation and the capacity for change. And all they ask for is hope. Since we've started this unit, we have been a part of 9 individuals being released, either through our efforts in the courts or through our recommendations through the Parole Commission. But again, nothing is guaranteed. And so what we want is a guarantee, not just in Prince George's County, not just in Baltimore City, but around the state, that all juvenile lifers will have a fair opportunity to be heard, and that they all will have hope. So thank you very much, and I urge a favorable report.
Thank you. State's Attorney Mosby.
Thank you, Mr. Chair, Madam Vice Chair, members of the Judiciary Committee. I come before you today as a top prosecutor in Baltimore City, testifying in support of HB 409, the Juvenile Restoration Act. You may ask why, and as my colleague has already testified, why as a prosecutor I'm coming before you to testify on a bill that authorizes a court to impose a sentence less than the minimum required by law, or why we're supporting a bill that would prohibit a court from imposing a sentence of life imprisonment without the possibility of parole for juveniles, or why we're advocating for juveniles convicted as adults for offenses they committed when they were juveniles to have their mere ability to file a motion with the court to reduce the duration of their sentence. I'm testifying before you today because as a prosecutor, we must ethically be guided by our mission, which is justice over convictions. And justice requires us as prosecutors to acknowledge that we have historically played a role and contributed to the epidemic of mass incarceration and racial inequity in this country by making excessive sentence recommendations, period. But in many instances for children that science has determined should be treated differently than adults. Recognizing the harm that prosecutors have inflicted, we now have the responsibility to right those wrongs. This bill would ensure that we're not only relying on the science, but we're acting in conformity with 23 other states across the nation that have already outlawed juvenile life without the possibility of parole. Right now in the state of Maryland, approximately 300 juvenile lifers have effectively become juvenile lifers without the possibility of parole, in contradiction to science in the Supreme Court, because Maryland is one of only 3 states that require approval from the governor as part of the parole process. Right now, in the state of Maryland, there are extremely limited legal mechanisms to revise and modify sentences that should recognize the reality that what you do at 16 should not always define who you are at 70. The status quo is neither just nor sustainable. And I come before you today because as a prosecutor, my responsibility to the citizens I represent is to not only enforce the laws, but to reverse the harms imposed upon them because of those same laws. This bill puts into practice the imperative need to review and, when appropriate, revise sentences in the interest of justice and fairness. And I urge your support on this important bill. Thank you.
Very much. There are questions for this panel, and I see Delegates Shetty, Wanika Fisher, and Williams to begin. So we'll start with Delegate Shetty.
Thank you, Mr. Chairman. Thank you to our bill sponsor for bringing this important bill forward. It's always nice to see you in Judiciary. Welcome home. So I have 2 questions, if I may. I'm going to direct one to my constituent, Judge Baer, and I'm going to direct the other to either of the two prosecutors or Mr. LaRuffa if you choose to respond. So the first question, Mr. Baer, is there has been reference made in the testimony on the first panel to Maryland's existing rules being against what the US Constitution requires. So I was wondering if you could quickly outline for us what the Constitution requires, how this bill specifically would address that. And then my second question, again, for the prosecutors or Mr. LaRuffa, is related to the victims. So we hear often in these bill hearings from other prosecutors across the state who come before us and share that this is really unfair to victims to be coming, asking them to yet again participate in another review of a case. And I know, Mr. LaRuffa, you very kindly shared your personal story and how, not all victims are equal, and different victims have different views. And so I'm just wondering if either the prosecutors who have shared testimony have any, differing thoughts that they'd like to share, or if Mr. LaRuffa, if you would like to share. So either group can go first. Thank you.
Well, I'll just say that, we certainly inform our victims and give them an opportunity to participate. But we have to make tough decisions as prosecutors. And really, it's about what is just, what's justice. And in cases where people have been disproportionately sentenced, and we believe that, we have to make the tough decision to try to make it right. And so that's really the simple answer that I have for you.
I would just like to say that what I said was I just want to dispel the idea that all victims feel a certain way, because they don't. People like me and other people have come to the conclusion that their life isn't better because somebody who committed violence against them is in prison for the rest of their life. But I know people disagree with that. I know other victims disagree with that. But it's just that not all victims feel better about this. At the time I was shot, honestly, yeah, I wasn't about to say in 2002 that I wasn't worried about Lee Boyd Malvo walking the streets again. But that was 18 years ago. So I've learned a lot in that time, and I've talked to other victims who feel the same way, that their life isn't better because of that. Now, there are victims that will say the opposite and say they'll feel bad if a person gets out. But I just don't feel that way. And just one last thing, if I may, when I met a few years ago, when I met people like Eddie Ellis and other people at CFSY, the Campaign for the Fair Sentencing of Youth, who have been released, there's no way they're the same people that they were when they were 15, 16, and 17. And I always say to people, think about yourself at 30 and how different you were than when you were 15. There's no comparison. So people do change. And, that's why I feel passionate about it, that somebody should have a second chance. And if you are against it, I just use this example. If you meet somebody like Eddie Ellis, if you're against this bill, you're saying, no, Eddie, the world would be better. Everybody's life would be better if you were still in prison. And that's absurdity. He's living proof, and other people are living proof that it works, that these people do change. And one final thing, please. The recidivism rate for the 600 and something people who have been released in the last several years is close to zero. So that alone proves that a law like this works. Thanks a lot.
So Delegate, if I may, you asked two questions. One was pertaining to the law. I mean, and as you may be aware, in 2016, the Supreme Court outlawed mandatory juvenile life without the possibility of parole. However, in the state of Maryland, juvenile lifers, and when I said this in my testimony, have effectively become juvenile lifers without parole, because in 1995, our then Maryland's governor, Glenn Denning, removed the pre-release of all lifers in the correctional facilities with his famous life means life rhetoric. And so this has been the same sort of position for every governor succeeding him until 2019, when Governor Hogan directly approved parole for 3 juvenile lifers. There are approximately 200 juvenile lifers that are on parole, that are parole eligible, that can and should be considered for release. And so that's how they have effectively become sentenced juvenile lifers without the possibility of parole by default. With regard to the survivors, I think that you are absolutely right. And it's incredibly important to include the victims and the survivors of these offenses in this process. You know, I announced my sentencing review unit in December. And one of the things that we emphasized, I hired, and you will hear from Becky Feldman, who was a former deputy public defender and worked on the Unger cases. And she's very familiar with, you know, these individuals that have aged out of crime and has the statistics. But one of the things that we emphasized was that victims and witnesses and survivors affected by these crimes, it requires us to create a process that is sensitive to their concerns. It will benefit and heal them in ways that allow for a restorative justice process to kind of take place. And so, you know, I'm really, really excited. And Becky will tell you her own story when she testifies. I mean, she was a survivor of homicide. And her brother, right? Like, and I'll allow her to explain it. But at the end of the day, what we attempted to do through that process is that we set up a partnership with a local restorative justice organization where we refer the survivors of these homicides to that organization so that they can begin that process of healing.
All right, if I could just briefly address Delegate Shetty's question also. And I do concur with what the other people have already said, but basically, just to set the law straight, the Supreme Court over the last 10 years has issued 3 opinions. One is called Graham versus Florida from 2010, followed by Miller versus Alabama in 2012, and Montgomery versus Louisiana in 2016. And basically, what those cases, these were Justice Kennedy cases, and what basically the court was saying is that juvenile offenders must be afforded, and this is a quote, a meaningful opportunity to obtain release based on demonstrated maturity and rehabilitation. So essentially, just a flat life without parole sentence for a juvenile is really unconstitutional. That's kind of the bottom line. Now, the Maryland Court of Appeals has sort of addressed this, but not exactly. There's a Court of Appeals case called Carter versus State from 2018 that was kind of a split decision where they were trying to figure out how do we judge juveniles who are serving life sentences when, as has been stated, you've got an overlay of a governor having to approve parole, and you have different policies by different governors essentially not granting parole in most cases. So this bill would, I think, kind of alleviate that constitutional problem by addressing, and I'm just looking at the House bill, Section C, where it says the court shall consider the following factors when determining whether to reduce the duration. So it's not saying the court has to reduce it. The court can reduce it because, again, the Supreme Court has recognized that juveniles are not adults and that they have different brain development, and that particularly, as this bill does, look at this person 20 years later. It's not the same person. So anyway, all this bill does is say to the court, look at the age at the time of the offense, look at the nature of the offense, look at whether the person has a good institutional record since they've been confined, whether they've completed programs, whether they've shown maturity and rehabilitation to re-enter society, take into account the victim or the victim's representative. So all these things, you know, the background of the child, family, trauma, history, abuse, of that sort of thing. So all it's really doing is I think this bill actually brings Maryland into conformance with what the Supreme Court has mandated and what other states have already done. So I think in a sense, Maryland is a little behind the curve on this. And I think now is really the time to bring us up to date.
Okay. Delegate Juanita Fisher, followed by Williams, McComas, and Griffith.
Thank you, Mr. Chair, and thank you, Delegate Lewis, for bringing this important piece of legislation. We miss you. This is directed to the judge, Judge Bayer. Why can't we do this through the parole system? That comes up a lot. Can you clarify why it can't be done through our current parole system?
Well, a couple of reasons. One is that the parole board will look at similar factors. They'll look at factors that are similar to what is in this bill and to what the Supreme Court has mandated. But the Parole Commission is not a court, right? They're not legally trained. I mean, some are, but some of them aren't. So that's one difference. Another difference is, as I was saying, and as the state's attorney has said, once you politicize this, once you bring in a political role by the governor, which I think only 3 states have, if I'm not mistaken, around the country, that's going to inject a very different sort of dynamic to the process. So it's going to skew how the parole commission is going to even recommend cases, and it's going to skew who the governor is going to approve. So I think it's the combination of the fact that it's not a court doing it, it's the parole commission doing it, coupled with currently, and I know this is another bill before the General Assembly, is the governor's involvement.
Delegate Williams.
Yes, thank you. Thank you, Mr. Chairman. And thank you, Delegate Lewis, for bringing forth this bill. My question sort of was already somewhat answered. One, I just want to make sure if I heard correctly, I think State's Attorney Mosby, you said there was 28 other states that have already enacted similar legislation to this?
23.
23, okay. Well, close enough. Still quite a bit. And then secondly, and this was kind of alluded to earlier, Delegate Lewis, I don't know if you saw the letter from MSBA about their proposed amendment just to allow or put some type of language in the bill kind of requiring notification to victims with regards to that. And I know that was kind of mentioned. I know State's Attorney Mosby had mentioned kind of what her office is doing, as well as State's Attorney Braveboy had mentioned what her office is doing in terms of notifying the victims. I didn't know if there were any additional comments or thoughts about that.
That was actually in my testimony. I cut it off to try to keep everything for you all, but yeah, we accept the recommended amendments from the bar. The Attorney General's office has very comparable amendments, essentially stating the same thing, making sure that victims have to, or their representatives have to be notified, which we absolutely support.
Okay, thank you. Those were my only questions, but thank you for bringing forth this bill so we can also address those constitutional concerns as well. Thanks.
Delegate Griffith.
Thank you, Mr. Chairman. And I want to reiterate Delegate Fisher's comments to Delegate Lewis. I miss you too. It's good to see you again. And this is for all the witnesses. My first question is, in a situation where the victims may object to the individual getting some kind of early release, because obviously in a situation they've lost a mother, father, son, or daughter. And I certainly, again, commend Mr. LaRufa for his capacity to forgive. I think it's a great example for all of us. But certainly in a situation where someone is concerned for whatever reason as their right as a victim, what type of consideration does that make on this decision?
Well,
I can,
oh, go ahead.
no, I was
Go
just gonna
ahead,
say, I can approach it both from the legal and from being a judge for 8 years, having just been retired. Under this bill, that is one of the factors. So the victim has the absolute right to testify, whether by a written statement or orally at the hearing. And judges are used to these kinds of hearings. They're frequently motions for reconsideration of sentence in your typical case. So this is the type of hearing that a judge in criminal cases is very familiar with. And the court is used to balancing all kinds of factors. So a judge is going to balance, and some judges balance factors differently, right? That's just the nature of different trial judges handle things differently. But when you have a list of, I think there are 11 factors that go into the decision, the victim's testimony, and I can tell you from experience, is very powerful and is taken into account very seriously by judges. So judges are going to take into account the victim's view, but it's going to be one factor that's weighed with lots of other factors.
I would just echo that as the judge. I mean, these are some of the considerations that we already make, even before we make a recommendation to the judge, or, I mean, we don't have this legal mechanism in place yet, but these are the considerations, is the sentiments of the victims and the survivors of these crimes. You know, in our review process, the consultation, even before we get to the stage of making a recommendation for them to be released, we consult with the victim and the next of kin. We consider the facts of the case, the mitigating circumstances, the changes in the sentencing guidelines, the conduct while that person has been incarcerated, their re-entry plan, right? Certificates of achievement, letters of support, their length in time in prison, their age, their medical conditions, their remorse, positive development, family community support, and their likelihood of reoffending. All of those from a prosecutorial perspective are factors in our larger sort of consideration before we even make a recommendation to the bench. Those are the similar sort of factors that the judge has already outlined that they would also consider.
Sure, and thank you for the answer. And again, you know, I'm certainly all ears on this conversation. You know, I'm certainly not the person I was when I was 15. Unfortunately, we live in a society right now that wants to punish and destroy people for mistakes they made when they're young, or a tweet they posted when they're very young, and that's unfortunate. And I certainly believe in somebody serving their debt to society be given a second chance. I just want to make sure that while trying to make sure we're giving people a second chance after they serve their debt, we're not forgetting about the actual victims in this. So I really do appreciate the bill and appreciate your answers very much.
Thank you for your question, Mike.
Delegate McComas.
Thank you, Mr. Chair. This is really, I kind of want to get some more information from Mr. Ellis. I'm definitely impressed with what he's done. I guess my one question is, what was the mechanism that got you out of the juvenile, the system? Because I assume that you had a life without the possibility of parole, or what were you sentenced to?
I was, when I went to jail, I was actually sentenced in DC. I went to jail, I faced 75 years, found guilty on manslaughter. And because of victim impact statement that was written, the judge had, the family asked to have leniency on us. And the judge could have gave me 30 years, 35 years, gave me 22 years. And, but it was because the victim impact statement was weighed heavily by the judge. And the judge said that was the first time he ever received a victim impact statement to ask for leniency in my case. And
so really your circumstances are not really this similar to what we're talking about in Maryland. I mean, in other words, it was kind of a whole different situation.
No, it is, but it is the same. But it shows that a child doesn't have to spend 50, 60 years in jail in order to change. I spent 15 years in jail, and I've been home going on 15. August would be 15 years for me being home this year. So it's showing that the capacity of change. And we are in the same, I did face life. I could have received life. You know, even 40 years would have been a lot of time. But I did 15 years and it showed my capacity of change. And it's the same thing for a lot of others who are still behind bars. They have the capacity to change if given a chance to.
Were you in the DC prison system or what?
Yes. Yes, ma'am. I went to Lorton. I went to the BOP. I did 6 years in the Supermax in Florence, Colorado. I did 10 years in solitary confinement. And I've shown then, even with going through solitary confinement for 10 years, that it's possible to show change, the capacity of change, to get on with your life.
Were you in the federal system? Or
Yes, ma'am. Because DC
Okay.
closed their prisons down.
Okay, so real quick question. Did you have a number of programs that you were able to engage in while you were in the system?
Yes, I did. I think I took over 80 programs, but unfortunately for lifers in federal and certain state prisons, they're not allowed to take a lot of these programs. But I took advantage of over 80 programs, some college courses, pre-parenting classes, because I wanted to be a parent when I came home, and a lot of other classes to deal with anger, to deal with what I'd done to my victim and his family. So I took a lot of programs to try to better myself in the sense of understanding the impact that I had on my victim and his family, and also on my family, and the impact that I had on myself. And those programs is what allowed me to change my life.
Thank you, sir.
Thank you.
Vice Chair.
Thank you. And thank you, Mr. Chair. Delegate Lewis, I'm not going to be so forgiving as the rest of your colleagues for leaving us. But anyway, Mr. Ellis, thank you for being here. You and I have had great conversations about this piece of legislation. And I'm wondering if you could just talk a little bit more about how the victim impact statement in your situation helped you and helped your release.
Yes,
We had that type of legislation proposed last year, but it didn't move forward.
Thank you, ma'am. And we did have a wonderful conversation. Well, my victim impact statement, the aunt, she wrote and asked the judge to have leniency on us because we were children and my co-defendant. And her nephew was 19, I was 16, my co-defendant was 17 years old. And again, I take responsibility for what happened. And the aunt just said, you know, they don't need to spend the rest of their life in jail. They might be able to contribute to the community. And the judge said that weighed heavy on his decision of not giving me and my co-defendant 35 to 40 years. And he gave us the 22 years. And I wanted to make sure that I honored, you know, my victim's aunt, my victim, with the way that I live my life, but I also honor myself. But it helped me a lot. It helped me a lot. It showed someone in a very hurtful situation can find forgiveness, you know, and that's what his aunt gave us in that moment, forgiveness. And I wanted to, and I want to show her and prove that I am doing something with my life to give back and to create change out here in the community. And again, I just think there's many others that's still in prison that should be able to show the same thing.
Thank you. I appreciate your testimony tonight. Thank you.
No problem.
Delegate Griffith for his one and only second bite at the apple this evening.
Yes, sir. Very grateful. Only one this year so far.
Yes, the only one. Yes.
Mr. Ellis, question for you, and this is an honest question. This is too personal. Please feel free not to answer. But, you know, after you committed your crime, you're sentenced and you're in prison. You know, at what point do you feel that you know, not remorseful for being in your situation, but when did you really feel you became really aware and remorseful of the impact, you know, of what you did and the impact on the family? At what point, how long in that process did you feel you started to turn that corner and really hit you?
Well, to be honest with you, I can't give you exact days or numbers of days, but I can tell you my father was shot and killed when I was a baby. And the impact of my choice hurt me instantly when I found out that Bert lost his life. I'm gonna honor him by saying his name. He lost his life December 20th, 1991. And I didn't know how to respond because Bert pulled the gun out on me and my co-defendant, and I shot a gun, and he was hit one time and he lost his life. And I didn't know how to respond emotionally as a 16-year-old child. I was a mama's boy. You know, my mom wasn't there to help me. In a sense, she was there for me, but she couldn't hug me. She couldn't hold me. Neither could his family. But I'm just saying, I didn't know how to respond. And when I came down off that pain, depression, you know, feeling down, I started to realize that what I'd done, it was wrong. I wish I could have done something different. My dream was to be a professional football, basketball player, not to go to jail or harm anyone. You know, and I knew that early on that what happened was wrong. And I made it my business to apologize to the family up front the best way that I knew how as a 16, 17-year-old. And as I started to get a little older, I started to realize more, despite of Bert having a gun and me having to defend myself, I had to take, you know, responsibility for what happened. And I started to grow from there and understand that I took someone's life, whether it was in, I felt the self-defense situation or not, someone lost their life. And I want to grow from this and learn from this, and I want to give back. I don't want to spend the rest of my life in jail, but I understand I had to be held responsible for what happened. And I just made sure that I prepared myself to be the best person I could when I came out here in society, so I can be a motivator people that's coming out of the system and help young people with preventive things by going to schools, talking to schools. You know, I've been a part of so many trainings and things to just give back. Because to me, that's what the rest of my life is here for, to give back, but to be a good husband and a good father. But I have to give back, you know, and that's, you know, always be a learning process for me. You know, it would never go away what happened in a situation. You know, I always think about it because it's something I will never forget. But I try to live my life in a way that's productive and healthy and make sure that I'm doing what I need to do to try to curb crime and to support, you know, but it's an ongoing process. No matter how old I get, I think I'm always going to deal with it for the rest of my life, but I want to deal with it in a constructive way. And that's what I've been doing.
Thank you for sharing. I appreciate it.
Delegate Arakan.
Mr. Chair, this question is for our state's attorney, whoever's still on the call. Just hearing Mr. Ellis's story, I'm so interested to know, how is it possible that someone who was acting in self-defense is being charged? Is this something that happens a lot still? I'd always thought that if you were acting in self-defense, that you were not supposed to be charged with murder. I mean, how could that have happened? And I hope somebody can illuminate that.
So I can't interject and say why in that particular case he was charged with murder, but what I can tell you is in his case, it was in DC, right? It wasn't in Maryland, but things like this happen a lot in the criminal justice system. You know, my office was one of the first in the entire state of Maryland to establish a conviction integrity unit where we do actual claims and reinvestigate claims of actual innocence. And I can tell you that we've exonerated 10 individuals who have cumulatively spent 270 years in jail for a crime they did not commit. On several sort of occasions, it's been because of prosecutorial misconduct. And so, although I can't speak to Mr. Ellis's case specifically, I can tell you that it happens, right? And so that's why it's so important for us to recognize the errors and the harms that some of these decisions and these laws have imposed upon people. And so that's why we're testifying and saying we don't want to continue that same sort of harm when it comes to juveniles and looking at this issue. So, I mean, I just give you that as an example. It happens all the time in the criminal justice system.
Yeah. So, and for the cases that you exonerated, were they recent cases? I mean, is this like an old school way of doing things, or do we have prosecutors today who are still aggressively filing charges that are just crazy?
I can't speak to other jurisdictions and their charging decisions. I can tell you that in Baltimore City, a majority of the cases were pretty old. And some, like I said, you're talking about 10 individuals who served 270 years in jail. So a number of these were some of them happened before I was even born. But I do say all of this to say that it still happens, right? Using that discretion and charging decision is something that is an awesome amount of power that is not necessarily overseen in every jurisdiction.
Okay, thank you very much. Thank you, Mr. Chair.
Thank you very much. I think that concludes the questions for this panel. We do thank the state's attorneys who joined us today. I know that State's Attorney Mosby has to go right away, apparently, but thank you all very, very much. We'll go to the next panel, and I'm just going to be going down the list as I have it. Rabia Chaudhry, Erica Suter, Preston Lila Meadows. Thank you very much. I think that concludes the question. Margaret Berry. So I'm going to repeat them. Oh, did I miss? I missed Frank. Delegate Conaway, I apologize. We'll get you on the next. I got you on the next round. You're okay. And repeating: Rabia Chaudhry, Erica Suter, Preston Shipp, Lila Meadows, Margaret Berry.
Oh, hello. Good evening. Am I supposed to begin? I'm sure. I'm sorry.
No, that's fine. I was letting everybody get in first, and that's fine.
Okay.
Start with you, Ms. Chaudhry. Go ahead. 2 minutes, please.
Good evening. My name is Rabia Chaudhry. I'm a resident of Bowie, Maryland. In 1999, when Adnan Syed was arrested in Baltimore at the age of 17, he and the entire Muslim community of Maryland had a lot of hope in the justice system of this country. But we were naive, and we didn't even know enough that we should be scared. We did not know that America had the unique dishonor of being the only nation in the entire world that sentences children to die in prison, or that 22 years later, Maryland would still be one of the states in the country that had not yet abolished juvenile life sentences without parole. We didn't know that Adnan would be one of those children given an effective death sentence. I want to tell you a little bit about the children that we end up sentencing to die in this country. 79% of them have witnessed violence in their homes. 47% of them have been victims of physical abuse. 40% were enrolled in special education classes, and less than half of them were actually attending school at the time of the offense. So these are the children that we lock up. Our children deserve better. They deserve redemption. Maryland must do better because Arkansas does better. Virginia, DC, West Virginia have done better. So I really believe that we must do better now. I urge our elected officials, the leaders of our communities, to pass the Juvenile Restoration Act. Thank you.
All right. Let's go to Erica Suter, please.
Good evening, and hello again, everyone. My name is Erica Suter. I'm a post-conviction and appellate criminal defense attorney. I'm vice president of the Maryland Criminal Defense Attorneys Association, and I am here on its behalf. Last session, I was here in behalf of felony murder reform with a former client of mine, Warren Hinson, who received a life sentence when he was just 17 years old. Warren wanted to be here today, but he has a new job and he couldn't take off from work. So when we talk about criminal justice reform, it's easy to think that we are either on the side of victims or criminal defendants. I've been representing criminal defendants here in Maryland for well over a decade. And in particular for my juvenile lifer clients, it is often the case, as Robbie had mentioned, that they have experienced trauma, neglect, poverty, that they have been failed and oftentimes victimized by many of the people in the systems that were supposed to protect and support them. However, as the Supreme Court tells us, in my own experience working with clients like Warren shows me, children are capable of reform, and it is our moral duty to treat them as such. I would urge this committee to support this bill. Thank you.
Thank you. Go to Preston Shipp, please.
Thank you, Chairman Clippinger and Vice Chair Atterbury, and good evening, members of the Judiciary Committee. My name is Preston Shipp. I serve as Senior Policy Counsel for the Campaign for the Fair Sentencing of Youth. We're a national organization that works to abolish extreme sentences for children, such as life without the possibility of parole. And we're certainly grateful to Delegate Lewis for introducing this important legislation. The U.S. is the only country in the world in which a child can be sentenced to die in prison. This came about after the tough on crime era of the 80s and 90s. I was a part of that world. I was a prosecutor in the Tennessee Attorney General's office, and we were sentencing younger and younger people to longer and longer prison terms, effectively abandoning hope for people who were only 15, 16, 17 years old. But as we increasingly began to understand adolescent brain development, the U.S. Supreme Court weighed in on youth sentencing in a series of cases. And in 2012, the court held that based on these fundamental differences between children and adults, kids' diminished capacity to appreciate the consequences of their conduct and their profound capacity to make positive change and experience rehabilitation, that life without the possibility of parole is unconstitutional in the vast majority of cases. That's not an excuse. It's a matter of constitutional law and something that all of us have experienced personally or as parents of teenagers. And so the court says that we have to give young people a meaningful opportunity to have their sentence reviewed and to demonstrate rehabilitation. That fueled a very dramatic, rapid national trend away from these kinds of extreme sentences, so that states as diverse as Delaware and Wyoming, Massachusetts and North Dakota, Oregon and Texas have all abolished life without the possibility of parole for kids, and that includes Maryland's neighbors of Virginia, West Virginia, and DC. So this bill gives Maryland the opportunity to join those states, give kids an opportunity for review, and abolish life without the possibility of parole. Thank you so much.
Thank you. We now go to Lila Meadows.
Good evening again. My name is Lila Meadows, and I'm a faculty member at the University of Maryland School of Law. On December 22nd, one of my clients was the second juvenile lifer to be released through the new sentencing review unit in Baltimore City, referenced by Ms. Mosby earlier. At the time I approached the unit, my client had served 37 years in prison for a felony murder in which he was not the principal, and he was in isolation after contracting COVID-19. He walked into prison in 1983 at 16 years old, and on December 22nd, 2020, he walked out at 53, following a modification hearing in which the court considered his youth at the time of the crime and his resulting rehabilitation. I want to be clear that my client was lucky. He was lucky to have been convicted in Baltimore City, which has made this type of relief a priority, and lucky to essentially still have a pending modification, which the state could consent to. Without that, we would not have had a way back into court under the current law. I can't emphasize how rare this is, and he would still be incarcerated today had it not been the case. As you will hear from others, there are hundreds of juvenile lifers in our state who deserve to have their sentence considered in light of their youth and their change. Whether they receive it or not should not be a function of where they were convicted and whether they've already exhausted all of their other legal options. This legislation ensures that every juvenile lifer will have the chance that my client did, and that court will be forced to consider the factors that the Supreme Court says are so important. Others, opponents of this bill, will claim that there are already enough ways to get back into court. I can assure you that there are not. I encourage you to issue a favorable report. Thank you.
Thank you. Margaret Berry, 2 minutes. Off you go.
Thank you for this opportunity this evening. My name is Margaret Martin Barry, and I direct the Reentry Clinic at American University's Washington College of Law. I testify today as a member and on behalf of Montgomery County's Women's Democratic Club. WDC strongly supports HB 409, and we thank Delegate Lewis for introducing it. As you've heard, the Supreme Court has said that life without parole is cruel and unusual punishment in all but the most extraordinary cases when applied to child offenders. That's because of what science tells us about the culpability of children. Maryland needs to join the 25 states plus DC that have done away with such laws. The bill also provides for resentencing child offenders who have served 20 years and can demonstrate rehabilitation. This is a crucial piece of the legislation. Approximately 400 child offenders, as Delegate Lewis pointed out, would be immediately eligible. If the bill doesn't pass, it's unlikely that most of them will ever return to society. There's very little hope for a second chance. Shamefully, 87% of these child offenders are Black. 115 are over 50 years old. The refusal to see, despite all they demonstrate, that these are people worthy of redemption is something we as a community must address. Thank you.
Thank you all very much. Questions from several members of the committee. We're going to start with Delegate Conaway. You may not have a question right now after all, but I cut off the last panel too soon. So we're going to let.
Thank you, Mr. Chairman. Thank you, members of the committee. Thank you, people that came in to testify. I certainly agree with going along with the Constitution and providing hope for people. Well, my question is, since the judge is going to balance the view and there's several factors that they're going to take into consideration, how often does a victim's family input statement affect the ruling of the modification? Does anyone know what the data shows? Okay, with that, I want to say this. While we're talking about people who have been incarcerated and they've shown change, what I want to know is if a parent has a child that's murdered, is the parent required to acknowledge that change and that rehabilitation of the murderer of their child? Does anyone have any comment on that?
I can speak, I think,
sure.
Anecdotally.
Anecdotally, okay.
Yeah, I mean, I don't
So you
think
have no children? You have no children?
I have children.
Okay.
My children are pretty small though. But I don't know that I don't think anyone is tracking the data to directly address your question. What I can say is someone who's practiced criminal defense in Maryland for over a decade, Maryland courts do a really fantastic job of recognizing and taking into account the testimony of victims and recognizing years later and validating and bearing witness to the pain that victims continue to feel years later. As to your second question, whether or not, if I understand it correctly, you're asking whether or not the victim's family is required to acknowledge the rehabilitation of an individual. No, they're not required to recognize that. Is that, am I getting it?
Yeah, you have that 100% correct. So as a parent who has decided that their job or obligation is to protect their child, if you're released from prison or allowed to be paroled or whatever, some of the parents, as I know some of them, might feel that they have to change because they feel that justice has not been served. I mean, when you start talking about all of this balancing, you're a new person and all like that, there's a certain level of responsibility that is held for years that I know of, which is generally called street law.
So, I mean, I think that it's important to recognize, as we do in sort of all humanity, that there is a great and broad diversity of victims, and they have the right to sort of process their experience however they may. And I can tell you, for example, I have a client who received life for first-degree murder when he was 16 years old. And in his case, there was a victim's advocate named Lisa Spicknall, whose children were murdered by her ex-husband. And she was doing work. She was doing work for Mothers Against Drug Driving. And through that, she was reaching out to the prison. And she wrote a letter saying, this is not a letter that I ever thought that I would write, but I've met this young man who I think has rehabilitated himself in so many ways. And so I think it's difficult to, I think that victims sort of process their grief in a number of ways. And it's
But I
important to
think,
sort of,
excuse me for cutting you off. I don't want to take up a lot of the committee time, but I think I clearly expressed that I'm talking about a parent that says, I do not forgive you. And you are sentenced to life in prison without the chance of parole. Now, I've already said that I understand the constitutional challenge, but once you do that and you parole this person and the parent sends something into you that says, I do not forgive you. And if you are paroled, you're subject to make me show change. What about that? Some parent, you don't have to answer, but just some parents or some people are just not going to find your constitutional ruling to be acceptable. And while you talk about people showing change and balancing the scales, some of this is just going to be unacceptable. So,
well, can I just jump in real quick? Because
Mr. Shipp, I just need to say one thing. Mr. Shipp is going to talk next. I will allow Delegate Lewis to also jump in on this.
Oh, well, I'm sorry, Delegate Lewis. I sure
No,
didn't
no,
want to talk over you.
You trump Delegate Lewis.
No, go ahead. Go ahead.
We've heard from Delegate Lewis too much for the last 2 years. He's gone now. We're upset. So we're happy to hear from Mr. Shipp. Go, Mr. Shipp.
Thank you, Chairman. Thank you, Delegate Lewis, and thank you, Delegate Conaway. But you know, my background as a prosecutor in Tennessee, I have had some heartbreaking conversations with the families of victims. And when I moved over into the world of criminal justice reform and started working for the campaign, I didn't all of a sudden stop caring about the well-being of victims. I didn't stop caring about accountability and public safety. But what I have learned, and I'm learning, especially by working so closely with folks like Eddie Ellis, is that justice is not a zero-sum game where I can only care about one side of the equation. And if I start investing in a concern for rehabilitation and second chances, that somehow diminishes the feelings that I have, the compassion that I have for victims or the family members of people who've lost loved ones. What we want to do is hold those things together and leave room, for hopefully all people, the people who've caused harm, the people who've suffered harm, to move forward into a better future. Thank you for that question.
Thank you.
All right. I believe Ms. Chaudhry wanted to respond. Do you still want to respond or no?
I would like to just say something. My understanding is first that this bill would not require the families of victims to be involved if they did not want to. They can also submit written testimony if it would be too difficult for them to appear in court. But I think what's important, I don't practice criminal defense law, but I am an attorney. And I think what's important to recognize is that we have relied on our courts to tell us what justice is. There might be families of victims that believe if a juvenile killed one of their loved ones, that juvenile should be executed. As Erica said, as Ms. Souter said, there's a wide span of how victims' families might feel. So we can't really rely on the sentiments of victims' families completely like across the spectrum because there would be no consistency. So in this case, the Supreme Court has told us what justice is and is not. So justice is still served justice is still being served if this bill is passed, because according to the Supreme Court, these are the sentences that apply to such offenses. And I just wanted to add that.
Yes, I agree with you 100%. Thank you.
All right. Okay. We're going to go now to questions from Delegate Juanita Fisher, Delegate Lopez, Delegate Crutchfield. So Delegate Juanita Fisher, please.
Thank you, Mr. Chair. And this is for Mr. Shipp, not just because of the great accent, but just directing my question. Something that we don't talk a lot about is cost savings. And something that just irks me in our criminal justice system is the amount of money where Maryland taxpayers are paying for what we consider justice or safety. What is the potential cost savings of this bill and that you think the state would benefit from?
Well, thank you, Delegate Fisher, Chairman Clippinger. Thank you for that question. And I have alluded to this actually in my written testimony in case anybody would like to take a look at that. But we know that it costs, I think, $44,000 approximately per year to incarcerate a person in Maryland. Nationally, it's about $2.5 million to incarcerate a child for the duration of that person's life. And then when you contrast that with someone who has a high school education, who is released after serving about this amount of time, 20 years, they could contribute $250,000 in tax. Well, maybe not quite, but over $200,000 in tax revenue. If the person earns a college degree, the person could possibly contribute as much as $700,000 in tax revenue. And certainly, our experience with the Incarcerated Children's Advocacy Network, where we have got folks who are serving as substance abuse counselors and entrepreneurs and restorative justice practitioners. We've got a preschool teacher in the ICANN network, all of whom are, earning, good salaries, supporting their families, paying taxes. And we're not throwing money down the drain to the tune of $40,000 per year, warehousing people that we that have been rehabilitated, that if they came in front of a judge would be able to demonstrate that they have been rehabilitated and are entirely deserving of a second chance. So I think both in terms of what we're spending and what we could be making, it makes a lot of sense from a financial point of view. So thank you for that, Chairman.
Thank you.
Delegate Lopez, then Crutchfield.
Thank you, Mr. Chair. We've had a lot of questions tonight, but I haven't heard it brought up very specifically yet about recidivism. So can one of you share either specific data or statistics you might have about juvenile offenders who've been released in recidivism, or just trends that you've seen to that effect?
If I could jump in, other people may want to, but a study came out of Philadelphia last year that found the rate of recidivism among 175 former juvenile lifers was 1.14%. You're going to hear later from Tina Zottely and Tarika Kapoor, who authored that study. They'll go as deep into the data as you would like to go, but the takeaway, and I don't mean to steal their thunder, is that when these folks get a second look, they are the safest population you can imagine to release, because they have invested in their rehabilitation, their brains have matured, they've aged out of crime. So if you look at a 1.14 rate of recidivism, you're talking about almost no chance of reoffending.
Can you compare that to the rate of the regular population?
Nationally, I believe, it's probably in the neighborhood of 65%, I think is the latest data that I saw. Tennessee, it's a little bit higher. Not real proud of our rate of recidivism across the board. But, certainly this is remarkably low rate of reoffending.
So 1.4% for juvenile offenders.
1.14%.
Okay, cool.
Thank you for the question, and thank you, Chairman.
Delegate Crutchfield.
Thank you, Mr. Chair. Are there other states that have really looked into this issue, dived a little deeper? Do you have any data around that?
So yes, and I appreciate the question, Chairman Cliffinger. But yes, in terms of the other states, as I mentioned, it's a wide variety of states. The last state that we saw ban life without parole for kids was Ohio. The governor signed their bill on January the 9th. We were very pleased to work with, in Ohio, Republicans have a supermajority in both chambers and a Republican governor. And so we were pleased to get to work with folks in the very red state. But then, we've also seen legislation pass in Oregon in 2019, North Dakota, Nevada, Arkansas, Virginia early last year. Virginia passed a 20-year bill. The bill that Delegate Lewis has filed is based largely on what West Virginia did a whopping 8 years ago. It's better to be a kid in West Virginia than just about anywhere else in the country. because they understand that children change. And so in 2014, they committed to, after 15 years, no matter who you are, what you've done, you're going to get a look at that point. So this bill is largely based on what has been so successful. I should point out that John Elam, a Republican lawmaker, former Republican lawmaker from West Virginia, submitted written testimony. So if you'd like to read through what former Representative Elam had to say about their experience in West Virginia, you have the benefit of his testimony.
Mr. Chair, may I have one more question? And Mr. Shipp, do you know how many states actually have this type of legislation in place?
Ohio was the 24th, and then DC as well.
Thank you.
Thank you, Delegate Crutchfield. Thank you, Chairman.
Are there further questions for this panel? Looking out for my people who sometimes like to wave. All right, I have a few questions that I'd like to ask. Some of these might be on this best directed to the sponsor, might be best directed to Professor Meadows. But let me take a swing. I think that I don't believe that juveniles should be charged to life without parole. I just leading out with that statement. I don't know many people who do believe that. I think that that the science is fairly clear and is there, and that sentence was rightly struck down by the Supreme Court. The questions I have relate more to the motion that's filed to reduce the duration of the sentence. Throughout the testimony, a lot has been said about this is addressing issues of juvenile lifers. And in the bill, it says on the second page in 8110B1, the individual has been in prison for at least 20 years. That creates the possibility that this is not somebody who is being held for a life sentence. Is there a reason why it is not specifically related to people who have been sentenced to life? Because I've heard the numbers from the state's attorney for Baltimore City saying that there are 300 people who received a life sentence who are being held right now. And I've also heard, both not at this point, not during this testimony, but at another time from the sponsor, that the issue is there are a lot of people that are being held who are in fact sentenced to life and presumably life with the possibility of parole. Why wouldn't it be limited to people, at least at first, who were sentenced to life sentences?
Yeah, I think so the bill focused on life without the possibility of parole as well as life equivalents. So it's essentially folks who also have just very lengthy sentences that, the nexus was given to them when they were a juvenile.
But the people who have a term of years would be able to go through the parole process. And my understanding for this particular bill is the goal here is to deal with the people, and as was mentioned in the previous panel repeatedly and rightly, we had House Bill 3 not that long ago, getting the governor out of the parole business. They still have access to the parole system, where people who have been sentenced to life with the possibility of parole do not. So I guess I'm wondering if for no other reason than for efficiency, is it better to focus on those people who are in for life, or at least begin?
So I think, the bill is written from the context that House Bill 3 hasn't passed yet. I would love a context where House Bill 3 has passed. I think that our bill would be different under those circumstances. Make sure that we're providing everyone with an opportunity to request to go before a judge after they've served 20 years. So to directly answer your question, My bill is if House Bill 3 doesn't exist yet, because it doesn't yet. But as the chair knows, I am very supportive.
Well, but I accept that point. That's actually, that is my point, that House Bill 3 does not in fact exist yet. So my question is, we're targeted at people who were life with the possibility of parole, people who were, but they were sentenced as juveniles. People who are there for a term of years are eligible for parole. The governor is not part of that process. I'm wondering, given what was testified earlier, that there are 300 people who would fall into this category, whether it would be better to start with them.
Delegate Lewis, do you mind if I take a stab at this?
Sure, Lila.
So I think that there are two answers to your question, Chairman. The first is exactly what Delegate Lewis mentioned, is I think the bill is trying to capture a group of people who are not serving life sentences, but they're serving extreme sentences. And I think the reason why that matters for parole eligibility is because if you're serving a long sentence for a violent crime and it's not a life sentence, you become parole eligible after serving 50% of that sentence. And so if we have a juvenile, let's say, who's serving a 60-year sentence, it's going to be 30 years before they have their first parole hearing. And I think that's problematic. And the Court of Appeals has had a few things to say about that in a case called McCullough v. State. And I think you'll have the benefit of hearing from Brian Cicenti later, who argued that case. So I think that's the first answer, because we do have a population of juveniles in the state of Maryland who right now are required to wait decades for that first parole hearing, just because of the way that parole eligibility works here in the state. But I think that the second answer to this question is what I tried to touch on earlier in my felony murder testimony, is that really we need both. Even if House Bill 3 does pass, even if we remove the governor from the parole process, I think that there are special things about being incarcerated as a child that make it even a little bit harder to prepare for parole, in my experience representing juvenile lifers in that system. So the types of evidence, for example, that you need to marshal to be able to demonstrate rehabilitation and change, the type of insight you have to provide to demonstrate that you've changed, even if you really have, to be able to explain away sort of some of the situations in your childhood. Some of my clients are really, really well equipped to do that on their own without the aid of counsel in a parole hearing, and some of them are not. And what this bill provides is the opportunity to have a day in court where you are represented by an attorney who helps you pull all of those things together in front of a judge. And unfortunately, you don't have that ability in parole, even if we remove the governor from the system. And so I think this really is a case of not either or, but yes and. We need both of these pieces of legislation.
So I have a few further questions. I don't know that I want to dwell too much on any one point, but you talked about what juveniles have to do to demonstrate that they have been rehabilitated or are in a place where they are in a place where they should be released. And as was mentioned before, one of the issues, and I did not know that the Bar Association was going to come in with a statement that they think that the victim should be notified prior to any hearing, and I completely agree with that. I concur with that, and I might even go further in saying that I think that the victim has a right to appear, just as they would have a right to appear in any kind of sentencing. Another question, though, that goes, I think, to the ability of, I don't know if it's the ability, I don't even know if that's the right word or not, but that goes to the convicted person's readiness to leave, I think, goes to mental health. And there is no question. I think that this is tricky, because you start to talk about, well, I want to make sure that they're in a good place with mental health. I'm not going to necessarily find them in a good place in their mental health because they are in fact imprisoned, and that is not necessarily, in fact, it's not good for mental health. I'm not making light of it. I'm just saying that's an issue that has to that has to be addressed. In the parole process, however, and it's not in the process that's in this bill, but it is in the parole process, there is a mental health evaluation that is required. And well, there's a mental health evaluation that is required. And it strikes me that having that mental health evaluation would be something that would be of help to the judge, of help to the inmate, of help to everybody in properly determining how or what kind of aftercare they're going to need when or if they are released. I think that's something that would be very important as well. And I see in the bill that the judge would consider any report of a physical or a behavioral examination of the individual conducted by a health professional. I'm assuming that is kind of a bank shot way of saying mental health evaluation, but I kind of wonder whether that needs to be explicitly in the bill. And I'd like to hear from the panel about that.
If I may, it seems to me that when you have a candidate, someone who's going before the court and can demonstrate all those 11 factors that are there, to assume that they need a mental health evaluation is kind of imputing something that is often not demonstrated. Our clinic has never seen a client who has mental health issues. Now we've been, I'm sure there are ones out there, but to assume that that's necessary, I think that would be apparent in a client who's going forward, and that would be something that you could identify and then be prepared to demonstrate to the court with regard to how they are appearing or how they're prepared to be released. But to assume that they need that, I think, is not really evidenced by the people who have demonstrated all these other factors that are there. I've had clients who have come up for parole year in and year out and shown great patience, great fortitude, great evenness in that process. And I just am worried that there'd be this assumption that they would have a mental health issue because they've been in prison. It's challenging to be there, but it's not necessarily fair to assume that they have mental health issues. And I just wanted to put that in because I've just seen so much to respect and be in awe of in a lot of the clients that we have worked with over the past several years.
I don't know that I disagree. I think that I would tend to agree that there shouldn't necessarily be a presumption. Having said that, if we're setting up what effectively is a parallel system to that in the parole process, and the parole process requires a mental health evaluation, and that evaluation is supposed to be there for the judge to be able to make this evaluation. A judge who almost certainly will not have ever seen this defendant before, will have really honestly not a lot of information about the defendant. I just feel that, or in this case, the inmate, I feel that I feel like having more information is probably better than less in giving the judge the ability to evaluate that. So I don't necessarily disagree with what you're saying, that we shouldn't necessarily presume that they have a mental health illness or a mental health question. But I also think what I would be more concerned about it in some ways is if they're going to be released, wanting to make sure that they're going to be able to get the aftercare for mental health conditions that we really should know about before we release people on the street. So that to me seems like another thing. I have a couple other relatively smaller points. I kind of wondered whether it was. I did note that the individual has completed an educational, vocational, or other program. I kind of wondered whether that should be required, not necessarily just something for the judge to consider. And I also, in for Delegate Lewis on page 2, line 19 and 20, it indicates that the individual may introduce evidence in support of the motion of the hearing. This may be quibbling, but I'm wondering whether the state should have the ability to introduce evidence if they wanted to at the hearing. I don't think that's necessarily the end of the world one way or the other, but I just think that if one side's going to have the ability to introduce evidence, the other side should have the ability to introduce evidence too. So that was just a relatively small thing. But I, again, very, very briefly going back to the mental health side, I just want to underline, I don't think it's necessarily a reason, it's not like a fatal flaw in the bill. It is, however, when we're dealing with people who went in with a lot of trauma and are going to be dealing with people who come out with trauma, I think that it is wrong for us not to evaluate people for mental health, for mental health issues or before they are released. So with that, isn't that so? If anybody wants to respond to that, that's fine. And otherwise we'll go from there.
The only thing I want to say, if I can, I know the other panelists may, various expertise may want to chime in, but generally speaking, I mean, the chair and I have spoken about this before. I think everyone exiting prison, whether in solitary confinement or otherwise, they should be, whether they're juvenile lifers or otherwise, should be given the resources for them to appropriately come back to society. I'll allow others to retort. I don't think the state is limited in, let's say, responding with, the inmate, offering something. But I'll let the others respond.
That's fine.
Chairman, if I just might jump in and respond, certainly I think that the judge that's reviewing these, will certainly be in a great position to determine whether or not the judge would like to see the results of a psychological evaluation, if the judge would like to order that. I think going all the way back to the testimony of my colleague, Eddie Ellis, he mentioned to you that he served 10 years in solitary confinement. 10 years in solitary confinement. And he is solid as a rock. So I think to Professor Berry's point, the notion, that, somebody who has done this kind of time from such a vulnerable age, certainly they have overcome a lot, but I think that giving the judge the discretion to determine, in this case, I think that I would like to order a psychological eval. We'll put it off, 3 months and get the results of that. I think that's perfectly sound. And then again, going back to the recidivism rate, when you look at the success that these folks are having, when there's, a 1% rate of recidivism, states all across the country are getting this right. So you can look at a state like Arkansas and see that they're releasing in the neighborhood of 60% of the people who come up for review, which great for them. They're keeping 40% back. When they look at those folks, they're saying, well, this person is not ready yet. And so I think that, we can see from years of different states passing legislation like this, the success that's being had, our ICANN network, this is something where judges are going to get this right.
If I could just add to that, I'd hate to think that we create a financial barrier for certain people getting out. If you're going to require upfront that a psychological evaluation is done, the question is who pays for it. If the judge orders it, that might be a different thing. But to require that as part of your packet might create a financial barrier for people who don't have the resources to pay for such a thing. And if you're looking to the kind of risk assessment that they're doing through the parole process, we talked earlier about how long the wait is for that. And you could also talk about what that provides in terms of real insight into how people are doing in any event.
My presumption would be that the inmate would not be responsible for paying for the psychological evaluation. I don't believe that should be there if they had otherwise sort of cognizable claim to a sentence modification. But so my goal is not at all to set up a financial burden for somebody to get over in order to do this. But Professor Meadows?
Yeah, just very briefly, I testified that I had a hearing for a client in December that I think would look very much like these hearings if this law were passed, a juvenile lifer who had served 37 years. The motion that I filed in that case, I looked at it again today because I assigned it to some students who I'm sure are unhappy with me, was 112 pages. Only 17 of those pages was the actual motion, the rest was exhibits. And so I would like to think that I did my job as defense counsel and provided the judge with the information that he needed to really get a sense of my client's rehabilitation. And while a mental health evaluation wasn't included, certainly a very, very robust plan for reentry was. And that was very important to the court during that hearing. And so I think that as defense attorneys, when we're doing our jobs for these clients in these hearings, we're taking all of those things into account. And the last thing I'll say is we know that unfortunately, our clients who struggle with mental health issues tend to not do well in prison, and their adjustment record tends to reflect that. And so I think that's another piece of information that's available to the court that can trigger that concern and could trigger a judge asking for an evaluation in this process.
So my last question, and then I'll maybe mercifully allow the hearing to continue here. But I did hear from Mr. Ellis, and I guess the other thing that's not roughly parallel with the parole process is an indication of remorse to the victim. I wonder whether. I wonder whether that is not an important thing to have happen, and I don't know whether that was deliberately left out, and if it was, I genuinely would like to know why, and hear a little bit more about that.
May I respond just sort of?
Sure.
Thank you. I think it's kind of important to not lose sight of the fact that Maryland courts are capable of looking at sentences and have been doing, this is something that the courts do all the time, right? So prior to 2004, everybody who's sentenced has a right to file a modification within 90 days. Prior to 2004, the court could hold that perpetually, meaning if you got this incredibly lengthy sentence and you came back in 20 years, the court could take a look at it and you'd have time to establish rehabilitation and change. In 2004, the Rules Committee changed the rule, so the court only has jurisdiction for 5 years. So that's a huge, this bill, in effect, would give people the opportunity to demonstrate change, because most judges will tell you 5 years for somebody who has a 70-year sentence or a life sentence is not significant enough for them to be able to establish that record. So our courts know how to, and as someone who regularly files modifications, part of what we always do and part of what the court wants is a home plan, a reentry plan. How are we going to make sure that this person doesn't fall through the cracks? They're going to look at what evidence there is that they might likely recidivate, which when we look at that also has to do with the age of the person, the crime, how much time they've served. All of those factors go into recidivism. So certainly it's been the case with my clients that the court has asked for a risk assessment. But I think it's important not to lose sight of the fact that this is not something that Maryland courts don't know how to do. They do this all the time. What's happening here is that let's take this right that we have, that the courts have effectively exercised in looking at defendants, but let's make sure that they consider all of these incredibly significant juvenile factors that our sort of evolving understanding of juvenile brains needs to be considered that maybe perhaps we didn't give proper consideration to before. So modifications, assessing home plans, assessing the risk of recidivism is something that the courts are well suited to analyze and regularly analyze, and that defense attorneys hopefully always address when advocating on behalf of their clients in that posture.
I don't disagree. I mean, and courts deal with modifications all the time. That kind of wasn't the crux of my question. My question was more, and I'll be a little more direct. One of the things that's not in the list of things that in the bill that a judge is to look for is an indication or an indicia of some kind of remorse to the victim.
Certainly, and I would just say that the fact, I don't think that this is sort of an exhaustive list or an exclusive list.
You can't get to here without having, you're just saying it's just another step on the way, along the way, and so it's just going to happen because.
In my experience, courts are always looking for remorse. And if a defendant is not expressing remorse, not only in this process, but also in the parole process, the court certainly would take a negative look on that. And that would definitely cut against a client having any chance of getting relief.
I would tend to, I would agree. I guess I'm wondering, as we look to trying to build a parallel process effectively between, and I mean, you're seeking to go around the parole process and build a separate process. I'm wondering, where are those parallel, where are those similar guideposts along the way? I would agree that part of that growing up process that would in these cases be happening behind bars would almost certainly come from a person growing and understanding what happened and understanding the huge pain they caused another person, and probably finding a way to express that pain. I just wondered, as I went through the list of things for a judge to look at, why that wasn't one of the things that was there. I don't think, not a fatal flaw, just something that seemed to me to be something else to look at. Mr. Schiff, maybe. Yeah.
Yes, if I may just very, very briefly, I know we need to move on, but very briefly speak to that. I do think that would be something that would be very appropriate for the judge to consider under factor 11, where it's sort of the catch-all, any other factor that the court deems relevant. But I also think that we should be mindful that we just heard State's Attorney Mosby talk about actual innocence cases, where people have served long prison sentences for something that they did not do. And if an indicia of remorse was a prerequisite to demonstrating suitability for release, those folks would never come home.
Okay. I was looking for the answer to that question, and that I understand that the answer to that question then. All right. I have now tortured these people enough. Does anybody else have any questions for this panel? All right. Thank you very much. We'll continue on to the next panel and go from there. That will be Martina Hazelton, Kimberly Nelson, Alexander Greenspan, Crystal Carpenter, Alonzo Turner Bay. And I'll repeat just to make sure. Martina Hazelton, Kimberly Nelson, Alexander Greenspan, Crystal Carpenter, Alonzo Turner Bay. Don't see them yet. I see Martina Hazelton. So why don't we begin with Ms. Hazelton? Are you there?
I am here.
Great. Thank you very much for joining us again.
No worries.
You will have 2 minutes.
Okay, so just wanted to, I guess, continue on from my earlier testimony. My loved one is a juvenile lifer. He will be 45 years old next week and has served 28 years in Maryland prisons. And I've heard a lot of conversation about racial disparity, but nothing about the fact that there has to be a reckoning of past wrongs, right? So we live in 2 Americas, and that by just default, there's 2 Marylands, right? So there's a process that is outlined of how things are supposed to work and things that are supposed to happen, but that doesn't necessarily happen if you're brown or Black or poor here, right? So I just want to draw that point out. This system is one that is near and dear to my heart. Based on Attorney Braveboy's testimony, she said that there was one case, and unfortunately and sadly, that case was the case of my loved one, where a judge exercised her discretion and did not hear the court despite having the support of the state's attorney's office. And that petition was almost identical to his co-defendant. And because of just, the fact that they ended up in front of two different judges, the co-defendant, who admittedly is the primary in the case, is home, was released on December 20th. So I just ask that you support this bill, because it creates some equity that does not necessarily exist in how things matriculate through the court system. Because if that's not unfair, I don't know what is.
All right, thank you very much. I understand that neither Kim Nelson or Alexander Greenspan are in the waiting room, so we're going to add a couple more here. So the next person to testify will be Crystal Carpenter, who I believe I did. So we'll do that. Then Alonzo Turner Bay, Adrian Citroni, and Becky Feldman. So if we could go to Crystal Carpenter, please, for 2 minutes.
I'll be quick. My name is Crystal Carpenter, and I have the pleasure of working alongside Eddie Ellis at the Campaign for the Fair Sentencing of Youth. As a resident of Maryland, I just want to start off to say that I would be remiss if I didn't publicly say thank you to State's Attorney Brave Boy and Mosby. They were here today as administrators of justice in a system that they have been elected to represent. But they are also representative of a Black community that is disproportionately impacted by longer and harsher sentences in this state. I'm hopeful that their voices ring loud in the diverse chorus of supporters that have come out in support of this legislation. The data is clear. 87% of individuals that would be immediately eligible for this bill is Black. That is one of the many reasons why the Maryland State NAACP has made this one of their leading priorities this session. And I think you'll hear from Willie Flowers, the president of that conference, later today. Earlier this week, this committee had a hearing on some much needed legislation in regards to parole reform. The reality is, even with that much needed change, the data proves to us that it would not be enough. The parole board sees less than 12 of these juvenile lifer or life equivalent cases each year. And that's data from the past 5 years. And I'm being generous in that number for some of the years. If the parole board continues to hear those cases at the same rate that it has for the past 5 years, it would take over 30 years for everyone that would be immediately eligible today to even have a chance of getting a hearing. And as you have learned from other testimony, people go before the parole board multiple times with set-offs of 2, 3, or even 10 years before they get their next parole hearing. And that doesn't even take into account the 18-month delay that we heard about earlier on risk assessments that many spoke about. Unfortunately, alongside the data you heard today, there are 114 people that are aged 50 years or older that today are languishing in the Maryland prison system. They have already waited over 30 years and cannot wait an additional 33 years to simply be provided an opportunity for a hearing. So in closing, I guess I want to be absolutely clear that failing to prioritize the passing of this bill is not only sentencing children to life in prison, it is in many ways sentencing children to death.
Alonzo Turner Bay. I see you, but I don't hear you. There you go. Alonzo.
Hello. How you doing? I'd like to thank the ladies and gentlemen of this committee. I'm Alonzo Turner Bay. I was recently released after serving 31 years, 6 months, and 15 days for a crime that I committed as a juvenile offender. I was sentenced to life plus 5 years for a crime that happened in PG County. I was released on October the 16th, 2020. I'm coming before this committee and ask you to please pass this piece of legislation, House Bill 409, because it's very much needed in the state of Maryland. If we look at our neighbors to the neighboring states, Virginia, West Virginia, look at Washington, D.C., Ohio, and even Mississippi. All these states have passed or created some type of law that stated clearly, no longer will we allow our children to be locked up for the rest of their life. All of them have offered some form or chance for a second release for these individuals who are serving life or equivalent to life, with the exception of the state of Maryland. To remove the governor from the parole process, that's great, but it's not enough, because we all know Maryland has a broken parole system. For example, for the last 5 years, the organization I created put out these pictures right here to all senators. Well, let's look at the first line of it. There's an individual on there by the name of Mr. Gary Miller. He's been juvenile offender. He's been locked up since 1965. He has had over 17 parole hearings. His last 11, he was given a 1-year set-off. He was told to come back 11 times next year with the promise of release. Mr. Gary Miller has given up hope in the parole board and the system. Let's give Mr. Miller that hope back by passing this legislation, because removing the governor from the parole process keeps Mr. Miller and all other lifers and those who are serving equivalent life in the state of Maryland longer. I'm hoping you allow a judge to make the decision and make a decision to decide if these juveniles get a second chance, and if so, when. So I ask you, please, let's give hope back to the juvenile offenders in Maryland.
Thank you very much. Adrian Citroni.
Unmute. Hello.
There you go. Go ahead.
Can you see me?
No, we can't see you.
All right, let me try that now.
Now I can see you. You have 2 minutes.
Okay, sorry.
It's all right.
How many minutes?
2. We'll start you over.
All right, that's fine. I only prepared to come for 1, but anyway. Good evening, Chairman Clippinger, Vice Chair Atterbury, and members of the House Judiciary Committee. Thank you for this proponent opportunity. My name is Adrian Citroni. My daughter was 14 when her life took an unexpected detour as she watched her mother suffer and perish from pancreatic cancer. Soon after her mom passed, she spiraled down and into the criminal justice system. When she was 17, a 3-day relationship, you heard that right, a 3-day relationship, she met a very disturbed 19-year-old boy, and she was led to her sentence of life imprisonment. She has served 27 years. Without this legislation, she may stay in prison for the rest of her life. She entered the system a broken juvenile. Today, she is a full functioning woman. She continues to help and create programs for her fellow inmates and is halfway to a college degree at Goucher. She is a lady who has earned and deserves a second chance. Life is too precious to throw anyone away, and unnecessary jail time is too expensive to fund. So please become an agent in this change. A judge will decide, just give them the opportunity. I thank you.
Thank you very much. Becky Feldman, please.
Good evening. Thank you for this opportunity. I am the chief of the Sentencing Review Unit for the Baltimore City State's Attorney's Office. One of my main responsibilities will be reviewing cases of juvenile lifers who've served 25 years or more and seeing if they are ready to be released back into society. The big challenge, if that wasn't big enough of a challenge, is finding a vehicle in court to make this happen. So I think there's been a lot of testimony already about that we really do need a mechanism for the court and the state's attorney's office to review these cases and bring them back when appropriate. But after hearing, I've been listening since 1:30 today to all these bills, and what I really want to talk about now after hearing a lot of the concerns is the concern for the victims. I will tell you that my brother was killed 21 years ago in Baltimore City. He was shot and killed. And it was the Baltimore City State's Attorney's Office that saved my life. They held 2 people accountable, and I don't know where I would be if that had not happened. So I definitely understand and appreciate holding people accountable and what that means for victims. One thing that we are doing at the Baltimore City State's Attorney's Office, and I hope other offices do the same, is we are starting a program for restorative justice. I can't tell you, since we've announced this, how many victims have already contacted me asking to talk to the person who killed their mother, who killed their son. There is a need for this, and the current criminal justice system does not provide it. And we're really excited to start this. We're working with some groups who are trained in facilitating these conversations for the purpose of bringing healing, for bringing closure. And I think that is a real need right now. And it's completely up to the victims whether to participate or not. And it is not a factor in whether there is participation in what happens with the particular case. But we are very mindful of the victims, their perspective, their feelings, and we want to offer another opportunity so that they don't have to continue carrying all of that pain and all of that anger if they are ready to let it go. So thank you for this opportunity.
Thank you. All right. We have any questions for this panel? I don't think I saw any this time except for Delegate Nicole Williams. Delegate Williams.
Yes. One, I just want to thank the panelists for their testimony today. Thank you, Ms. Carpenter. Good seeing you again. My question was really for Ms. Hazelton. I didn't know, I know she was talking about the experiences of her loved ones and if she had any just additional information or context that she wanted to make sure that we walk away with before moving on to the next group.
Thank you, Delegate Williams. I appreciate the opportunity to expound. What I will say is, given context, is that this is, I think, just to piggyback on what Ms. Feldman is saying, is this gives not a you can or you may, but it's a you shall. You shall bring someone back after 20 years and give them an opportunity to demonstrate that they have changed. And right now, all of the mechanisms, even motions for reconsideration, are you may. There are judges, my loved one has had a reconsideration hearing denied without even a hearing. Without even a hearing. And to know that, you know, again, in this situation, because they're, in this specific case, the trial judge was, you know, retired and is since deceased, their cases got split up. And because one went to one judge and one went to another, and they were identical petitions with the support of the state for release. And the judge still said, no. I just need, this is a you must. You must come back and look at someone after 20 years. They get the right to do that. And right now there's a lot of discretion that a lot of people aren't speaking about. Like the opposition keeps saying that there's all these mechanisms. Yeah, but there's not anything that says that you have to. So thank you for that.
Delegate Conaway.
Thank you, Mr. Chairman. Thank you for everyone for coming in to testify. I just want to be clear on this. Maybe someone can help me. The bill is presented as a juvenile life without the chance of parole bill, but actually, if I'm correct, the bill also includes people, or can include people who may be adults and were given extremely long sentences. Is that correct? That's what. Well, actually, I got that with the chairman's comment.
That's actually what was said previously. So yes.
Yes. Thank you so very much.
Okay. Are there further questions for this panel? All right. Seeing none. Thank you all very, very much. Very much indeed. And we thank, again, not to call out Ms. Hazelton all the time, but we do thank you for hanging with us here today. All right. Daryl Green, Allison DeMarco, Jermaine Merriweather, Garrett O'Day, Tarika Daftari Kapoor. I see Mr. Green. If Mr. Green would like to proceed, that would be fine for 2 minutes. Mr. Green?
All right, Daryl Green, Allison DeMarco, Jermaine Merriweather, Garrett O'Day.
I feel like I just said that. Mr. Green, if you'd turn your volume on your speaker down a little bit, we can get you underway with the 2 minutes, please.
That would be fine for 2 minutes.
Oh, okay. I'm not sure. Thank you, Chairman Clippinger, to the Vice Chair, to Delegate Lewis as well. I'm not sure if you guys are hearing me correctly. I hear an echo or something. Yes, but I want to. Oh. Should I continue?
Let's do this. You're playing the recording for the hearing probably on another window. Maybe I don't want you to leave the Zoom, but if you can close that or turn that down, then everything else should be fine.
Let me see.
Mr. Green, and if you want to take a second to figure that out, I will come right back to you, I promise, okay?
Okay, thank you.
You figure that out. Is Allison DeMarco here? No. Jermaine Merriweather, are you here? No. And if you are here and I just missed you, I'll come back to you. Garrett O'Day, I do see, however. Garrett O'Day from the Maryland Catholic Conference.
Mr. Chair, thank you very much. Nice to see you. Mr. Chair, members of the subcommittee or the committee, thanks for your time today. For the record, Garrett O'Day, Deputy Director of the Maryland Catholic Conference, here in support of House Bill 409. Here as an affiliate of the Maryland Youth Justice Coalition and on behalf of the conference as the public policy voice of the Maryland's Catholic bishops, the diocese, and approximately 1 million Maryland Catholics. So from our faith perspective, the church supports elimination of sentences of life without parole. The teaching of our church is one with what the courts have said recently and what they've ruled that our Constitution requires. So Judge Baer mentioned the precedents over the last decade, so I won't quote Graham or Miller or Montgomery. For the record, I'll quote Pope Francis instead, who was labeled such sentences, such life sentences, as a death penalty in disguise. So restorative systems of justice are at the core of our church teaching, and we're talking about demonstrated rehabilitative nature, and that is a consideration for the court among other things in this bill. And so it's not saying let everyone out of jail. It's not saying just open up everything. It's saying give people a chance. It's saying give Martina's loved one a chance, as she said, just a new opportunity to come home to their loved ones. It's saying give rehabilitated people who have changed their lives after decades of rehabilitation the same chance that Eddie had. So we thank you and we ask you to consider a favorable report for this bill. And thanks so much for hearing us on the bill. And it's good to see Daryl too as well. Thank you.
All right, we're going to try Daryl Green again. All right. Oh, got to take yourself off mute.
Thank you, and thank you. I've been here since 1:30. Chairman Clippinger and the Vice Chair. Thank you very much. I'm just super excited to come before you today. You know, I am a victim. I'm the one that folks have been talking about. You know, where the victim, but not all victims think and believe the same, right? I believe in second chances. For the committee, my younger brother was killed over a pair of tennis shoes at the age of 14 years old. I mean, at the age of 6 days after his 17th birthday by a 14-year-old kid here in Baltimore City. He was sentenced to life in prison. And I will tell you, when it first started, I was angry. I wanted to do harm to him, his mother, his sister, his brother, the dog, the goldfish, the cat. I wanted to do harm to everybody. But then it took me 2 decades to heal, right, on my healing journey. I began to look at that young man. I began to look at his life, what his life was like prior to taking my brother's life. How did he grow up? What was his family? Those sort of things. And so I went to court after he served 25 years, and I testified on his behalf for his release, i.e. we forgave him. The name of my organization is called Deep Forgiveness. And so we travel to try to help individuals to heal, reconcile, and to ultimately forgive. And we use the word forgiveness. Forgiveness is not about the other person. Forgiveness is for you. And so I had to let that thing go because I was dying inside of unforgiveness. When I testified on behalf of the young man, the judge, he said he was blown away because he had never heard anybody speak in that vernacular to testify in his courtroom to forgive him. And so we did. That young man is now home. He spent 25 years in jail. He's now home. Him and I now work together. I believe in second chances. I believe in second chances. Everybody under the sound of my voice has done something. Maybe not so as horrendous as a young man who took my brother's life, but somebody has done something, and we deserve a second chance. We deserve a second chance. I hope that you look favorable on this bill. Thank you.
Thank you very much, Mr. Green. We'll go now to Tarika Daftari Kapoor, and I am feeling confident that I screwed up that name, but go ahead.
That was actually pretty good. Thank you, Chair and Vice Chair, for allowing me to speak on this panel today. For the record, my name is Tarika Daftari Kapoor, and I'm a professor of justice studies at Montclair State University, and I study adolescent development and legal competencies. I am here in strong support of HB 409. As State's Attorney Mosby stated, since 2012, 24 states in the District of Columbia have eliminated life without parole sentences as an option for juveniles. And in keeping with these trends, HB 409 recognizes adolescence as a formative developmental stage and acknowledges that successful rehabilitation as well as societal reintegration is possible for the vast majority of youth who commit crimes. I just want to make 3 quick points today. First, there's insurmountable evidence that the vast majority of juveniles who commit crimes, even serious crimes, will desist in their criminal behaviors as they enter adulthood. Secondly, I have done work in Pennsylvania with juvenile lifers, the work that Mr. Shipp was referring to earlier. And we have found that released juvenile lifers pose a negligible risk to public safety. Of the 174 juvenile lifers that have been released in Philadelphia, only 6 of them, or 3.5%, have been rearrested. This is in comparison to a 30% rearrest rate for homicide offenders nationally. And of those 6, only 2 were reconvicted for low-level offenses. So for a recidivism rate, as Mr. Shipp mentioned, a 1.14%. Third, I wanted to touch on cost savings. We did cost savings analysis in Pennsylvania, and I'm happy to expand on this later. And we found that Pennsylvania would save an estimated minimum $9.5 million in correctional costs just over the first decade of release of these 174 individuals. Lastly, this group does have rehabilitation potential, and the research shows this. All of those in our study took part in programming in prison, even though, as Mr. Ellis mentioned, it's very limited for those serving life, and had few to no misconducts in their last decades in prison. The main takeaway from our work is that youth have rehabilitation potential, and releasing individuals who have served long sentences, especially older individuals, does not seem to have a negative impact on public safety. We're continuing to study juvenile lifers in Pennsylvania, focusing on reentry, and are seeing very promising results. I can't get into those right now in the interest of time, but happy to take any questions. I would urge a favorable report on HB 409. Thank you.
Thank you very much. Okay, are there questions for this panel? I don't see people waving hands, and I don't see hands in the participants box. So we all thank you very much for spending most of your day with us, and thank you all very much for your testimony. Appreciate it. We will move on now. Tina Zotoli, Olinda Moyd. Joseph Tolbert is not in the box in the waiting room, what I'm calling the box, I guess. And then, so we're gonna skip him, but if he is there, he can show up, that'll be fine. Brian Saxenti, Jermaine Bowden, Tyrone Walker. If Mr. Tolbert joins us, then we'll just do 6. But for now, let's begin with Tina Zotoli.
Yes, can you hear me? I'm having a small problem with my camera. I will be right with you. There we go.
There you are. Go ahead.
Yes. All right. Good evening. Thank you, Chair, Vice Chair, and members of the committee. It's been a long day. I'll try to keep my remarks brief. For the record, my name is Tina Zotoli. I'm a professor at Montclair State University with Tarka Dafri-Kapoor, who just spoke. My research is largely focused on adolescent decision-making in legal contexts. And I'm here today in support of House Bill 409. Let me get right to the point. House Bill 409 is exactly the kind of legislation we should see given the state of the science on juvenile offending and rehabilitation. Adolescence is a transitional stage of human development involving considerable physical, hormonal, and behavioral change. Many teenagers will engage in rash and even dangerous behaviors, especially in emotionally fraught contexts and in the presence of peers. Indeed, it's been said many times today, the Supreme Court has acknowledged that criminal activity among youth often reflects these transient features of adolescence, risk-taking, insensitivity to future consequences. And we know that most youth who commit crimes will not continue to do so as adults. My written testimony summarizes the research on adolescent development relevant to this bill. I know earlier today there were a number of questions on neural development, neurocognitive development, anticipation of future consequences, and I'm pleased to answer any of those questions should they arise. In the interest of time, I just want to emphasize, I'll re-emphasize briefly what Dr. Dafri-Kapoor presented today on the re-entry of juvenile offenders. As she said, only 2 of the 174 juvenile lifers released in Philadelphia have been reconvicted of any other crime. These data provide convincing evidence of the rehabilitative potential of juveniles who commit serious crimes. House Bill 409 gives youth an opportunity to re-enter society at a time when they are still able to make a meaningful contribution. I urge a favorable report. Thank you.
Thank you very much. We'll go to Olinda Moyd, please.
Hello, once again, Chairman Clippinger. I come again on behalf of the Maryland Alliance for Justice Reform. I know it's been a long evening, and I just want to make a couple of points. My colleague, Judge Karoun, will also be on shortly, we hope, to make some additional comments. If you ask the question, why is it inappropriate to sentence juveniles to a life sentence without the possibility of parole or release, there are a few answers to the question. One, because it's not in line with the Supreme Court's decision in Miller. You all have heard a lot about Miller today, that says that you have to take into consideration the characteristics of youth when you're sentencing children. Secondly, it sends the wrong message to our children to say that we believe that your life is so beyond redemption that we're just going to throw you away. Every life has some redeeming value, and that should be the message. The third point I want to make, which was made, I appreciate Crystal Carpenter's comments. She talked about the racial inequities in our criminal justice system. We know that policing, prosecution, and even sentencing looks different in certain communities. And when we talk about 87% of the individuals who are eligible for consideration under this statute being people of color, that has to be of great concern to all of us. As I watched our president be sworn in yesterday, I couldn't help but remember the rhetoric from the early 1990s, calling our children super predators and saying that they were violent children. And the sentences and the path that we walk to build more jails and prisons after that, we're still reaping the benefits or the brutality of those sentences. When we look at these young children who were sentenced and now are individuals who are growing old in prison, I see them all the time. I volunteer in the Department of Corrections. And so I teach at Jessup and the women's facility. And so I started in the 80s. And now this population of people that I met, most of them lifers, have grown older along with me, except they're in prison and I am on the outside, especially as COVID. Okay, especially as COVID is ravaging through our prisons, and we look at the ages of the people who have died from COVID on the department's website. I just urge you to consider the individuals who you have heard from and who you will hear from, who have been released, who have taken advantage of their second chance, and just offer that opportunity to every juvenile who's been sentenced. Thank you.
Okay. Thank you very much. We do not see Mr. Tolbert. We do see Brian Saxenti, who is on the Zoom, I think.
Yes, good evening,
There you
Chairman
are.
Clifton.
Go right ahead.
Thank you, members of the committee, good evening. My name is Brian Saxenti. I'm testifying on behalf of the Office of the Public Defender in enthusiastic support of House Bill 409. As we did on behalf of clients after Unger and with the motions under the Justice Reinvestment Act, the Office of the Public Defender stands ready to represent eligible juvenile offenders on these motions. It would be our honor to do so because we've had the privilege of meeting many outstanding people like Eddie Ellis who just need a second chance. In representing such clients, we would typically gather information from the court file and the Division of Correction base file, which is a detailed account of their conduct achievements, infractions, and job history over the decades of their incarceration. With the guidance and help of social workers, we would develop proposed release plans and connect them with programs and treatment to address their mental and physical health needs, housing, and job assistance. All of this is designed with the common goal in mind of helping them be as successful as humanly possible when they are released. The state's attorney's office, in our experience, would conduct similar reviews and would notify the victim or the victim's representative so that they could, if they wished, attend or submit a written statement so their voice would be heard at that hearing as well. All of this collectively means that the judge at this hearing would know much more about the person standing before them than a judge could even hope to know at an original sentencing. And I think this really answers one of the questions raised earlier about the advantage of having an ability to go to courts on these cases. Because without taking anything away from the valuable work of the Parole Commission, people don't have a right to counsel at those parole hearings and in those proceedings, and most don't have counsel there. An advantage of going to the courts is that there are counsel on both sides able to gather and present important evidence and information to the judge. So if we trust judges with the power to impose on children very harsh punishments at the initial sentencing, shouldn't we also trust them with the power to grant mercy when that person decades later shows that they have been rehabilitated? For all these reasons, we urge the committee to issue a favorable report on House Bill 409. Thank you.
Get this right someday. I don't believe I saw Jermaine Bowden. So I see Tyrone Walker. I don't know that I see Ashley Devon. But I may not have announced her actually, so that's not fair. So we will wait with Ashley. We'll do Tyrone Walker and then we'll take questions and then we'll do, I think, what will be a final panel. So Tyrone Walker.
Thank you, Mr. Chairman and Madam Vice Chairman and all the delegates of this committee. My name is Tyrone Walker and I'm associate at the Justice Policy Institute, and we support House Bill 409. At the age of 17, I was arrested for a crime that I committed. I fired a gun that killed the person. Prior to me firing that gun, I was responsible for going to the morgue and identifying my cousin's body, who was also 17. So in a few hours, I was a victim. And then a few hours later, I was a perpetrator. I'm deeply sorry for what I've done. I live with that every day. I can't change what I've done. Only thing I could change is my behavior going forward. I served 24 years, 8 months, and 15 days for the crime that I committed. There were no victim impact statements given in my crime, but my initial sentence was 127 years and 8 months to life. Yes. So I was sentenced to die as a child in prison. Because DC passed the Incarceration, because DC passed the Incarceration Reduction Amendment Act of 2016, I was afforded a second opportunity to show that I was stable enough to re-enter society. And if Maryland give a favorable report to this bill, you will see other individuals who will return to the community to do the same thing. Yes, we all change. People who commit crimes change. Victims change over time. But are we willing to change the laws that give them an opportunity to show that they're worthy? Thank you.
Are there questions for the panel? I do not see people waving, and I don't see any hands on the participants. Oh wait, Delegate Bartlett.
Thank you, Mr. Chair. I have a question for Mr. Sacenti. Am I pronouncing that right?
Yes, you are.
My first question, I've been sitting here all day, just like everybody. I haven't asked any questions. This is my first question of the day. So I have one rhetorical question, just because, and then I have an actual real question. My rhetorical question is, do you think the state of Maryland is against seeing children benefit? Like I said, it's a rhetorical question. My second question is, when I read the bill, I don't see anything that says a child is going to automatically be granted a release, or someone who was convicted as a child is going to automatically be granted a release. Can you help me as I sit here today and I listen to all the testimony that we have had all day? Can you help me understand why this is such a controversial issue to the point that we have this many people speaking in favor of the bill, pleading, begging for an opportunity, and yet we still have opposition? And this is not the first time Maryland is hearing this particular bill, or the General Assembly is hearing this particular bill. Can you please help me understand? Because I'm totally baffled.
You know, I'm not sure I can. I'm a little baffled myself. You know, I think you have this many people testifying because most, if not all, of those people have had the experience of meeting wonderful men or women, but I'm thinking people like Eddie Ellis or Tyrone Walker or Alonzo Turner Bay. And there is something about the experience of having the privilege to meet and talk with someone like that and see, to hear about their lives, and you can't help but want to help them and help other people in their situation. Not everyone has that experience. Maybe that's why there's opposition. But I think that, you know, I think it's never too late to do the right thing and to make our system better. And this bill would do that.
And quick question, if I may, Mr. Chairman. So with that said, I wonder I understand that we have victims, and I understand that that some members have lost lives. And I get that part of concern. But what I read in the bill are so many protections in the fact that it's not a guarantee. And I just want to make sure I'm reading the bill correctly, that it is not a guarantee that if you are convicted as a child, that you are going to be released. What you will be guaranteed by this bill, if I understand it correctly, is that you will be guaranteed after 20 years, right? 20 years, not 5, 10, 15, 20 years, you will be guaranteed an opportunity to ask to be released based on certain criteria. And if you don't meet that criteria, then you're not going to be released. Or if the judge doesn't believe you've met that criterion, you're not going to be released. Or if there is, and I do remember this addition, if there's a victim statement that is influential or persuasive to the judge, you're not going to be released. Am I reading the bill correctly?
I think you are. I think you're reading it right, that there is no guarantee in here except for an opportunity. But I will tell you, that is an opportunity that is worth more than its weight in gold to so many people. I talk to people on the inside who would just say, give me that opportunity and I'll show you how far I've come, and I'll point to how hard I've worked and the jobs I've had and the programs I've done and all these things I've done to try to turn my life around, and just give me that opportunity. And that's something this bill does. And that's why we support it.
Thank you. Thank you, Mr. Chairman.
Okay, I think those are all the questions for this panel. We thank you all very much for speaking to us this evening. I think there are only 3, 4 more people speaking in favor that are left in the waiting room. So we are just going to call all 4 of them, then 1 favorable with amendment and an unfavorable. So we're going with Ashley Devon, James Dold, Calvin McNeil, and Philip Karoom.
Want to help them.
Ms. Devon.
I am here.
Great. All right, go right ahead. 2 minutes, please.
I'm not going to take 2 minutes. I think that we've been here since 1:30 and it's almost 8:30 now. Since we've been on here, I've seen the diligence and perseverance of our legislators. I've seen multiple babies pop up as you all try to fulfill your duties to Maryland and also, be human beings. I think that we've heard from quite a few directly impacted individuals and quite a few victims. And I think that it's important to note that this bill is critical that we pass it this year. We've heard from the state's attorneys, we've heard from the judges, we have heard from the advocates, and I don't want to belabor any other points except for to say this bill is critical. Maryland needs to adjust how we treat children, and that it is no longer okay for us to sentence children to die in prison or for them to go to prison with life sentences. I heard the testimony of someone who went to prison when they were in 1987 and was released in 2020. I was born in 1985. I heard the testimony of a man who said he was a child who did 10 years of solitary confinement. I heard the testimony of Martina, who shared her loved one who did not even commit the crime. I'm asking that you all move on this bill this year. This is critical legislation, and I would just like to urge you all to pass this bill. Thank you for your time, and thank you for all of your perseverance through this very long bill hearing. And I know that you have much more to go, but this is critical legislation that needs to be passed this year.
All right, thank you very much. Mr. Dold, James Dold, please.
Thank you again, Mr. Chairman. James Dole for the record. I'll be brief as well, just a few points to make. You know, all across this country, you see incredibly vulnerable children who get trapped in the criminal justice system, who are subject to lengthy mandatory minimum sentences, kids who are child sex trafficking victims, who participate in crimes against their traffickers or men who are attempting to rape them, and they get these lengthy mandatory minimums. This bill is important because it will make sure that judges have the discretion that they need to create more trauma-informed and age-appropriate accountability measures. If government's going to work, we have to entrust those in government to actually make these informed decisions, and judges are in the best possible position to be able to make those decisions both at the front end and then at the back end. And I'll also just point out that in 2019, we submitted an amicus brief to the US Supreme Court where we highlighted that Maryland was, at that time, was one of only 6 states. Now it's only one of 4 states out of 50 in the nation that has not implemented the US Supreme Court's decisions in Miller v. Alabama and Montgomery v. Louisiana, which categorically prohibit the use of life without parole sentences on children. Every other state has either banned life without parole sentences wholesale, doesn't have children serving life without parole sentences, or have the state Supreme Courts have directed the lower courts to begin resentencing those who had life without parole sentences. And so Maryland is in a very small category of states that has not acted on this issue. It's in violation of the US Constitution. It's in violation of human rights law. And I will say, as a Black man who lives in the state of Maryland, who has a Black wife and a Black son, you know, a lot of people talk about that Black Lives Matter, right? It's a catchy slogan. But I would submit that Black life cannot matter to you if the lives of Black children do not matter to you. And the lives of Black children cannot matter to you if some are deemed disposable, that we're willing to throw some away and leave them to rot and die in a cage. And this is one of the most consequential and important bills that this committee will consider this term. Virginia's done it, West Virginia's done it, Arkansas has done it. Be as progressive as Arkansas. That's all we would ask. Thank you, Mr. Chairman, for your time, and we would urge the committee's favorable support.
Thank you. Mr. McNeil, Calvin McNeil.
On mute. Good evening, ladies and gentlemen. My name is Calvin McNeil. I served 39 years before I was released from July 2020. This bill is definitely needed because under the simple fact that Maryland's system is so far behind time with all the other states that's around us. They are granting, they're looking at new and inventive ways on how to treat juvenile lifers altogether. I have heard all the testimonies, and someone said that the parole board has to recommend you for parole. Well, I can tell you that when you go up for parole after 15 years, after 20 years, the parole board doesn't recommend parole evaluation for you. They didn't recommend an evaluation for me until after I had 25 years in. 25 years, and I committed a crime at 16 years old. So the judge will have more impact on what's going on because that's the majority of the time, the judges that sentence you are the judges that you're going to go back in front of to be released. So we have to look at that because these men that are behind the wall right now at 16 and 17 years old that have done 30, 40, and 50 years, they are gravely ill right now behind these walls. We have to look at them because let's look at the money that we're paying for their health. Like me, I'm a diabetic. I have high blood pressure. I have other complications that the state was paying each and every year, $50,000 to $70,000 a year, not just to keep me in prison, but to pay my medical expenses as well. So we have to look at these things because a lot of these men are not getting the proper medical care, and some of these men want to come out here to be productive citizens. They want to do things. They want to show we want to help. Not only that, we hear about victims, but no one has said that before this pandemic came, victims were coming inside the institution.
Mr. McNeil,
Yes, sir.
if you would wrap up, please.
Okay, one thing. Victims were coming inside of the institution, and we were talking to these victims and letting them know and letting them see the pain. We feel that pain. We understand what we have done and that we have changed our lives. And that's all we ask in this committee to do, is to give us a second chance through the courts, even if it's not with the parole book, but the courts are the ones that's going to look at us fairly. Thank you.
Thank you. Thank you, Mr. McNeil. Judge Karoum.
Good evening, Mr. Chairman, members. Thank you for your stamina in sitting through all of this. Again, I'm speaking for Maryland Alliance for Justice Reform, not for the Maryland court system. And I would like, because the other speakers had done so well in addressing the substantive part about juveniles and their brain development, their character and so forth, I'd like to focus simply on the procedural aspect of this. The bill in its second section provides basically that courts could reconsider a sentence on a modification motion later than 5 years, which the Maryland rules now provide as a limit. I wanted to point out, as another speaker did, that that 5-year limit is new. It was adopted for some reason by the Court of Appeals in 2004. And for generations and generations before that, judges were able to do exactly what this bill, HB 409, would provide. There's the only difference between what HB 409 would provide beyond the list of criteria for the court to consider on a sentence modification is the fact that it says the court must have a hearing if it's a qualifying motion. I believe that that must have a hearing part is a desirable factor in the bill. And I see that my 2 minutes are up, but if I could sort of finish that thought, it's because most judges may retire after 16 years. So depending on when someone was sentenced and when this is coming in, you may be facing a new judge who has not heard this case before. And so having a hearing, I think, is very appropriate. And the courts are very able to go through a list of criteria like that. I think that we would include whether there was true remorsefulness as part of the rehabilitation. Thank you.
Thank you very much. Are there questions for this panel? I have a question for Mr. Dold, and it'll be a relatively quick one. You indicated, and I've been looking into the other states who have approved similar legislation across the country, including in Arkansas. I'm reading the Arkansas bill, and in the Arkansas bill, and I'm making sure that I've got this right, they require a comprehensive mental health evaluation conducted at the time the person becomes eligible for parole under the section that part of the bill. So that is not an unusual thing to be requested across the country. Is that right?
No, it's not, Mr. Chairman. And I think that there,
not the end of the world one way or the other. I'm just pointing out that at least in one of the states that's done it recently, that was something that was important.
Absolutely. And I think, Mr. Chairman, to your point, that the main focus of a lot of these states, and I worked in a lot of these states when I was with the Campaign for the Fair Sentencing of Youth as their advocacy director. The main focus there is making sure that kids have a meaningful opportunity to come home based on demonstrated maturity and rehabilitation. It's very similar legislation was passed in North Dakota unanimously. And so it's almost identical to the bill that Delegate Lewis has introduced here.
That's fine. I do think it's important to look, and I see you, Delegate Conway. I'll be there in a minute. I'm not sure what Delegate Cardin's doing. I wanted to look at that and look at a couple of the other states as well, but I do think that there are some of the issues that I brought up earlier that appear to have been covered in some of those other states. So hopefully we can work some of those issues out. All right, Delegate Conway.
Thank you, Mr. Chairman. Thank you, members of the committee and people that came to testify. To Mr. Vaughn and Mr. Dole, I just have one question. I want to know if you would agree with this. The difference between these children that we're talking about and other people who are in general population is that these children have a demonstrated direct knowledge of killing humans. Would you agree with that?
James or Mr. Dole, if you don't mind, I would like to go first.
Absolutely.
Thank you so much for the question, Delegate. I want to just let you know that I'm a former educator, and I came to this work through my brother's experience. My brother is currently serving a life sentence in prison for a crime that he did not commit. There have been numerous individuals that have come before you today that have discussed their innocence, and still they serve extremely lengthy life sentences. So I do not stand in a position to condemn all of those individuals who would be eligible for parole now based on
First thing I said is I agree with the Constitution. That's the first thing I said. So I'm not talking about people who are innocent. I'm talking about the people who we know have direct, demonstrated knowledge of killing humans.
I would ask you, Delegate,
yes.
How do you
Well, you're not
know?
allowed to ask us questions. I'm sorry.
My apologies. I would just like to make sure that I highlight and continue to highlight that many of the individuals that have come home and many of the cases that have been lifted up are individuals that were innocent. And currently under our law and in our justice system, we don't have evidence and data.
Thank you. My question wasn't about the innocent people. We hope to redeem those people. Okay.
And Delegate Conway, if I may, some of them, yes. Certainly this bill would affect some kids who were convicted of homicide-related offenses, and some of them may have been the people that actually did the killing. But this bill is much broader than that as well. So it includes anyone who has a sentence of longer than 20 years of incarceration. So you could be talking about somebody who, and I don't know right off the top of my head, but somebody who has, armed robbery or a series of armed robbery where no one was hurt, no one was killed, but they got stacked sentences and now they're serving a de facto life sentence. And even though nobody was killed, they're in prison for the rest of their life.
Wonderful answer. Wonderful answer. Thank you.
You're very welcome.
All right, are there further questions for the panel? Seeing none, that concludes the testimony of those in favor. Former Delegate Neiman has been with us all day. He's here favorable with an amendment. I think we know what the amendment already is, but hey, here's 2 minutes. Delegate Neiman, take yourself off mute though.
All right, thank you, Mr. Chairman. And I acknowledge the perseverance of the committee. And I'm wearing 2 hats today. I'm chairman of the Legislative Committee for the Maryland State Bar Association's Criminal Law and Practice Committee. And we are in support of this bill with the amendment that has been mentioned about requiring notice to the victims. I think the Attorney General's office has a similar proposal. I would urge you to adopt that amendment. I'm also the head of the Sentence Integrity Unit for the Prince George's County State's Attorney's Office. And for the last 1.5 years, I've been working with these cases directly and trying to find ways, as the state's attorney says, creative ways to get them in front of a court. It is not easy to do. So let me address just a couple points that have come up as a way of clearing up some things. One is you'll hear there are alternatives. On the earlier bill, you heard 13 alternatives to do that. That's simply not the case for these situations. That most of those alternatives occur early on in a sentence. 20 years later, they've been exhausted and they're simply not there. We can sometimes find creative ways to get around that, but there's no guarantee. Ms. Hazelton, whom you've heard from twice today, I handled her loved one's case, which was denied by a judge because she did not think she had to consider the factors the Supreme Court has said, and that the Court of Special Appeals even told her to do. This bill would address that situation. So I think it is very important to do that. The other things, post-conviction, reconsideration, appeals, those all happen early in the process. They're not applicable in these cases. Finally, the parole commission is a viable thing. I support the parole commission in general. It's simply not equipped to handle these cases. That's evidenced by the pitiful small number of cases they get put forward. And even if you take the governor out of the equation, that doesn't change the equation. Much better to have a process where we put it in front of a judge who is in the community where the crime occurred, who has an understanding of the reality of what those crimes are, and who is used to making these kind of balancing equations to look at the different aspects of the case. There's much more that could be said, but I'll leave it at that. One final comment, I guess, and that I would urge you to avoid being too prescriptive in addressing factors to be considered. Just as in a sentencing factor, there's a lot of different things that the court has to weigh, including mental health issues and so forth. But it doesn't make any sense to be too prescriptive in that any more than it's being prescriptive about what the sentence should be imposed. We've learned the error of mandatory sentences. So I'd suggest you avoid that and allow the court to do what it does very well and balance the factors and look at these cases. So
Right.
I'm happy to answer any questions as well.
We'll take questions for Doyle Neiman. I think we are wearing out. So do not see. Yeah, well, I think we'll leave that at that. And thank you very much for your testimony. One more person to testify, Joseph Riley from the State's Attorneys Association in opposition. Mr. Riley.
Thank you, Mr. Chairman. My name is Joe Riley. I'm the legislative chair of the Maryland State's Attorneys Association, the elected state attorney for Caroline County, and I am one of the governor's appointees to the Board of Victim Services. We are urging here in opposition of House Bill 409. I want to make clear before I start, though, that I am here talking about Criminal Procedure 8110. And I also want to make clear that when a sentence reduction is appropriate, it should be granted. No one is going to be here saying that Eddie Ellis should still be in jail. I don't even think Eddie Ellis would be eligible for this sort of relief that we're talking about here. But what we are talking about here is that trial courts are not in the best position to make these sentence reduction determinations. If Sarah Citrioni, whose case was discussed earlier, if this bill is passed, Sarah Citrioni won't go in front of Judge Beck, who sentenced her to 2 consecutive life sentences for stabbing Catherine Farrar 86 times and then stabbing George Wall an additional 30 times and murdering both of them. Era Crow, who was just recently passed, hearing it from the state's attorney's office, it's going to be a completely different set of people. But what will be the same are the victim representatives. And I know that there are people who are very acutely aware of what issues a victim goes through on this panel. And victims come in all shapes and sizes. Some victims think that these sentences are appropriate, and they have to make a calculus between doing what is most effective, going to court and making the judge look them in the eye when they reduce the sentence, or doing what causes the least amount of trauma, which might be writing a letter, which might not be coming or doing anything at all. They have to make this decision 13 times already under the collateral review, the way a sentence can be attacked over the course of a span of a sentence, as the person who testified before me said. It's over the period of time, but there are 13 ways you can attack a sentence collaterally. This would give you a 14th, 15th, and 16th way to attack a sentence. It's not a second chance. It's not a second opportunity, because after you have your motion and present your case, if the judge says, no, we don't think that you've met this burden, well, guess what? And 3 years later, we can come back again for a third opportunity in a light most favorable to the proponents. Well, I still don't think you did. Well, then I get to come back for a fourth time. At some point, when will we let the victims rest in the state of Maryland? I see an unfavorable report on this bill. Thank you.
Thank you very much. Are there questions for State's Attorney Riley? Genuinely appreciate that you have stuck with us today. Delegate Bartlett has a question. Delegate Bartlett.
Hi, thank you, Mr. Chair. And my question is for Mr. Riley. Over a 40-year period of time, going to court 18 times, Your argument would be relevant to me, or would be persuasive to me if we were talking about a short period of time. We're talking about 20 years plus. So during that time, sometimes the victims are no longer even alive anymore. The victims' families are no longer alive. Furthermore, the circumstances have changed over a 20-year period. Sometimes the prosecutors are no longer there. So my point to you is, isn't it so that it's over a period of 20 years, at least based on this particular bill, that they would be coming back for the 18th chance as opposed to the second chance?
Yes, and they wouldn't have a right to an appeal if it was ruled against them. If they were there and they were alive and they wanted to be heard and they went, they don't have a right to an appeal. A victim has to take whatever the judge gives. And I don't think that's fundamentally fair. If this bill is talking about fundamental fairness. Yes, sometimes victims will not make it through a 20-year, they might not be the same victim's representative, but it might be the child of somebody who died, who has gone through their life without a parent. It might be several different hypotheticals that could possibly exist, not just somebody who has passed on.
Right, but I guess my point was combining two parties, because we're talking about two sides here. We're talking about the victim side as well as the inmate's side, because the inmate has family as well too. The inmate may have children. The inmate may even have great grandchildren at this point. So it goes both ways. And I understand there's a balancing act that has to be done. But what I don't understand is your point as to going into court so often and ignoring the fact that we're talking about a 20-year plus time period. We're not talking about within a 5-year time period going into court 18 times. And I just want to make sure that we clarify that, because we are talking about a long period of time.
Yes, we are, Delegate. And I've had the pleasure of sitting with families who have gone through these things and actual victims themselves who have been victims of first-degree rape, who have gone through these types of things. And it's not something that I shy away from. I'm the elected state's attorney. That's part of my job. And part of my job is being a victim's advocate. And I'm here as a victim's advocate, not necessarily looking at the family of the convicted person who is serving the sentence that was rendered by a judge after a finding of beyond a reasonable doubt.
Right, and I understand that. And part of my job is to be a victim's advocate as well. And what you may not know is that I am a victim.
And I certainly said that members of this committee are
life. And so I get to see, unfortunately, I get the benefit of having both sides as a victim and as a family, as someone who has a family member who's serving life. So that is part of our job. And so I just want to make sure that we make it clear that the time frame is very relevant, that it's not just going back for the 18th time without any regard of time itself.
And I'm not saying that it's not relevant. I'm just saying that after the first time that it's denied by a judge after 20 years, then you get a second time after a judge has been denied it after 23 years, and then a third time after 26 years. At some point, the sentence has to be final. At some point.
Would you be favorable to the bill if we said after 46 years?
In one hearing?
46 years, meaning that that's the last time you get to go back after 46 years.
If you want to make an amendment about one hearing rather than 3 hearings, that's something that I can take back to the board. I'm not able to speak on behalf of the Maryland State Attorneys Association to proposed amendments that don't exist.
Okay. We have 2 more questions. Delegate Shetty.
Thank you, Mr. Chairman. Thanks, Mr. Riley, for being here tonight. I'm sorry my son is running and avoiding bedtime, so you can probably hear some stomping above me. My question to you, sir, is how do you respond to the fact that we are in violation of the Supreme Court case and the U.S. Constitution? What is your response to that?
I am here to talk about Criminal Procedure 8110. I'm not addressing the first half of the bill, which I may be addressing constitutionally problematic issues. I am here talking about the criminal procedure 8110. I don't know if I can answer that any more clearly.
To be clear, if I can try and I maybe shouldn't step in to try and translate, but begging Delegate Shetty's pardon, you're commenting on the process by which someone could seek relief on their sentence, not on whether people should be sentenced to life without or life with the opportunity for parole.
The chairman is correct.
Okay. All right. Delegate Shetty, go ahead if you have further questions.
No, that's it. Thanks.
Okay. Delegate Juanita Fisher.
Thanks, Mr. Chair. And that was part of my question. Hi, Mr. State's Attorney. How are you? I was just a little confused on the position of the state's attorneys. So it's only that the process part that you all are against officially, correct?
I'm here to talk about the 8110. I only have 2 minutes when I'm doing testimony.
Okay. And then the other part I wanted to talk to you a little bit about, and I know we talk about this on a lot of bills, but your comments I just couldn't help it. All of the things we discussed in Judiciary are hard, but I just wonder if you or the State's Attorney Association takes consideration of the part of justice you're talking about, and you were talking about the victims and then coming back and their position in that we're all victims of a system, right? The impact of injustice, the impact of racism, the impact of slavery on the people that you're talking about. It's just always so interesting to me because, especially in our state, we haven't had relief in so many other ways. And I think this year, outside of not just this committee, but others, there is an agenda for that relief that I think we're all really proud about. But I just wonder if that's also part of the concept when you're looking at these things. It's yes, state's attorneys are victim advocates, but you're also the stewardship of justice. And that's on both sides. And you and I very well know one day you're in court, someone's the victim, next day you're in court, that same victim is your defendant. So I just wonder, at least that was my reality. So I'm just wondering how that thought process really turns out in your discussions, because we constantly see state's attorneys here usually opposed. And I'm really trying to grapple my mind around it on the concept of justice and the concept of, we have more African-American males than a lot of states that, I don't like to be compared to. Like, what is the state's attorney's position on that? And then what are you offering specifically for, Delegate Lewis's bill to assist in getting to that goal if you're actually not opposed to the life sentence?
I don't know what your question is. Sarah said
it was three. It was the mentality around victims throughout the system. And then what are you proposing? That's the first part of the question. And my second part of the question is, then what are you proposing if you're not actually against, you're not really sure about your position on the constitutional matter of it. You're opposed to 8-1, I forgot the rest of it. Like, what's your proposal to fix that then?
Look, I look at every case, every defendant, every set of circumstances, the victim's race, whether racism played a part in the killing. All of those are factors. The comment on each and every individual case, I certainly can't do here in this hearing. But yeah, it's absolutely a factor when we think about things. It's a factor when we think about what cases that are going from juvenile to adult court. It's a factor in everything that we do, particularly here in Caroline County. I think that's why we look at our numbers on the mid-shore in Caroline County. Juveniles are, compared to the other counties on the mid-shore, have a lower racial disparity in our county than in other counties. So certainly it's something that we take account of. As to what we would propose with this bill, if Delegate Lewis wants to meet with the State's Attorneys Association and say, hey, what amendments would you to this bill to make it something that you could at least be on no position on, we would love to have Delegate Lewis.
Well, I can't speak for Delegate Lewis, but I also feel like this is like the 50th time we've heard this bill. And I just think that the State's Attorneys Association should also maybe be proactive about like putting forth solutions so you can be neutral and can be a part of it. I just would say that, but that's just me. I can't speak for my I can't speak for another delegate.
All right.
I don't know if that's a question.
It wasn't a question. It was just
It's not, okay. All right. Stop. Thank you all very much. Are there further questions? Seeing none.
Delegate McComas had a question.
Delegate McComas has a question.
Thank you, Mr. Chair. Mr. Riley, it's been my experience, depending on the victim and the victim's family, very different reactions. And I would think if the victim had been a child, that the parents, sometimes they just never get over that loss. And I mean, we've seen it. And so I kind of wanted to get a little more of your thoughts on that matter.
Sure. When we're talking about victims that no parent should ever have to bury a child, but we have had people who've had to go through that. And to sit there and have them go, I don't want to go through this again, or they've lost their wife. I mean, we have people who very recently lost their spouse in a situation like this. They don't need to go through this trauma of 14th, 15th, 16th time. And to ask them to do that is some sort of perversity I don't understand. And then say that you have to remember victims, for the victims, the decision is final. There's no appeal for the victims on these hearings. There's no appeal for a victim on a parole hearing, on a motion to modify, on a 3-judge panel review. They have to keep coming, and they have to make sure that judge looks them in the eye. And if they can go through that trauma one more time, they don't. Often they say it's not worth it, and I can't do it one more time. And I'm just going to write a letter, or I'm not going to go. I'm going to move to another state and get away from the state where this happened. All of those things happen.
Thank you, Mr. Chair.
All right. Thank you all very much. I don't think I see further questions for Mr. Riley. Thank you very much. That concludes the testimony on House Bill 409. So we finished at 8:45. Okay. Members of the committee, I say that because normally these would have gone a little longer maybe, but who knows? Members of the committee, we will be back again on Tuesday with a longer list of bills. The list of bills get longer from here. So we look forward to hearing those bills and seeing you again, and apparently everyone's kids as well. So we'll see you next Tuesday.
One quick question.
Is this a question, Delegate?
Yes.
Or
Yes.
is it a question on the bill?
Oh, no, I'll just get you offline. Sorry.
That's fine. Let's do that. Okay. Thank you all very much. Have a good evening.